So, ladies and gentlemen, good morning. So, good morning. We are ready to start our meeting.
This helps.
So, good morning one more time, and it's a great pleasure to welcome all of you in Riga. And pleasure to welcome you here in the premises of the small guild. Before we start, I will explain a couple of practical issues in relation to our meeting today. We have our participants also connected in Zoom. And for those who are in Zoom and require interpretation from French, English, and Latvian, so you see that this feature is displayed in the toolbar at the bottom of the Zoom window. And for those who are here in the room, headphones are available on your tables, and interpretation devices could be also found on the tables of the back. So please ask also our colleagues if you require some assistance in relation to interpretation. We will also live stream our event today, and the event will be recorded also and available afterwards at the YouTube channel of the Ministry of Justice. Who are here in person, we will have a lunch at 1 o'clock after this high-level session. And after the high-level session ends, we kindly invite you also to take the family photo here on the way to the lunch on the first floor. And now it's my pleasure to provide the floor to our host, Mr. Jānis Bordens, Deputy Prime Minister of Latvia, Minister of Justice. So the floor is yours, please.
Thank you. Dear colleagues, it is really, it's my pleasure to welcome all of you here in Riga, in Latvia. Sincere gratitude for your time and opportunity to join the debate today, personally or virtually. OECD Access to Justice Forum creates for us an excellent platform to exchange the best practices and build expertise. And in our continuing efforts to bring justice closer to the people, it is important to keep pace with the rapidly changing demands of the society. I believe we all are on the right path in this regard, when the discussion we hold today is focused on the people interest, people-centered delivery, and responsiveness. Personally, I'm very pleased that the 2022 OECD Global Access to Justice Roundtable takes place in Riga. And it was possible for us also to hold this strategic morning session. Seems also continuing the tradition for the capital of our country to be in the center of global justice forums. In July 2018, Riga statement investing in access to justice for all was adopted, calling for action in investing in access to justice. In December 2021, during the global dialogue of justice leaders, many countries adopted the Riga Justice Agenda for transforming justice for a vibrant social contract. Democracy and the rule of law are the elements of crucial importance today. And I think it's very important that we put our work on access to justice in this broader context. We as justice leaders should support the restitution of international legal order, strengthen the respect of rule of law, and contribute to what extent possible to stop the war in Ukraine. Latvian Ministry of Justice has been actively engaged in mobilizing global expertise in finding the ways how to contribute to recovery of the state by supporting it with the best legal approaches possible. This summer, in the framework of Riga Justice Leaders Forum 2022, with the participation of Ukrainian Minister of Justice, Mr. Denis Malyuska, we took an opportunity to discuss a number of the questions in this regard, especially focusing on the need to change the substance of war crime in the 21st century. We also discussed procedure, base and legitimate objective for the confiscation of property under the sanctions. The work is still ongoing, and I will be happy to provide with further details when we agree on concrete next steps. We are in the building of small guild. That used to be characterized by the quotation from 1936. This building offers us a unique picture of the art of old Riga Crafts Corporation, a true example of citizenship and unselfishness. With the references for trade, business unions in a modern sense, I find it very symbolic as one of the core objectives of our debate today is devoted to economic resilience, business development, and national well-being. Dialogue between justice and business sectors has been developed on the continuous basis, and again, it is very important to see how justice sector could support economy in practice. In direct ways, developing the commercial law frameworks and corporate governance standards, and in the broader context, from support to the well-being and safeguarding the right of children, to putting in place high standards of justice services. For me, as for Minister of Justice, fair justice system and secure business environment are the priorities and cornerstone for the inclusive growth. In this regard, the Specialized Economical Court has been established in Latvia last year to concentrate expertise in commercial matters, corruption and money laundering cases. A number of legislative initiatives are initiated and implemented to strengthen access to justice and trust in recent years in Latvia. Among them, more transparent registration of beneficial owners in commercial register, low-income person release from a small debt, the comprehensive justice audit conducted to revise the cooperation between justice and law enforcement agencies, leading to enhanced dialogue. Online dispute resolution concept is under development and to be integrated in judicial services to raise an access to justice and reduce cost of litigation. Last year, the trust to the justice system, as example in Latvia, among businesses has increased by 13%, among citizens by 10%. Looking forward for our debate today and all the important issues in the agenda, I'm convinced that it is for us to understand the justice sectors around the world face nowadays a number of national and cross-border challenges. In this regard, we cannot act the same as was done previously. I would like to stress the role of leaderships here. The capacity and responsiveness of justice institutions should be strengthened. Building leadership versus management and investing in expertise. To be the driving force for the change, new generation of justice leaders needs vision. Ability to adapt and innovate and to take risks in the situations of uncertainty. I invite us to endorse flexible and open approaches at all levels, and I'm convinced that thus we could do more, from implementing latest digital trend to reacting on security and energy risks. Once more, it is a pleasure and honor for Latvian government to be in the position to co-organize the discussion today with this objective, to shape the future of global cooperation for justice. I would like also to take the opportunity and thank OECD for our fruitful cooperation through these years. Many important projects have been carried out together. My sincere gratitude to Ms. Elza Pilichovsky to be present today. It is great pleasure for me to greet all of you, and please let me also especially acknowledge the presence of Mr. Ramin Garagurbanli, President of Council of Europe, CEPEJ. Hello, Ramin. It is really my pleasure always to cooperate. On 18 September 2002, 20 years ago, was the day of the establishment of CEPEJ. Deepest appreciation and sincere gratitude for over the years sharing the values and efficient and qualitative justice system. And now I wish you excellent time in Riga, and at this stage let me provide the floor for Ms. Pilichovsky for opening remarks.
Thank you very much, Deputy Prime Minister. So dear Deputy Prime Minister Bordans, dear ministers, ladies and gentlemen, it is also my great pleasure to welcome you to the 2022 Global Access to Justice Roundtable in this absolutely beautiful setting that I think will be very inspiring for our discussion today, as the Deputy Prime Minister said. So after 2 virtual roundtables, it's of course a big pleasure also to meet in person after 2 difficult years. And let me express our sincere gratitude to the Deputy Prime Minister, to the government of Latvia for hosting this roundtable today, and of course to all participants for joining us today. We are all meeting at a very challenging moment. A lot has changed since this roundtable last met in person. In 2019, governments were already facing some very difficult challenges, including, economic, social, and environmental issues. 2 years or almost 3 years after, these challenges are still present, but we're also looking at recovery from COVID. We're also looking at the cost of living crisis, and of course, the very big difficulties with the Russian aggression against Ukraine. There is also a widening gap and a spreading disconnect between people and public institutions, and in particular, vulnerable groups. Rule of law indicators have declined for the 4th year in a row in over 70% of countries around the world. Of course, these challenges are enormous, but they are also a call for action. And against this background, OECD countries have recognized the importance of looking at the health of their democracies and taking action to build greater trust between citizens and their governments. As part of this effort, last year we launched an inaugural survey called the OECD Survey on the Drivers of Trust in Public Institutions, to which 22 countries participated. Many of those 22 countries are present today. And we have surveyed the views of over 50,000 people worldwide on really the drivers of trust. This report will underpin the discussions that will be taking place at ministers' level on building trust and reinforcing democracy on the 18th of November in Luxembourg, under the chairmanship of Luxembourg. And I know that the Ministry of Justice is present today, and it's actually the Minister of Justice who is chair, but countries are coming at different level, and the vice chairmanship of Colombia, France, Lithuania, and the US as well. There is a lot of things that the justice community can learn from the report on trust that will underpin this big effort. Our data shows that just over half, about 57% of people on average, trust the courts and legal system today. So actually, the court system is faring relatively well in this survey compared to other institutions, but you would expect that in our advanced democracies, and if the court system is not doing well, then we have an issue. But still, 56% in OECD countries is not that much when you think that these are some of the most stable, advanced democracies in the world. Moreover, something that is not published in our data, but that we have as data, is that young people below 30 years old trust the judiciary less than people older than 50. This is also in line with other findings in the survey, that young people overall have less trust in public institutions. And importantly as well, trust in the judiciary and perceptions of court independence are also related. And the findings are not comforting. Only about 4 out of 10 respondents on average believe that the court would make a decision free from political influence in our countries. So there is plenty in this report that is relevant to these roundtable discussions. Its findings definitely show that there is a significant scope to strengthen citizen trust in the justice system and meet their expectations for independent, accessible, transparent, fair, and efficient justice. So we need to do more to bring justice closer to all people and make sure that it works for all people, including young people. As acknowledged by the UN Secretary General's Common Agenda and underlined during the 2021 Global Justice Week, there is a need for transforming justice systems to renew the social contract, the Deputy Prime Minister has said it, deepen democracy and advance the implementation of the 2030 Agenda. So let me share with you what the OECD is doing to support countries with this. Putting people at the center of rule of law efforts is key, bringing this fundamental democratic value closer to people's daily experience and needs. This calls really for a paradigm shift. We need to understand the legal needs of different groups, identify what works to meet them, and ensure that justice and legal services are conceived, designed, and delivered in a way that they are responsive and appropriate to address them. This has an added value. In a fiscal constraint scenario, it does help governments distribute limited resources in the most effective way possible. So in 2021, we launched the OECD framework and good practice principles for people-centered justice to identify core elements to make people-centered access to justice a reality. Now we need to reflect on what needs to be put in place in practice to implement this. This will be the focus of this roundtable. So together today with over 100 representatives from our member and partner countries and international organizations, academia and civil society, this roundtable will reflect on common challenges and opportunities for positive change in the justice sector. A few exciting topics for today's discussion. First, the key steps to make people-centered transformation of justice a reality. So what are the necessary regulatory and policy environments, how to empower people and the justice sector workforce, and how to strengthen interagency, coordination, and collaboration. Second, improving the use of data as a major asset for justice systems to effectively design policies that meet people's needs, including to measure and evaluate the system's performance. Of course, this roundtable will also discuss digital transformation of justice systems, including the progress and opportunities to simplify legal procedures. Next, the roundtable will look into ways to bring access to justice to all people with a focus on specific groups, children, indigenous populations, people with disabilities and minorities. And finally, we're proposing a discussion to stimulate cooperation and exchanges to develop justice responses to present and future global challenges, including on the role that justice can play to tackle climate change and facilitate a people-centered green transition. As we all know, this is a core part of trust of public institutions in the future. So these discussions will build on a series of milestones in advancing people-centered justice, including the Global Dialogue of Justice Leaders in December 2021, and the recent IDLO conference and the World Justice Forum. They will feed into the global series of actions in the coming months, of course, to accelerate progress towards the SDG 16.3 target ahead of the forthcoming OECD Global Forum and Public Governance Ministerial Meeting and the UN SDG Summit in 2023. So we would like to thank you again for joining us today, for the support and commitment to this agenda. And I very much look forward to the rich discussions that we're expecting today. Thank you.
Thank you very much, Ms. Pilechovsky. Already it was mentioned the issues on discussion. And let me once more a little bit to mention from my side before we start discussions today. Some key objectives of this high-level discussion is some of them are is to review countries' experience, progress and commitments in making equal access to justice for all a reality through people-centered justice transformation. Then in December 2021, during the global dialogue of justice leaders, many countries adopted the Riga Justice Agenda on transforming justice for vibrant social contract, and which recognized the importance of renewing the social contract by strengthening trust between people and institutions through people-centered justice. The statement also affirmed countries' ambition to make access to justice a reality as part of the implementation of the SDG commitments on access to justice. In this context, our high-level roundtable aims to showcase country progress, results and commitments at the national and local levels in advancing people centricity, trust in justice institutions, access to justice and the rule of law. We will reflect on what should be our key priorities for action and how the international community can also support efforts at the national level. We will also discuss ways to make the case for investment in access to justice initiatives, highlighting the need for integrated justice responses to present and future global challenges. Also the context of economic uncertainty. The result of the discussions will support global efforts to expand the application of people-centered approaches to the components of the rule of law and place the needs and the experiences of the people at the center. Building on the OECD Reinforcing Democracy initiative, this endeavor will aim to help governments moving towards a people-centered approach to the rule of law and getting countries closer to SDG 16.3 target to promote the rule of law and ensure equal access to justice for all. In particular, and as already mentioned by Elsa, from the OECD, the discussion at the Roundtable form an integral part of the global series of events in the past months, aiming to feed the momentum of the movement for people-centered justice, including the global dialogue of justice leaders, which was December 2021. 16th conference, people-centered governance in a post-pandemic world, which was Rome, April. The World Justice Forum, The Hague, in June, to build the momentum for the UN SDG Summit in 2023. And today's debate aims to support countries in this global commitment process towards people-centered justice transformation. And now I would provide the floor to all participants equally, as first I would introduce Mr. Jean-Paul Janssen, the President of Federal Public Service of Justice of Belgium. Yes. Yes.
Thank you, Mr. the Minister. C'est un moment important pour tous, pour toutes, parce que la question de l'accès à la justice est vraiment essentielle dans un État démocratique. Et même si cet État démocratique a une histoire démocratique très longue, on constate que malgré tout, la question de l'accès à la justice reste essentielle. Tout à l'heure, je
And the justice is a very important question also today. In the afternoon, I will be also participating in a task force where I will be speaking mainly about victims, because in Belgium this year we had a court and this proceedings were very important because there were civil participants who will be also making statements. And the victim definition in our country is very important. I was also closely listening to what the minister was speaking previously, and this is funding to the justice system. As we do speak about justice, it is people. People are involved, men, women, who need funding in order to be able to work. And we have funding 250 million available to us for the next 4 years. Because currently in Belgium we are spending 2 billion euros for justice, and this funding will be increased because first of all we need more staff, more personnel, and we also need new tools. Of course, the tools would never be able to substitute the people, humans. However, it supports humans in providing their services. We also need to think about digital skills and digital gap. So there are people who have no access to digital world because they do not have the necessary competencies and they do not have access to information. That's why we need to think about how to ensure that the people have at their disposal the tools, how they can fight for their rights and address the courts. We need, that's why, also to cooperate with many associations working directly with people. In Belgium, I have found that sometimes we are offered some alternatives, and one I want to highlight, which I believe is unique for our country. It is the Office of Lawyers, the law firm, which is an NGO. Funny, it sounds funny, because lawyers are usually expecting a lot of income, but this is indeed a group of lawyers who have decided to create an non-profit organization, and they have also acquired representatives of other services and offices which have been done with the aim to help the person in the broadest possible manner, a person who has come to them. So for them, this proceeding is not the most important, but they are trying to mediate and help and solve the problem with any ways they have, and also with reconciliation. And on the level of ministry in Belgium, we would like to support it, and also we encourage other attorneys and lawyers to act in the same way. It is very beneficial to the citizens, to the community, because the people, they don't want to go to court with someone. They just want to solve their problems in essence, and this is a sustainable solution. It also provides an agreement, a reconciliation between the people, especially if we're talking about some family matters. And this is why it's very important. And on the level of the Ministry of Justice, we are trying to support and also fund such initiatives. This is a particular example which shows how much we need to indeed be people-centric. We need to cooperate with those who especially want to accentuate the role of the people in the center.
And now I would like to give the floor to Mr. Emil Dyke, Deputy Minister of Justice, Bulgaria. Please, Emil.
Thank you very much. Dear colleagues, having the privilege to speak at this high forum, I would like to set one very simple question. What is the biggest problem of justice the biggest problem of justice is that virtually each time at least half and often more of the participants in the judicial process are not satisfied by the results in the end of the trial. Accused because of their conviction, victims because accused didn't get the punishment severe enough, plaintiffs because they didn't receive the requested compensation or no compensation at all. Can we fix this issue completely? Unfortunately, this is out of our reach. Possibility of everyone being happy with the judicial process is a chimera. Can we improve the situation? Yes, we can, and that should be our goal. When people are more involved, when justice is by the people and for the people, only then we can expect better results. Enhanced citizens' participation is highly important for several reasons. First of all, it is a guarantee for their fundamental rights in the context of state's obligation to conduct a fair trial. This approach increases people's engagement and enables them to be an active part in the decision-making process on issues that are of primary importance to them. Such a way of action, opening the court to the people, taking into account their needs and daily problems, increases the trust of the citizens to the judicial system. It solidifies the role of the court as the link between people and institutions in the contemporary society. Preliminary public discussions of draft laws, including in the field of judicial reform, is also an appropriate approach both to promote upcoming reforms and to seek civil society support for them. The openness of the government enhances people's trust and accountability in it. The Bulgarian government has undertaken such approach and is committed to continue the reforms, strengthening the rule of law in the National Recovery and Resilience Plan and the National Program for Development Bulgaria 2030. Many of the proposed measures are an essential element of the reform of the judiciary and are the result of a wide range of consultations with stakeholders. In addition, another guarantee for rule of law is the equal access to justice for all people. In Bulgaria, the state provides free legal aid for natural persons meeting certain conditions. Free consultations are given at the regional counseling centers of the bar councils. Free legal assistance is brought to people in remote areas, including through mobile groups in 3 regions of the country. We pay special attention to developing and implementing alternative dispute resolution, and we also aim to reduce court fees. There is a tendency in my state to promote more in our legislation the mediation. We encourage parties, especially in civil procedure, before to go to a court, to try to reach an agreement among themselves, because actually this is the best way. As I mentioned at the beginning, when you have a classic trial, always at least one of the parties is unsatisfied by the final result. It feels itself as the party which lost the battle. In a mediation, it's possible both parties to reach an agreement in which every one of them to feel satisfied. The increasing global use of information technologies and the digitalization of different sectors is a tendency that reaches judiciary as well. The need of people to have fast and easy access to and communication with the courts lead us to find adequate solutions. In order to deal with the challenges raised by COVID-19 pandemic, digitalization of justice sector has been accelerated. New technologies have the potential to provide all the possibilities to facilitate access of individuals and business to courts. In Bulgaria, serious steps have been taken in this direction, given the functioning of the unified portal for e-justice and the unified information system for the courts. New procedural legislation guarantees the possibility of holding video conferences on civil, criminal, administrative cases, as well as the performance of certain procedural actions. To increase people's perception of their value for the state, the latter should reinforce coordination among courts, legal and social service providers. A good example in this respect are the joint centers for legal and non-legal services as a way of securing a holistic approach to solving people's problems. In this way, various legal and non-legal difficulties of their life could be addressed: social, economic, and health-related issues, medical care, psychological counseling, legal and police defense. In recent years, the civil society has strongly developed. People are well aware of their rights and continuously require and propose new initiatives for improvement and protection of rule of law and democracy. The tight collaboration between society on one hand and governments and judiciary on the other is essential for choosing the most efficient and coherent approach to develop people-centered justice. Recognizing and setting common goals for all people and state, meeting the needs and possibilities will lead us ahead to a better future for democracy and rule of law. Thank you.
Thank you very much. And next I'll ask to say for our forum to Mr. Michael Souza, Senior Assistant Deputy Minister, Policy Sector, Justice Canada, from Canada. Please.
Thank you. Well, hello, bonjour, et bon dia. It is really a privilege to be here among you today, my first OECD event. I'd like to echo my thanks to you, Deputy Prime Minister, and your government to host this wonderful event. And of course, Elsa, we'll chat later, but the work that you and your team do to pull this off, it is truly a miracle. So we've been here not too long, and I'm already seeing immediate benefits for me. Hearing from my colleague from Belgium about access to justice and it having a long history. It does have a long history. My law school's motto 30 years ago, almost 30 years ago, was access to justice. But how do we make that concrete? I like the way you talked about the human nature and how to orient individuals to develop this this practice, this orientation, I think is the word that you said. And of course, my Bulgarian colleague, I really appreciated your direct assessment of the problem. And that first question, I think, will be the cornerstone that leads us to the discussions today. But I think as Elsa and the Deputy Prime Minister already echoed, it's a critical time now. We haven't met for a couple of years. We've seen a lot of world events make the rule of law and people-centered access to justice more important than ever. So I think the timing is right for us to exchange those ideas. But how do we strengthen the rule of law and our democratic values to build trust in institutions? So also you mentioned the first ever, I think, report that you guys did on trust in government and public institutions. As someone that's relatively new to the policy sector and looking at this data, it really shook me in terms of what you said. I think you mentioned for 4 years in a row that trust is starting to decline, and it's the young actors that I'm worried about the most as a father of a teenager. But the results are concerning. It's confirming what we saw, what we heard anecdotally, and now we have the evidence and the research and the data. And from getting prepared for the conference and recognizing the importance of research and data. That has to be the cornerstone. And I think my Belgian counterpart also mentioned how important that will be. It's easy to talk access to justice, sounds really nice, but what are the concrete measurements to ensure that we're getting progress in our institutions? Right now, it's evident from the report that the OECD produced is that people aren't viewing their governments as doing what they need to do for them. They don't see their needs reflected in the decisions, the programs, the policies that are supposed to represent their interests, and it's our job to ensure that those systems do that. Canada is not alone, but we're grappling with our own issues in terms of systemic discrimination in core institutions, and our minister's mandate letter has various items and objectives to address some of those, which I will go through. Historic policies and laws have resulted in generations of harm and trauma. And one of the goals of my minister is to find ways to address the overrepresentation of particularly Indigenous peoples and the Black population in correctional facilities. Similarly, the government and the Prime Minister has, as one of its main priorities, is to rebuild the nation-to-nation relationship with our Indigenous peoples and go on a journey of reconciliation with Indigenous peoples. So we're working quite closely with the Métis, the Inuit, and of course our First Nations peoples to dismantle the racist policies and the laws that have existed and has caused that intergenerational trauma. So with their collaboration, we'll look to ensure that laws, policies, and programs reflect their culture, their values, and even their laws. Back to public confidence, research has also shown a lack of public confidence in the criminal and family youth justice systems. Only a minority of those people experiencing those types of issues will resort to a court, tribunal, or even legal professionals. Canada has recognized the role of people-centered justice and access to justice, and that this is critical for us. In our submissions to the 2021 Summit for Democracy, we indicated a commitment to support a people-centered access to justice. This is important as an aim to advance empowerment, equality, and promote a better understanding of the legal needs of people, including our Indigenous peoples and racialized communities. The Government of Canada's upcoming National Action Plan on Open Government will also reaffirm our commitment to access to justice and provide a concrete set of milestones, evaluations, and a public mechanism to track progress. Because that's the other aspect, right? We have to track real progress, not just rhetorical speeches in our House of Commons. Research, I talked a little bit about research and data. That's going to be key. When we have the interagency panel, we'll talk a bit more about that, but I'm really proud that Justice Canada took a novel approach at looking at gathering some of this data in what's called our Canadian Legal Problem Survey, and I'll talk a bit more about that later on. Part of the approach on using data effectively is sharing that data, publishing reports, sharing tools to improve legal literacy, which is probably at an all-time low as well. We know that open justice cannot be achieved without sharing information, evidence, and materials to empower people to hold their governments to account. A people-centered approach puts the best interests of the people at the heart of rule of law. It reminds us that our laws, institutions, rules, programs must serve the needs of the people we represent. The 2030 Agenda is our compass. Research, data collection, and our evaluation will be the roadmap. I think with sharing with one another in a spirit of openness, diversity, and collaboration, we'll be able to put back the public trust in our institutions that it deserves. I'm confident in sharing our lessons learned throughout the next few days. As I said, already getting some good, valuable insight from my counterparts, that this will be a resounding success. So thank you again, Elsa and Deputy Prime Minister.
Thank you very much, Mr. Souza. And now, Josip Salapic, State Secretary, Ministry of Justice and Administration, Croatia. Please.
Good morning to everyone. Thank you, Minister Bordans, dear Ms. Pilichovsky, dear colleagues, dear ladies and gentlemen. It is my great honor to participate on behalf of the Ministry of Justice and Public Administration of Croatia in this Global Access to Justice Roundtable. First of all, allow me to give the special thanks to the government of Latvia and OECD Public Governance Committee for inviting us on this forum that will give us excellent opportunity to exchange experience and good practices on this very important topic. The Croatian government, as many governments across Europe and the world, is concerned about relatively low levels of public trust in justice institutions. The major drivers of trust and satisfaction within the justice system are fair and equal treatment for all citizens, predictable norm enforcement, and well-managed process to ensure efficient handling of cases. Monitoring levels of trust in the justice system is important. Studies show that trust in the justice system can also influence trust in all public institutions in the country. In Croatia, the Ministry of Justice carried out an extensive study of the satisfaction, experiences, and attitudes of citizens, the business community, court users, and employees in selected institutions of the judicial system between 2010 and 2016. So what was the outcome of this study? The study showed, among other things, the long duration of court processes, influence of politics, and the cost of procedures were perceived by the citizens as the biggest problem in Croatia. It also showed low level of public trust in justice system at all. The starting point for changing the situation in our country in the judiciary is to restore citizen trust in the judiciary by giving them quick, fair, and efficient court procedures, and our activities in the Ministry are focused on that at all. Our main goals and plans of increasing the efficiency of the judiciary are clearly set in the National Resilience and Recovery Plan and the National Judiciary Development Plan up to year 2027. These goals will be achieved through shortening duration of court proceedings, additional reduction of cases, strengthening the competencies of judicial officials, and modernization and digitalization of procedures of the courts. Plenty of changes are also taking place in the fight against corruption. We have new 10-year anti-corruption strategy. The law of whistleblowers was adopted in Croatia, where we have introduced new elements of whistleblower protection. We are working now at the new law of lobbying, which will regulate the field of lobbying for the first time in Croatia. Together with OECD, the Croatian Ministry of Justice and Public Administration is developing a technical support instrument project. The TSI project will measure citizen satisfaction with key government services. It will also include justice services, identify areas of improvement of quality of these services. Currently, we have participating partners in 11 countries, member states, and hope the kickoff of the project will be in May 2023. The framework standards for the work of judges are also an instrument by which we strive to increase the efficiency of the work of our courts. Through action plans created by each court, we were trying to influence the increase in the number of resolved cases in the courts. For several years now, we have had a positive trend that more cases are resolved than received. A step forward is also necessary in speeding court proceedings, which we try to achieve by revising procedural laws, civil and criminal, digitalization, and constant discussions with court precedents. To conclude, increased transparency and trust in the justice sector, digital transformation of justice, and fair, fast, and efficient court proceedings for citizens and businesses are important for providing improved justice services fit for tomorrow for everyone. Thank you for your attention, Mr. Minister from Croatia.
Thank you, Josip. And now I give the floor to Mr. Takashi Kikawa, Assistant Vice Minister, Ministry of Justice, Japan. You're welcome.
Okay, thank you. Excellencies, distinguished participants. At the outset, I'd like to express my sincere gratitude to OECD and the government of Latvia for bringing us together to discuss access to justice. Goal 16 of the SDGs is prerequisite to the achievement of all other goals of the SDGs, and access to justice is an intrinsic part of Goal 16. I trust that this gathering will make great contributions highlighting the significance of access to justice and enhancing further discussion. The subject of this high-level dialogue, reinforcing democracy and the rule of law, is indeed timely and pertinent. The COVID-19 pandemic and Russia's aggression against Ukraine have prompted us to reflect on the importance of universal principles, such as democracy and rule of law. I am of the view that to prevent us from sliding into nationalism and authoritarianism, governments and public institutions must act effectively to address people's needs. To reinforce democracy and the rule of law in societies, what is required is a people-centered approach. For the justice sector, this translates into people-centered justice. In responding to the global challenges we face, alongside the need for each state to make efforts to revamp its own judicial system, the need for states to learn from each other, cooperate, and share best practices must also be stressed. In this regard, Japan is leading efforts to globally promote and establish universal values, such as the rule of law and respect for fundamental human rights under the agenda Justice Affairs Diplomacy. As one of the pillars of the Justice Affairs Diplomacy, Japan provides legal technical assistance to developing countries. It particularly has a long-standing record of providing assistance to countries in the Asian region. Legal technical assistance activities include dispatching Japanese legal experts to developing countries to assist the development of their judicial systems and accepting trainees from developing countries with the aim of building capacity of legal professionals that are expected to play a responsible role in the functioning of judicial systems. In doing so, Japan respects the culture, history, level of development, and ownership of the recipient country. We have attached great importance to identifying the best legal reform options for recipient countries in light of the circumstances and needs on the ground, and to developing an enabling environment in which recipient countries will be able to nurture their own legal professionals. We consider respecting the independence and autonomy of the recipient country as essential for building trust in the judiciary among the people, which leads to the strengthening of the rule of law within societies. Through the provision of legal technical assistance, there is much that we ourselves learn. Japan's engagement with developing countries in their effort to reform judicial systems is a catalyst to constantly reflect and reform our own judicial system to achieve people-centered justice. I think that's a very important thing, I think. Japan will continue its endeavor to promote people-centered justice in the international community, including through leading initiatives to share experiences and best practices, and will make every effort for the global prevalence of democracy and rule of law. I thank you.
Thank you very much, Mr. Kikawa. And now I would provide the floor to our Latvian colleague, Irena Kucina. She is Vice President of Constitutional Court of Latvia.
Thank you, Mr. Bordan. Dear colleagues, ladies and gentlemen, considering that I am the only representative from Judiciary branch on today's discussions, let me address some points offered for today's discussion from the point of view of a judge of the Constitutional Court. Albeit initially courts were seen to fulfill the role of authoritarian conflict settlers, so German legal scholars have concluded that this view is now generally being replaced by the view that courts provide services. Latvian commentators have also indicated that the work of the courts has to be seen as providing services to the society. One of the functioning of the state is to provide for the socially significant goods and services, the production or provision of which in the private sphere is impossible or inefficient. One example of such social services is judicial services. The state resources that may be allocated for the provision of judicial services are limited and therefore need to be used efficiently. Because, unlike in the usual situation where an increased demand causes an increase of prices, this correlation doesn't work with respect to judicial services. When the state is providing judicial service, it doesn't make a profit. This is one of the main differences between customer-orientated approaches in private sphere and people-centered approach with respect to the services of judiciary. It is not only the limitation necessary deriving from the restricted competence of each court and from the demands of impartial and independent judge, but also purely economic factors that make courts cautious with respect to opening themselves to the risk of being exposed to trial or even vexatious lawsuits. That said, the trust in justice is a goal in itself for courts and for state. The Constitutional Court has said that the trust of sovereign for constitutional bodies of a state power is one of the most important preconditions for existence of a democratic state based on the rule of law. The nature of judicial proceeding is such that frequently the motives of even the best argued rulings may be incomprehensible to a law person. It is for that reason the judges of the Constitutional Court have indicated that in order for society to trust the judiciary, the society has to understand the aims, tasks, and basic principles of the activities of judiciary. Such an understanding may be achieved in the work of the courts in transparent, which means that the information about the work of the courts is open, accessible, and comprehensible. From the perspective of the Constitutional Court, ensuring that the information about its work is open and accessible in a relatively easiest task, the Court published detailed information about its pending cases, which includes specific indications on when and how cases would be examined and all the decisions that have been made. A more challenging issue is the one of the ensuring comprehensibility of information about the court's work. The challenge lies in the fact that the information is occasionally difficult to comprehend to a law person, not because it is initially made overly technical or even obscure, but because of the nature of issues addressed to the court. The court puts a considerable effort into ensuring the comprehensibility of the information about its works. For instance, on the website of the Constitutional Court, anyone can access plain language instruction on how to submit application to the court and so on and so on. But more interesting for you could be that in the most important cases examined by the court, the judge rapporteur of each case record a specific video explaining the ruling of the court in their own words. However, as indicated above, this activity has their limits. Therefore, it is inefficient for the court to engage in one-side provision of information. It is necessary to discuss issues relating to the court's work, but also with regard to constitutional issues in general, such as rule of law, fundamental rights, democracy, etc., in cooperation with various groups of society. In recent years, the Constitutional Court has been very active in engaging in such general dialoguing, starting from organizing lectures by judges and staff members of the court in various regions of Latvia, continuing with organizing an annual drawing and essay competition for pupils, and ending with organizing public interdisciplinary discussions with leading intellectuals regarding issues of statehood, democracy, etc. In conclusion, I would like to once more again return to the difference between the understanding of people-centered justice with the court system and in broader manner. When carrying out their principal function, adjudication cases, courts may not and should not exceed their competences in order to become more people-centered, because it would be a real threat for the delicate mechanism of a fair trial.
On the other hand, courts can and should do whatever it is in their power to build trust in the justice system and the rule of law in general. Thank you.
Thank you very much, Irena. And now I will pass the floor to our colleague Jurga Greciene. She is Vice Minister of Justice of Lithuania.
Thank you. Dear colleagues, I would like to express my gratitude to organizers of a Global Access to Justice Roundtable. On 24 February, with the outbreak of war in Ukraine, we all woke up to a new reality where justice became even more important and even more worth of our collective efforts. I fully agree that people-centered justice systems are crucial to reinforcing democracy and rule of law. This even is an excellent forum to share the political ideas, how to achieve our common goals in this area. The rule of law is one of the constitutional values to share in democratic societies. I'm convinced that our cooperation at international level leads to a common vision how mechanisms necessary to ensure the rule of law can be even further improved. In the context of aggression against Ukraine, it is utmost important for all of us to respond to disinformation and to ensure the safety of journalists. Therefore, we fully support the European Commission initiative regarding measures against so-called SLAPs. We have also initiated amendments to our national laws aiming to specifically tackle this problem. One of the main goals of the Lithuanian government is to increase transparency and public trust in justice institutions through their modernization and making legal procedures even more effective. The use of digital technologies in courts may improve accessibility and availability of our justice system. We can communicate with our courts electronically. Numbers show that the use of video and teleconferences for organizing distant court hearings is growing. This year, we have achieved further progress in distant court hearings. Together with our stakeholders, the Judicial Council made it possible for the public to observe remote court hearings. The publicity of courts is directly linked to public trust in justice. We will further strive to ensure the same level of publicity for remote court hearings as in the courtroom. We have also adopted the laws ensuring the distribution of functions that are not intrinsic to the judiciary, to notarius and bailiffs. We hope that the introduced changes will allow the courts to focus on the most important legal issues, thus better reflecting the needs of our citizens and businesses. State-guaranteed legal aid plays an important role in addressing the legal needs of the vulnerable members of society. We are delighted that the development of the information system was finalized earlier this year. This tool is a beneficial supplementary method to reach legal information, receive legal aid e-services, and use self-help instruments to find answers to legal questions. Currently, our aim is to work towards the improvement of the effectiveness and quality of the state-guaranteed legal aid. Intense discussions with stakeholders have been held to reach a common view on the possible changes to ensure effective, adequate quality legal services to the most vulnerable members of society. Common work of the government with our partners is at most importance. Thanks to all this cooperation, the Lithuanian government is able to present to the Parliament the draft laws that not only represent the political aims of the government, but also reflect the real needs of a public society in general and of legal professionals. Dear colleagues, I am really honored to share the experience of Lithuania today. I am looking forward to our further discussion. Thank you.
Thank you very much, Jurga. And next panelist is our guest from Malta, John Galea, Permanent Secretary, Ministry of Justice, Equality and Governance of Malta. Please.
Deputy Prime Minister and Minister of Justice, honorable ministers, experts, guests, colleagues. Listening to the previous speakers, it confirms how many common factors and challenges countries and societies are facing, and the importance of such a forum that we are in today in order to be able to face such challenges. Although still a developing notion, there is by now a strong cultural consensus on the need for people-centered justice, with the explicit acknowledgement that people, rather than institutions or structures, should be at the heart of justice systems. For example, at EU level, we are seeing various targeted directives and regulations, such as the Istanbul Convention on Domestic Violence. Also European tools, such as the EU Justice Scoreboard, to give specific attention to focused populations, such as children and the elderly. And definitely, we cannot forget, and I have to mention, the virtual Global Roundtable on People-Centered Justice convened by the OECD early on last year, during which people-centered justice emerged as a rule of law approach that relies on perspectives, needs, strengths, and expectation of the justice user to improve the quality of justice and reduce barriers to service delivery. From an administrative and strategic perspective, I would like to reflect on a couple of points, which, in my opinion, and also from the viewpoint from Malta, merit attention. First of all, learning to read the signs. It is very important that we break free from our established way of thinking and start looking at justice from the perspective of the user. We need to acknowledge opinions and positions that are challenging to established ways of thinking. We need to look at our processes with fresh eyes and re-engineer them in order to address shortcomings. For example, when in 2021 we carried out a population survey to study the degree to which the Maltese population is ready to embrace digital justice, we learned that online services, which we had already designed and were already in practice with the intention of providing more access to justice to the users, were still not being taken up. This leads to our justice sector needing to look at itself and ask the questions why, and also rethink its strategy. And this leads me to the second point, the need to strike a balance. It is important to acknowledge that in making justice more people-centered, the main input has to be provided from both the service provider and, even more so, the end user. If the language in court is difficult to understand, it is very important that legal professionals have to be trained to speak less technically. If the cost of litigation is too expensive, it is very important that legal professionals and governments will need to offer alternative mechanisms to make justice more financially accessible. People centricity does not come at the cost of losing sight of the needs of the service providers. It brings together both service providers and service users in working to bridge the justice gap, whereby people do not get the appropriate knowledge, services, support, and institutional resources to handle their everyday justice needs, while also achieving the necessary fair outcomes. My third point is that it is form that follows function, and not the other way around. When we are transitioning into people-centered justice, we need to strategically align all our structures to support and fulfill this transition. We do this, for example, by entrenching communication lines with different user groups into interministerial committees, drafting new policy lines so that change becomes institutional, to measure people centricity through agreed upon KPIs. This will necessitate that we even look at our data structures and question whether they are providing us with the means to measure what we need, and if needs be, to adapt them. Digitalization has given us an unprecedented opportunity to make justice more accessible. During the pandemic, many jurisdictions have adopted virtual courtrooms. In designing the service, we cannot simply believe that we have enhanced the systems as a result of digital accessibility, without thinking of how these same systems have to cater for the digitally illiterate or the visually or hearing impaired. Therefore, structures have to knowingly serve the function of full accessibility. Another point is the building of trust through restructuring and education, something that currently in Malta we are doing through various initiatives. We are carrying out an information campaign that is not just about promoting a service, but rather also of educating the people to understand the role of the institutions in the justice sector, and thus consciously attempt to bridge the knowledge gap. Carry out a digital justice strategy rollout that will implement a vision for the continued development and strengthening of the national justice system based on strong investment in the digitalization of the justice system, its operations and processes, with the main aim of rendering our national justice system more accessible, inclusive, more efficient, and thereby even more effective, but based upon good governance principles such as transparency, accessibility, and accountability. The strategy was drafted following a public consultation process, during which we received feedback from a number of stakeholders that fell outside of our usual circle of collaborators. This was an eye-opener for us, as it made us aware how far-reaching the interest and investment in the justice sector actually is, and also how our traditional practices, at times, pose a limitation on the level of collaboration that such an exercise demands. The restructuring of our institutions in order to build trust is something that we have been carrying out over the past decades. A number of remarkable reforms have been carried out. We have established a number of new justice agencies, such as the Legal Aid Agency, the Court Service Agency, the Victim Support Agency, and also, for the first time, the Department of Justice. Furthermore, we have carried out a major reform by separating the functions of the Attorney General from those of the State Advocate, establishing both as separate agencies with their own legal identity and also independence. Presently, we are working with DG Reform and the World Bank in carrying out a reorganization process in order to enhance the efficiency of these offices and help them embrace good governance principles, all with the intention in order to build trust with the public. This will, in and of itself, empower people to understand and use the law through means that are familiar to them, thereby providing justice services that are people-centered while continuing to enable the access and use of fair remedies. In doing so, we would also be mirroring our development towards the 2030 Sustainable Development Goals in this field. To conclude, a key factor here is the creation of a data culture. We have embraced a conscious cultural and mental shift from a culture based on sporadic data collection and siloing of data to one in which data is the means to create a culture of accountability and performance management. One of the key strategic goals is to build data capability across all justice institutions, to create a data ecosystem that will provide us with the scientific knowledge to implement policy changes. It is through said interconnection whereby systems read one another securely and through the mere fact of rendering justice services digitally that we are striving to promote the collaborative whole of state and whole of society approach, reinforced by the notion of people-centered justice. Combating silos, bridging the justice gap, and bringing people together through a collaborative approach is key. This is clearly a strategic priority for us, and is currently already being implemented through a steering committee composed of key stakeholders in the field of justice, advancing a people-centered and user-centered justice system. I believe here that the OECD can be instrumental here to continue to assess states, as well as its partners, through the exchange of ideas on said founding notions, through the continued development of guidelines, and through the elaboration of model implementation principles based on case studies that reflect the reality in our societies. Bridging the justice gap is imperative, and it should be within reach. Thank you.
Thank you very much. And now I'll give the floor to Ms. Veronika Mihailov-Moraru, the State Secretary, Ministry of Justice, Moldova. And yes, so we all can see you already. Yes, please, floor is yours.
Thank you very much. Good morning, all. Distinguished audience, dear Deputy Prime Minister, dear Minister of Justice of Latvia, dear colleagues, it is my pleasure to be part today, even if online, to these high-level discussions aimed to address our views on providing responsive justice enhance the rule of law, and rebuild trust in the justice institution. Indeed, it is a valuable opportunity to share and gather, on other hand, good practices, and we are searching for in order to better the justice sector. As probably the Republic of Moldova currently undergoes wide reforming processes, mainly focused to address the challenges of the sector related to the integrity, accessibility, efficiency, and lack of trust. All questions proposed to be considered in today's discussion are relevant for Moldova's justice sector needs. However, I would like to reflect on our priorities in rebuilding the trust in justice. According to the statistical data, trust in the judiciary quite faithfully repeats the fluctuation of trust in the justice system institution. Unfortunately, this decrease in confidence engaged the government in general and the Ministry of Justice in particular with all energy to involve all decision makers and take urgent measures focused on increasing the quality and fairness of the Justice Act. The reforming processes that Moldova has embarked in are now implemented under a justice sector policy document. The strategy on ensuring and integrity of the justice sector for 2022 and 2025 has an overall objective: accessible, transparent, efficient, and responsible justice. The strategy is called also to ensure equal access to justice for all and to change society's perception, to increase trust in the judicial system and the degree of transparency. Among the promoted measures in the last period on ensuring transparency of the Judicial Act, I can mention about publication of all court decisions on the web pages of the courts, ensured audio recording of all court sessions, and examination of some categories of cases through video sessions, ensured the publication of the information on the place and date of court hearing on the court's web pages. All these pointed measures were obtained due to the implementation of the Judicial Information System, which functionality we are increasing on a permanent basis. A particular approach is paid to the actors of the justice system. Unfortunately, corruption remains the central element in the formation of trust in my country. So, and many realized studies allow us to freely evaluate the trend of perception regarding the presence of this phenomenon in the judiciary. At this point, I would like to inform you that an evaluation exercise of the judges and prosecutors has been started. And nowadays, the first stage of this exercise, envisaged for the members to the Superior Council of Magistracy, has been initiated, so-called pre-vetting. The second stage and the wider format of this exercise will be implemented at a later stage and will be focused to evaluate integrity of all judge and prosecutor of the national judicial system, also with involvement of our judicial bodies. This is a challenging exercise, but our expectations are to achieve within the next few years the increase of trust in the judicial system and the degree of its transparency. I would like to inform you about additional measures are envisaged by the Ministry of Justice to strengthen the capacities of the legal profession in order to deliver justice services in line with European standards. Measures to improve court services for citizens and make them more accessible. Measures to promote implementation of judicial performance standards through the use of modern IT solutions. A significant role of our government is to raise awareness of citizens and civil society on the harm of corruption. And it is of utmost importance to work hard to develop zero tolerance against corruption among citizens by these means changing the general perception over efficiency of the justice system as a whole. And I strongly believe that these goals can be achieved with the support of the international community, the development partners, and good expertise that we all have to change together, including in such formats of dialogue as the one ensured by the OECD today. In conclusion, I want to point out that the justice sector has been and remains a major priority for the Republic of Moldova, which is of utmost importance for the entire society and is an essential condition for developing democracy, since only an independent and efficient judiciary can reinforce democracy and restore sustainable growth. In the end, I would like to thank you very much for your attention, for your invitation, and I wish you all a very productive day.
Thank you, Veronica. It was our pleasure. And now I'll give the floor to our Portugal panelist, Pedro Tavares, State Secretary, Ministry of Justice, Portugal.
Thank you. Good morning. Thank you, Mr. Deputy Prime Minister and Minister of Justice. Thank you very much for the invitation. I will start by saying that having overcome the major challenges posed by COVID, we should start reflecting on the lessons that we have learned from the pandemic and too about this challenge times ahead. From our perspective, one of them is as follows. We know that it was thanks to the transformation path based on the principle of digital by default and a strong focus developing people-centered services that were able to face the pandemic crisis without the justice system ever ceasing to function. And furthermore, it was the constant dialogue with users of justice system that helped discover new opportunities to overcome and create new services for citizens. We have recently created a service that is enabled authentic acts that allows different legal acts to be performed remotely, such as real estate deeds or the separation or divorce by mutual consent. And at a time when the world faces new challenges and the ones that are most significant than COVID, the road must be paved with an eye on the Riga agenda, of course, if we are to overcome them as we overcame the pandemic. Let me show you and explain on 3 areas where we think we need to act and act fast to better transform justice. The first, obviously, is trust, the one that we are talking mainly here. I would say that trust can only increase if you can keep the people space. The digital transformation, the current changes on citizens require a new approach on justice. And we need to better understand that the people-centered justice means that people are both on the point of departure and also on the point of arrival on justice policies. No policy-making element is as fundamental as the proper assessment of citizens and business needs. Not just because they are the definition of this methodology, but also, first and foremost, because they are the key driver without which a citizen-centered approach will lack both goals on success criteria. So we need to keep people's legal needs in mind at every stage on the service life cycle, from its design to implementation or evaluation, to better understand the complexity of the project, the complexity of the challenges, and develop a response. So, for this reason, most strategic measures in our action plan that have been designed and implemented in constant dialogue with stakeholders are the ones that were really successful. These measures were appreciated by the judicial staff and the users, and this improves also the Portuguese judiciary system and has contributed to maximizing their impact and ensuring their long-term sustainability. Another aspect of this part of the trust area is communication. We cannot simply do change if we cannot communicate. Citizens often do not know what are the new systems available, what is the transparency, what are the information, the statistics. So we need to keep pace and inform people where they are right now. So as I've said, citizens have changed a lot in the last decade. The second area is purpose, trust and purpose. So in Portugal, we have made a strong investment in the modernization of justice. However, this effort can only be justified if modernization brings added value for citizens and business. And this assessment must be made through the eyes of these citizens and business with their expectations, needs and perceptions in mind. The participation on civil society, citizens and business is the single most important step in achieving a more people-centered and inclusive delivery of legal and public services. Citizen satisfaction, undoubtedly, one of the expected outcomes of any reforms, depends directly on the flow of information between stakeholders, and the challenge is to avoid limiting participation to periodic formal reviews. One that aims to a continuous improvement process and flow constantly. Citizens should be encouraged to take ownership of the services they access and should know and feel their voice is heard. Moreover, we cannot expect reforms whose purpose is not understood by citizens to produce the result desired by those in office. We also need to better measure impact and share data on the impact if you want to make sure that we revisit our purpose and be more transparent. And the third part is in connection with this is collaboration. We need, and Gartner just showed us a report a few months ago that says that culture blocking is on a query that they made was the blocking area where this challenge poses for justice. So we need also to talk about commitment. Commitment because change, no system can evolve from the inside, but this is also true if you only think that the system can only evolve from the outside. So we need to gather legal public servants, but also judges, of course, and prosecutors, but also the outside from this system. In this respect, we have had a very positive experience. The reforms that we have done in our transformation plan included to address these challenges, talking to citizens, addressing, observing, querying, but also talking to the inside. And the last part is making sure that people have skills, having competencies. I'll be talking this later on. So I would conclude that it is very relevant the work the OECD is doing right now on strengthening the work on all this rebuilding trust with obviously digital, but not just digital, with all these aspects that we have right now. So thank you very much.
Thank you very much, Pedro, for your words. It was very important issues, and now I'd like to give floor to Mihai Paske, State Secretary, Ministry of Justice of Romania. Yes, please.
Thank you very much, Mr. Deputy Vice Prime Minister. Thank you and the OECD for this kind invitation. It's very important for us to be here, and I'm very glad to be here, Your Excellencies. I'm honored to address this high-level session on a topic of utmost importance for our citizens, advancing the rule of law and the accessibility of justice systems. Well-functioning and fully independent justice systems are crucial for ensuring that justice works to the benefit of citizens and businesses. They are also essential for judicial cooperation across the EU, as well as for functioning of the single market and the EU's legal order as a whole. As a member of the European Union, Romania supports the horizontal instruments that assess these indicators of paramount importance for democratic societies. Part of the EU's rule of law toolbox, the EU Justice Scoreboard is a very important exercise that presents an annual overview of indicators on the efficiency, quality, and independence of the justice systems in the member states. Its main goal is to assist the member states to improve the effectiveness of their national justice systems by providing objective, reliable, and comparable data. Justice Scoreboard is a valuable tool which measures the satisfaction of EU citizens with the justice system. This year, Justice Scoreboard reached its 10th edition, which demonstrates member states' continuous concern to improve justice system. The EU Justice Scoreboard is also one of the sources of information for the annual Rule of Law report, the most recent EU mechanism designed to take a snapshot of the rule of law situation in all member states. The report includes two components, an overall assessment by the Commission of trends in the Union and country analysis of each member state. The EU Rule of Law report is a preventive tool to facilitate mutual understanding through dialogue, to help address the rule of law challenges to treat member states on equal footing, to help set an annual rhythm of debate in the Council and also the European Parliament, and to push for necessary reforms at the national level. The first pillar of the Rule of Law report is assessing the independence, quality, and efficiency of justice systems in the member states. The report provides a qualitative assessment covering the main relevant developments, presenting both challenges and positive aspects, including good practices. Starting from this year, the report includes country recommendations. It presents in an objective and factual manner relevant developments to the rule of law in all EU member states, based on a unique methodology which places them on an equal footing. Romania always supported the establishment of this new mechanism. Its main advantages are sharing the best practices as well as the possibility to make progress by following the recommendations. Every next year, the European Commission will evaluate the degree of accomplishment of the recommendations for every member state. It also offers the possibility for an annual dialogue between the Commission, the Council, and the European Parliament, together with the member states as well as national parliaments, civil society, and other stakeholders on the rule of law. It is not by chance that the first pillar of the Rule of Law report is the justice systems of the member states. Justice systems are the key of the rule of law throughout the European Union. And at the national level, there is a constant commitment to strengthening the independence and to improving the efficiency and quality of the judiciary. When assessed from a comprehensive and long-term perspective, these last 15 years have shown undeniable progress and substantial reforms which have modernized the Romanian judiciary and brought it well within the general European standards. With constant cross-institutional commitment, as well as with the valuable support of the judiciary itself and of a strong civil society, Romania has followed the path of progress and reform. In this vein, we expect the new justice laws to be adopted in the following weeks. The draft justice laws are the biggest project to revise the legal framework for the organization and functioning of the judiciary since 2004. In the drafting process of the justice laws, the CVM recommendations, the rule of law findings, the European Court of Justice rulings, as well as the Venice Commission opinions were all taken into consideration. The recommendations received from the judiciary, including the Superior Council of Magistracy, magistrates' associations, and individual magistrates, were also carefully assessed and taken on board as much as possible. At the policy level, the new strategy for the development of the judiciary for 2022-2025 interval and its related action plan were approved by the government this year in March. The adoption and the entry into force for the new strategy is a milestone under Romania's recovery and resilience plan. The strategy sets clear objectives and monitoring mechanisms. It identifies as areas of action the independence, quality, and efficiency of justice, as well as the access to justice. Improving the digitalization of the justice system through the implementation of ECRIS 5, which will provide key functionalities supporting the digital processing of cases in courts and prosecution offices, the collection of statistical data and the generation of certain predefined statistical reports, as well as the electronic transfer of data between different actors, including courts and prosecution offices. The National Anti-Corruption Strategy for 2021-2025 interval was adopted in December 2021, and coordination of its implementation is ensured by the Ministry of Justice. The strategy has 5 general objectives: increasing the implementation of integrity measures at an organizational level, reducing the impact of corruption on citizens, strengthening institutional management and administrative capacity to prevent and combat corruption, strengthening integrity in priority areas such as healthcare, public procurement, and local administration, and also increasing the performance of the fight against corruption by criminal law and administrative means. Thank you so much.
Thank you very much. Next panelist is Manuel Olmedo Palacios. He's General Secretary, Innovation and Quality of the Public Service of Justice, Ministry of Justice of Spain. Please, floor is yours.
Thank you very much, Deputy Prime Minister and Justice Minister of Latvia. Thank you to the organization, to the OECD. Good morning, dear colleagues. Buenos días a todas, a todos. Bonjour à tous et à toutes, chers collègues. I would like to highlight that, as it has already been pointed out, that the global situation has been marked these 2 last years by a serious health crisis, as we all know, but as every crisis, it has hit with more cruelty upon those more vulnerable groups. This exceptional situation demanded an analysis and a diagnosis and paying attention to the special needs and, let's say it without palliatives, some shortcomings, traditional shortcomings of the administration of justice. It has allowed us to maximize the momentum of the transformation of justice, especially in digital terms, but not only, guaranteeing the provision of this essential service thanks, among other solutions, to remote working and remote trials. Projects that would not have been possible without co-governance between the Ministry of Justice in Spain and our different regions. As you know, we are a decentralized country, but also the General Council for the Judiciary, the Prosecutor's Office, and the rest of actors, stakeholders that make up the public service of justice. Our project is a holistic project based on 3 axes, on 3 pillars, and with 3 different draft laws that are currently being studied at the Parliament, at the Spanish Parliament. On the first place, the organizational level, we are building, and we think that we have to build more flexible structures in our courts and the services attached to them. And we are creating modern offices in every municipality in Spain that, by means of technology, allow people to directly connect to court without having to travel to the court premises. I think that in the 20th century, we tended to specialize courts, specialize judges, rather than having courts in every town or in many, let's say, medium-sized towns. Now we are continuing to this specialization, but at the same time we have the possibility, by means of the new technologies, to connect people disregarding their domicile, the place of living, in safe places where they can, for example, declare as witnesses before a court without having to travel to the court. The second axis would be procedural efficiency. In this aspect, I think that we have to enhance alternative dispute resolution methods. As our colleague from Belgium said before, this can not only be a pilot by the states, but mainly by the third sector and private sector, of course with the support of the state, but private initiatives are welcome. At the same time, we're trying to eliminate bureaucracy, which I think it's no news at all, but we have to continue in that process of reducing bureaucracy without any loss on fundamental rights. The third axis or pillar would be digitalization, because we really think that digitalization raises trust in justice, especially among young people. future generations that do not believe or pay much attention to solemn courts, trials or weeks, but rather to TikTok, Instagram, and communicate through Fortnite and other platforms. So we have to take a look at them without forgetting old people, that maybe they need to have this personal attention all the time. But at the same time, we have to give the two options. Digitalization is not neutral in a social perspective. We are trying to digitalize, but paying attention to every gap or inequality in access to justice, whether due to gender, geographical, cultural, digital, economic reasons related to any kind of disability, national origin, as our colleague from Canada said before, sexual orientation, gender identity, or any other reason, to build an accessible and inclusive justice administration that improves social, territorial, and digital cohesion. These acts and these projects will be implemented following two principles that already inform our work in our government and especially in the field of justice. Co-governance, I mentioned it before, internally, but also in an international dimension. In our internal dimension, we started a forum of digital transformation in Madrid in April. Mr. Garagurbanli honored us with his presence there because it already has an international dimension. And we gathered there all the judiciary, prosecutors, but also private sector, business, enterprises, and the third sector, NGOs. All of them are stakeholders of our field of justice, so we have to hear them, we have to take into account their experiences, we have to co-learn, share experiences, and also reuse projects and technologies. We are investing 410 million euros from European funds, from the resilience plan. We are not dispensing them, we are investing them with a return of that in investment. I will now briefly speak about some projects which connect with the Riga Justice Agenda. The first one is our project which is data-oriented. Data-oriented justice means a change of paradigm from managing documents, which of course we continue to do that, but also we have to manage data, because this is the only way that we can build social policies in the future. For example, we have learned that in those blocks of apartments, old blocks of apartments with no elevators, the levels of violence against women and children are higher. And this is the only way that we can make real policies, sharing this information with other administrations that can make investments directly to reduce crime and facilitate access to justice. We now have an electronic judicial file implemented in 100% of all jurisdictions in the territory competence of the ministry, including the National Court that deals with terrorism and transnational organized crime, with big trials with hundreds of accused persons and lawyers. The lawyers may access directly to the file without having to travel to court. This is saving us, for example, 18.5 million euros in transport, avoiding 50 million kilometers of transport and saving the emission of 700 tons of CO2 to the atmosphere. The possibility to have remote judicial hearings is already saving 3,000 tons of CO2 and 7 million euros of savings for professionals traveling to courts or for people traveling to courts. We are also developing a system to give legal certainty to judicial trials. Judges ask us for this legal certainty. It is not enough for a person to go to a trial and show an ID and say, I am Manuel Olmedo. This is not enough. So we are implementing a system with digital signature so that the system can certify that the person that he or she says or declares to be is indeed that person with total legal certainty. Don't forget artificial intelligence. We are robotization processes, for example, ex officio cancellation of criminal records, which is saving days of labor of many officers and avoiding low-value tasks and permitting people and public officers to dedicate time to more to tasks that have more value added to their work. I would like to end with the international dimension. Of course, we are convinced that all these projects cannot be launched without other countries' experiences that help us learn, share, and reuse, and the support and commitment of international bodies with the same goals and objectives, such as the European Commission for the Efficiency of Justice. We now have a very successful project promoting cyber justice in Spain through the management of change, funded by the Directorate General for Structural Reform Support of the European Commission. We are also working on the ECRIS project, which has been very successful in the European region, and we are proposing Latin American countries to make a system similar to this one, to interchange this information. We are exchanging European investigation orders through the portal eCodex and the tool EDES portal and the tool eCodex. The first one was this year in May with the Public Prosecutor Office in Köln, the Oberstaatsanwaltschaft. And we received the first order from the Aveiro Prosecutor Officer in Portugal this year. So we've been the first country in Europe to issue and receive an European investigation order electronically. Latvia is also operative in this portal, and other countries such as Austria, Hungary, Poland, Belgium, Luxembourg, Slovenia, and Sweden. And we are trying to bring this to the Latin America region to make something similar to this system of interchange. So I will end saying that how can we put people at the center, in our opinion, enhancing ADR, alternative dispute resolution, and leaving no one behind, filling all the gaps. How can we ground in empirical data the transformation of justice? Only through a system which is oriented in data and digitally gathers data and not just documents, and facilitates taking decisions that build social policies. And of course, how can we work collaboratively? 2 dimensions, internally and internationally, sharing experiences, co-learning and reusing projects and technologies. Thank you very much.
Thank you very much. And I just noticed that indeed to be specializations kind of for you to be a General Secretary of Innovation and Quality in justice system, it's we can see how we can learn your experience to operate with that and to understand the meaning and the importance of that. And not all the countries have this specific innovation departments or institutions, and that plays the role. Thank you very much. And now I'll pass the floor to Navi Tantasanthen, Attorney General, Office of the Attorney General of Thailand.
Mr. Janis Boden, Deputy Prime Minister and Minister of Justice of Latvia, Ministers, Your Excellencies, distinguished guests, ladies and gentlemen, good morning. For decades, Thailand has worked with the OECD to foster economic development and national competitiveness. However, this is the first time our country will have a dialogue with OECD on the social and justice sectors. It is an honor to be here as the incoming Attorney General of the Kingdom of Thailand, representing the Thai justice sector to share our progress towards SDG 16 on strengthening the rule of law and ensuring access to justice for all. 30 years in the office of the Attorney General have taught me that law and justice are not merely governing tools, but are means to achieve sustainable social and economic development. My role as so-called state attorney has also helped me recognize the impact of law of rule of law on the investment climate and its ability to induce economic growth. The significance of the rule of law has been re-emphasized through the global COVID-19 pandemic, the current economic scenario, and ongoing climate change. The absence of rule of law has a cascading effect. Governments and democracy weaken. Economic growth stalls and public confidence in institutions fail. In Thailand, recent data gathered both domestic and international confirms fears that trust in our justice institutions is being eroded. Polls conducted by Thailand Institute of Justice demonstrate that public believes that other powers could interfere with the justice system, and only a quarter think that can be reformed. This growing trust deficit, especially among the youth, has eventually led to friction. Therefore, it is imperative to rethink and reform the justice sector in our country. These trends already inform our policy. In 2018, a 20-year national strategy roadmap of Thailand set out a structural reform strategy for the law and justice sector. Its features include a more responsive and transparent justice system that can effectively deliver equal justice for all while prioritizing civic engagement and emphasizing the use of innovation and digitalization. This roadmap is a clear pivot to viewing justice delivery as a service primarily for the people. Like any other public service, it must follow basic principles of transparency and accountability, and it places the idea of people right in the center of reform. 4 years into the roadmap, Thailand is already implementing the plan. Digital transformation of judicial process, such as e-filing for court cases, adopted during the pandemic, is being mainstreamed. Newly created feedback loops are helping gather public opinion and are being used to modify policies, improve laws, and redesign institutions. On the criminal aspect, a pilot project using social media listening mechanism seeks to understand perceptions and behavior around sensitive issues such as gender-based violence and how the affected interact with the justice system. Cross-sectoral collaboration between justice stakeholders, civil society, and the private sector as a driver of successful justice reform is also a focus through capacity building and other experiments. Through various policy experiments, projects, and studies, we see that the possibilities for change are immense and wide-ranging, but many challenges lie ahead too. Some are universal. For instance, less than 6% of the annual government budget is allocated to Ministry of Justice, police, courts, and prosecutions, thus limiting reforms and innovation. Equally, some challenges are unique to Thailand, such as the growing ideological polarization around justice and democracy. To close this gap, we must engage more deeply with Thai youths, especially, and involve them more meaningfully in justice reform. Given this context, I'm particularly appreciative of being invited to a global roundtable meeting such as this event. It is a valuable opportunity to learn from the experiences in countries and jurisdictions that have successfully overcome similar challenges as ours. We also see distinct alignment with the OECD's people-centered justice approach and recognize its deep interconnection with the rule of law, public trust, democracy, and sustainable growth. We believe that our engagement with OECD in these social and justice sectors will be mutually beneficial and will build on existing efforts in other areas of governance reforms. We look forward to fruitful discussions in this coming meeting 2 days. Thank you very much.
Thank you very much. Next, our panelist is Mozra Ikramov, Deputy Minister of Justice of Uzbekistan.
Thank you very much. Good morning, dear colleagues. It's a great honor to be here. I express my gratitude to our colleagues from the Ministry of Justice of Latvia and Organization for Economic Cooperation and Development. In order to follow the time limit, we decided not to use consecutive interpretation. The representation of our delegation brings my report to your attention.
I'll try to briefly describe recent reforms in the justice sector in accordance with the strategy for further development of Uzbekistan, as well as ongoing measures within the framework of recently adopted new Uzbekistan development strategy. I would like to emphasize that in both strategic documents, the reform of justice system is identified as a separate priority area based on the principle of in the name of human dignity and honor. Firstly, our efforts in recent years to improve the independence of judiciary have focused on following measures. The institution of supervisory review of court cases has been abolished, as well as the rights of the chairman of Supreme Court, the prosecutor general, and their deputies to lodge a protest as a supervisory review of court decisions has been abolished. The institution of returning criminal cases to further investigation has been abolished. The right of prosecutors to participate in all economic proceedings also has been abolished. Secondly, increasing the openness of judicial process has become the main focus of our reforms. A system has been introduced for the online broadcasting of court proceedings and introduced the practice of publishing court decisions on the website of the Supreme Court, and as well as explaining the content of the adopted judicial documents. Secondly, we attach great importance to the formation of the judiciary. An open and transparent formation of the judiciary on the basis of competitive selection has been ensured. In particular, the High Council of the Judiciary has been established and is working continuously to select candidates for the post of judge. It's composed of judges, lawyers, members of legal and scientific community. And qualification requirements and mechanisms for the selection of candidates for judicial office has been strengthened, and also requirement for minimal age, also raised to 35 years. They are judges and candidates for judicial office. They are now appointed or elected for initial 5-year, following 10-year and indefinite term of office, which ensures the stability of judiciary and enhances the independence of the judiciary. In the foreseeable future, according to our new strategy, increasing the level of access to justice for citizens and business entities remains our focus. To this end, we plan to expand the scope of judicial review by improving the system for handling complaints against decisions of officials in administrative courts, and to strengthen judicial control over the investigation through further development of the institution of habeas corpus, And introduction of a system of receiving applications regardless of jurisdiction and referring cases to the competent court on the principle of single window in the court system. And also it's very important to note that we are paying attention to digitalization of the judicial system and court system, and also we would like to note that in turn the Ministry of Justice is directly involved in the process of ensuring justice. Firstly, through our efforts to further strengthen an adversarial nature of judicial process and thus to ensure the objectivity of justice, a new institution of witness counsel has been introduced, according to which a witness also has a right to participate in the case together with a lawyer, defense lawyer. And defense counsel in a criminal case has the authority to conduct a lawyer's investigation. And lawyers have been given the right to act as mediators and as judges in arbitral tribunals and international commercial arbitration. Secondly, high-quality forensic expertise has a direct impact on the administration of justice. In this regard, the range of forensic expertise is constantly expanding, and the establishment of non-state forensic organizations is permitted in our country. A unified interdepartmental electronic system, e-expertise, was introduced last year. And all these measures are designed to improve the quality of the administration of justice and thus ensure the effective protection of rights, freedoms, and legitimate interests by the judiciary, by court. In conclusion, I'd like to note once again that today's event is an effective platform for sharing experience and achievements in the field of justice. Such meetings allow to maintain feedback with our colleagues on the most urgent issues as well as to further meet the needs of parties in solving legal issues. Thank you very much.
Thank you very much. And now I pass the floor to Ramin Gargun-Barangli, President, European Commission for the Efficiency of Justice, CEPEJ, Council of Europe.
Thank you very much. Dear ladies and gentlemen, dear prominent colleagues, it's my great pleasure to be here to participate in this roundtable. I would like to express my sincere gratitude to the organizers, to the government of Latvia, to the Minister of Justice, to the OECD Public Governance Directorate for such an important initiative, for such an important event, for invitation and excellent organization of this event. Taking into account that the people-centered justice and the access of justice are critical to maintaining and reinforcing the democracy and trust in democratic institutions, the Council of Europe as a regional international organization is constantly supporting its 46 member states in protecting the European values based on the main principles, the rule of law, democracy, and the human rights. We believe that the justice should be of a high quality, affordable, and accessible to make it as easy as possible for all members of society to benefit from them. In a recent period of time, as we all witnesses, we faced with unprecedented challenges such as COVID-19 pandemic, which caused the wide application of ICT in the organization of justice systems and delivery of justice. And I would say this was wide but uncontrolled application in majority of countries across the Europe. As well as we faced with other challenges recently, like conflicts and wars, with a relevant violation of fundamental principles of the international law. Today, the transformation of justice institutions in accordance with the modern challenges is a pressing necessity for many countries around the world. Citizens and businesses expect better and faster results and more responsive, targeted, and effective services in the field of justice. People centricity across the justice sector became a pivotal factor in all legal reforms in majority of European countries. Taking into account the limit on this 5 minutes limit, I would like very shortly to give you like the main expectations and the requirements based on our biennial evaluation report, which the CPEJ is running, and this is only the single source of information about the European judicial systems worldwide. So this is the one direction expectation. This is the promptness and continuity of justice in the era of unprecedented challenges, which must be ensured. We found out that the main problems which the users faced in the member states, this is the duration, the time frames of the court proceedings, and the optimum and foreseeable time frames of judicial proceedings must be provided in the member states, and the CPEJ are very supportive in that because we develop many analytical and practical tools like guidelines for judicial time management and implementation guide towards European time frame for judicial proceedings. And very important document was recently adopted. This was the analysis on the role of parties and practitioners in avoiding or reducing delay in disposal of court proceedings. At the same time, we should acknowledge that the user-centric way of service delivery, that's a strategy that's based on putting the user at the core of businesses process to provide a both positive experience and build long-term relationships. That's why in the plenary meeting of the Commission, we adopted very recently very interesting documents. This is the compilation of guidelines and comparative studies on the centrality of the user in legal proceedings in civil matters and on the simplification and clarification of language with users. As you see, the user centricity now is the, and it was before, but now it's more and more play a significant role during the adoption of the European guidelines within the CPEJ. I would like to say that in 2020 we identified, and based on the request from the member states, we see that the countries, majority of them, were not ready of delivering the justice in Europe during the lockdowns and this unprecedented pandemic. And we, based on the request from the countries, it was adopted the declaration on the lessons learned and challenges faced by the judiciary during and after the COVID-19 pandemic. It can be other pandemics in the future, and the continuous functioning of judiciary and of the services provided by justice professionals need to be ensured at any times. This is we reflected the main 7 principles in this declaration. So the crisis cannot be used to excuse the deficiencies in judicial systems, and even less to reduce standards or breach legal guarantees. It means that judicial systems have to be prepared at any time, notably when it comes to effective solutions to ensure the continuity of court work and access to justice. Secondly, I would like to draw your attention to the predictability of the justice. Today, among the main users' expectations are these concerning the predictability of the length of proceedings, cost of proceedings, and delivery of judgments. It means the predictability of the application of law, even despite the fact that the court decision is by definition is random. You know that the CPEJ delivered the European Ethical Charter on the use of artificial intelligence and in judicial system, and this is the only single, we were the pioneers in developing the document, which is the reference in matters of use of artificial intelligence in judicial field. And finalizing my speech, I would like just to touch some issues relating to the cyber justice and transformation of justice systems. Recently, we adopted very important documents, European guidelines on the video conferencing judicial proceedings, guidelines on electronic court filing and e-filing, and digitalization of courts. And I would like to say that the application of ICT in the court systems during the delivery of justice, including the use of video conferencing in judicial proceedings and installation of e-filing systems, should not undermine the right to fair trial, as enshrined in Article 6 of European Convention on Human Rights, and meet the requirements of the Convention for the protection of individuals with regard to automatic processing of personal data. Ensuring the cybersecurity and the protection of personal data must be a priority. I would like to also thank our colleague from Romania when he mentioned about the EU Justice Scoreboard. The CEPESH was responsible for the preparing of this scoreboard, and also we are responsible for the Western Balkans scoreboard. And it's our pleasure to support all the member states in delivering these reforms. And today, the CEPESH goes beyond Europe. We have other countries like Israel, Kazakhstan, Morocco, Egypt, who are reflected their willingness to be a part of this evaluation. And so thank you very much for your attention.
Thank you very much, Ramin. Indeed, very important conclusions. And now I pass the floor to Ms. Heidi Luterus, and Deputy Secretary General, Department of Legislative Policy, Ministry of Justice of our neighbors, Estonia.
Thank you very much. Ladies and gentlemen, dear colleagues, first of all, I would like to thank the Ministry of Justice of Latvia and the OECD for co-hosting this high-level event, and I'm looking forward to the discussions later on. Dear colleagues, in order to have a meaningful impact and to develop approaches and frameworks that actually better the lives of ordinary people, it is crucial to support the co-creation of services, especially in the justice system, which needs to be fair and just, as well as seem fair and just. So we should involve people already in the design phase of new regulations and services. This is especially important in the process of digitalization of justice, which we in Estonia see as one of the means of achieving the objective of people-centered justice. When designing new digital services, it is easier, or quite easy actually, to design the services from the perspective and the needs and understanding of the government, the courts, and other actors in the justice system. But we need to keep the needs and understandings of the people also in sight, so that they would be able and also willing to use these new digital services. So what does this mean for us? From the government side, it means that we need to think differently and we need to plan better. It means that we need to allow for more time for exchange of ideas. We need more time for trials and test runs, especially when we are talking about digital services. And we need more time for cooperation with people who are new to the justice system or who are not as well acquainted with all the intricate rules of the game. We need to be able to explain our ideas in a way that allows for people with less experience or less education to be involved in designing the way the justice system works. For us, this all means the need for new skills too. And I think this could be supported by the OECD through events like this one, but also other joint working level seminars, trainings, and toolboxes. It is important to ensure formal access to justice to all groups of society, without doubt. But we also need to make sure that access to justice works on a practical level as well. For example, is the support and services we provide equally accessible in all regions and throughout different language and cultural groups? Is the service quality good in all parts of the country? Is it good on all levels of the justice system? But even more importantly, how do the people perceive the justice system? Madam Director from the OECD mentioned earlier that the level of trust in justice system is around 56% in the OECD countries, but the level of trust among young people is lower, and this is a worrying trend. So even more importantly, we need to ask, how do the young people perceive the justice system? Do they perceive it as accessible to them? Do they understand how the justice system works? Do they feel that they are being treated fairly, with respect, and in a way that allows them to understand both the process as well as the outcomes? So based on that knowledge, we can start mapping out areas that need changing. We need to prioritize and come up with a realistic action plan that is backed up by necessary means. Ideally, of course, this all work should be carried out in a way that allows for involvement and engagement of a wider group of people, both from the government, the NGOs, enterprises, and citizens alike. We need to make sure that the implementation of such action plans is transparent and as inclusive as possible. In order to have impact, there has to be more emphasis, first of all, on sustainability. Secondly, on evidence-based practices that also consider the fact that we have limited resources. And thirdly, long-term funding for these kinds of activities and services which have proven impact, whether in our own country or in other countries. There needs to be more multi-agency cooperation, not only on working level, but also on policy level and among politicians. We need a long-term vision for developing justice systems that are in accordance with citizens' needs. This vision should be agreed upon a wider scale so that, for example, changes in government would not hinder this strive for a citizen-centered justice system. Allow me to finish with a more global, a more general issue when speaking about access to justice and also trust in justice. Respect of international humanitarian law and human rights law forms an inseparable part of the rules-based international order and our international justice system. In this context, sadly, I also have to talk about Ukraine and the Russian aggression. So it is up to the international community, including the OECD member states, to support Ukraine in its endeavors and also to discuss the different possibilities, whether it be establishing a special tribunal for bringing the perpetrators of the crimes to justice, conducting special investigations to find out the perpetrators, or even establishing an international compensation mechanism for later on. To conclude, I would like to stress that the fight against impunity, the rule of law, and the pursuit of justice are an essential component of sustainability, of peace and security. So, thank you very much.
Thank you very much. Thank you very much. And next speaker would be Johannes Surpa, Director General Department of Democracy and Public Law, Finland. Please, your floor is yours.
Thank you, Minister Bordens, Excellencies, dear colleagues. As we've heard already this morning, the rule of law and people-centered justice are clearly areas where the exchange of best practice and experience is very fruitful. And therefore, of course, on my behalf or on behalf of the Finnish Ministry of Justice, let me thank the government of Latvia and the OECD for organizing this very important conference and in this very beautiful venue as well. And I would like to also take this opportunity to thank you more generally for the ongoing work in this area, which we appreciate. The rule of law works well when citizens can trust that their rights will be protected. I also, as like others, underline the importance of trust as one of the most crucial elements of our democratic societies. If you like, trust can be called the internal glue that keeps us together. Dear colleagues, according to this year's Rule of Law report by the EU Commission, the level of perceived judicial independence in Finland continues to be very high, both among the general public and among the companies and enterprises. Overall, 88% of the general population and 87% of the companies perceived the level of independence of courts and judges to be fairly or very good. However, having said this, upholding the rule of law and the access to justice require constant work and nurturing, and Finland is certainly no exception there. In Finland, we have underlined that the rule of law and respect for democracy and human rights are all closely interlinked. There are no protected rights without the rule of law, and the other way around, there can be no rule of law if human rights are not respected. I would also like to emphasize the aspect of taking into account the various minorities and groups in a society, whether they would be on the basis of age, language, origin, sexual orientation, gender, etc., and as well taking into account indigenous people's rights in the countries where we have them, like Finland. I realize that others like Spain and Canada have also emphasized these aspects. Also, I would like to emphasize the engagement of civil society at various stages of the process, like just my Estonian colleague also emphasized. I think this really plays an essential role in the design of our legal policies and practices. I also believe that much of the trust is based on openness and transparency. Transparency has a positive impact on public and business perceptions of judicial independence. The Finnish courts have adopted a culture of openness, and publicity is very well implemented in their operations. One good example of this is the recently launched special network of media judges who are reporting on the work of the courts towards citizens, trying to make it more understandable for the citizens what they actually do. They go to social media, etc., to reach various sectors of the society. And here I'd like to also refer to experiences we've heard around the table, like in the host country Latvia, where also this aspect was emphasized. I would also now like to take this opportunity to present to you one concrete example of how we have tried to shape our services to be more people-centered and accessible for all. One of the key challenges we have recently focused on is debt and the over-indebtedness of citizens. And currently, the skyrocketing inflation and the soaring energy prices feed this phenomenon even more. When faced with financial difficulties, trust towards society and its institutions may erode. People may feel left alone. And in the worst-case scenario, the lack of trust may lead to polarization and the dismantling of the social fabric in our society. To tackle this, we have developed financial advice clinics, which resemble a little bit the idea of maternity and child healthcare clinics. So the idea that lies behind is that people are put in the center of the process. When you enter a clinic, you can meet experts from several different kinds of health providers at the same time. So experts from debt counseling, enforcement, social services, and also NGOs working in the field will be present. The concept enables for easy access services that are designed to help citizens from one place, thus avoiding people from being transferred from one destination and institution to another. At the moment, there are 30 financial advice clinics in different parts of Finland, and the results are promising. I think the same model could be implemented in other areas as well. So once again, I would like to thank the organizers for hosting this important event, and I'm looking forward to a fruitful and forward-looking conference at a time that is not easy for us after the pandemic and under the circumstances that were referred to by Estonia and others. Thank you very much.
Thank you, dear colleague. And next speaker will be Anneke van Dyke, Director General, Administration of Justice and Law Enforcement, Ministry of Justice and Security, Netherlands.
Thank you. Your Excellencies, ladies and gentlemen, please let me start by thanking the OECD and the government of Latvia for this opportunity to reflect on how the Netherlands has addressed and will continue to address Sustainable Development Goal 16 on access to justice. And I will highlight some of the central elements in the roundtable discussion, and hopefully we can inspire each other these days to uphold the rule of law to ensure equal access to and trust in justice and the democratic institutions, and the importance of people centricity in challenging times and a changing world. Upholding the rule of law is the fundament of a democratic constitutional state. It is essential for economic stability and development. The law is there for everyone. Everyone should have equal access to justice, and the government should be the first to abide by it. The rule of law also requires trust in and trustworthiness of justice and the democratic institution. This requires, above all, a government that is reliable, serviceable, and mindful of the human condition. It also requires a strong and independent judiciary that corrects the government, businesses, and citizens if they do not follow the law. And I'm satisfied to see that this year's EU Rule of Law report and European Justice Scoreboard offer a positive reflection of the state of the Dutch rule of law, as well as a generally high confidence in the judiciary. But like my Finland neighbor, I'm also convinced that this is not a reason to lay back. In recent years, the Netherlands had a saddening example of injustice and a dysfunctional rule of law in the so-called childcare allowance affair. Thousands of people were made victim of false allegations and fraud regarding childcare benefits. The state powers rigidly applied legislation without regard to the disproportionate consequences for the people involved, which was sanctioned by the courts. In the wake of the childcare allowance affair and other issues, the state powers have reflected critically upon their actions. And one of the most important initiatives resulting therefrom is a people-centered perspective and the improvement of equal access to justice. And, well, access to justice does not merely entail access to a judge. It's about meeting people's needs and helping them solve their problems in a durable manner. Sometimes court judgments do not offer a lasting solution to the problems a person faces. People may face multiple interrelated problems that are of a social, economic nature rather than of a legal one. Access of justice is about the practical meaning of the rule of law on people's lives. We must strive for people-centered justice. Affordability, comprehensibility, and availability are important goals in that regard. With this in mind, the Dutch government is working hard to make justice more accessible. For example, through greater commitment to socially effective administration of justice, low threshold, alternative dispute resolution, mediation, and restorative justice, and an extensive program to renew the subsidized legal aid system. And I'm interested in the Belgian, non-profit authorities. By strengthening access to justice, the Netherlands aims to contribute to the increased participation of citizens in society and increased sense of security, more trust in the rule of law, and a better business and investment climate. Well, let us learn from the challenges we are facing, and let us remain committed together to keeping the rule of law strong. Thank you.
Thank you very much. Next speaker is Alexander Rosenbodka, Director, Department of Strategy and European Funds, Ministry of Justice of Poland. Please.
Thank you, Prime Minister. Thank you, dear guests. Thank you, OECD team, for the invitation. It was always a great pleasure to be with you. It is not my first time on OECD event, but the first time as a speaker, so you know it's a great honor and challenge for me. According to issues that are mentioned here in the discussion, I want to underline that orienting the justice system to a people-centered model helps showing citizens that the justice system works to provide them with a sense of security, equality, and affiliation. A trustworthy system leads to the development of a social capital and civil society. It supports investments and impact the quality of a citizen's life in a positive way. It also means that the solutions introduced into the justice system are based on accurate analysis and statistics, and means that the system is accessible without obstacles, barriers related to language, architecture, etc. It helps people with different needs. It works on the principle of adequacy and crime prevention and strengthens citizens. And that's that is also taken into consideration in activities taken by the Ministry of Justice in this regard that concern ensuring an accessibility and citizen-oriented justice system, creating consistent and transparent law, improving the system on free legal aid, free civic counseling and legal education. In order to make justice reform meaningful and to have an impact on people, the Polish law-making system uses a tool public consultation. As a part of consultation, comments on projects can be submitted by associations, foundations, citizens, labor unions. It is an important role is also the ability of citizens to initiate changing in the law. The law on access to public information also point out another instrument. In Poland's system, free legal aid and civic counseling also helps right citizens trust in the institution of a justice system by making free legal aid available to those in need, providing legal education and civic advice. The system meets the most important requirements of people-centered justice. Promoting the people-centered justice model can positively influence increasing public trust. It is for sure. Reforms must be aimed at filling identified systemic justice system gaps. It is necessary to recognize where certain gaps appear and fill them with the best possible solutions. Strategics should take into account the process of proper data collection and analysis, and it was mentioned before. I mean data that allows for quality assurance control and data on the beneficiaries. Citizens need to know that the justice system is for them, that is developing and that it works according to their interest and, of course, their needs. The Ministry of Justice used a people-centered justice model in its 2021 action strategy titled Minister of Justice Strategic Direction and Goals. The Minister of Justice defined the following strategic directions for the Ministry of Justice, such as proper and efficient functioning of the justice system, the rights of the citizens in the center of the justice system, strengthening synergies and organization cultures. This direction enabled the Polish justice system to evolve to achieve proper and efficient functionality and provide full access to court. The Polish minister's strategic goals in this context include improving the operation of the justice system through the introduction of e-service and modern technologies, standardization of work organization system in the justice system, improving the spending of budget resources. And I would also like to mention that the most important issue needed for promotion, collaboration between government and society is a promotion of legal education. Citizens should be presented with what it means that people-centered justice is based on evidence and statistics, where the data comes from, why it is collected, and what conclusions are drawn from. In Poland, we have recently held extensive consultation with communities and groups involved in the free legal aid. These included legal councils, NGOs, and territorial self-government. We collect data and opinions of beneficiaries of the received advices. All of this makes it possible to adapt the system to the need of those who really need it and they need to use it. The digital transformation of the justice system promotes its efficiency and improves access to the courts. It was also mentioned before, and in this moment, I'd like to point to our important projects that I'm responsible for in Ministry of Justice. One of them is IT project. It's named the Dissemination of Alternative Dispute Resolution Method by improving the competence of mediators, establishment of a national register of mediators and other activity. The main objective of this project is to professionalize the mediator profession and also national register of mediators will be established. I hope it will help people to find good mediator for them and to choose mediation instead of the process as their first step in solving the problem. The second one, the second project I would like to mention is the project ensuring access to justice for people with disabilities. I think it will be a good subject for our next meeting, as I've heard, but I also wanted to mention that we take different needs into access to justice in Poland. People-centered justice leads to ensuring effectiveness of law in the country. It's for sure all those people involved in the functioning of justice system should know and understand what equality, accessibility, and availability or improvement are. Cooperation is needed, both internationally as a today meeting, but also nationally and locally. Each environment has its own experience and needs, but they also share the same goal, to ensure people-centered justice. And to conclude, not to make it too long, I would like to mention that also the OECD has a great input in this increasing of knowledge of education system among citizens, among countries, OECD countries, helps countries by creating platform for exchanging good practices, experiences, and thank you very much for that. Thank you.
Thank you very much, dear colleague. And next speaker will be, I would ask Matija Vidmar, Secretary Office of International Cooperation and Mutual Legal Assistance from the Ministry of Justice of Slovenia. Please, the floor is yours.
Mr. Bordens, Mrs. Pilichovsky, honorable delegates, ladies and gentlemen, my intervention will focus on Slovenia's perspective. At the beginning, I would like to highlight the challenge that we have faced in the rebuilding trust in justice. Let me emphasize that despite the success we have assisted in raising trust in the judiciary, this is not yet a completed task. It is a task that we must always keep in mind. A decade ago, less than a quarter of citizens trusted in Slovenian judiciary, and the influence of the media increased this trust even more. Today, trust in the judiciary is relatively high. What has Slovenia done to increase trust in the judiciary? In order to improve the justice system as a vital public service that upholds laws, defends rights, and supports institutions, the Supreme Court of Slovenia initiated in 2018 the Improving the Quality of Justice project. This project addressed the improvement of quality for three groups: judges, court staff, and court users. The desired effect of the procedural justice part of the Eu Justice project that deals with court users is a better understanding of court procedures and the nature of judicial work among the general public. The Eu Justice project has won the Council of Europe and the European Commission Crystal Scale of Justice Prize in 2019. More about the project I just presented you can find in my written statement, but it's also accessible at the web page of the European Commission, also of our Supreme Court. Let me respond to a question how we ensure the justice system reforms and modernization efforts are meaningful to people. To ensure this, I believe it is necessary to ensure quick and speedy resolution of trials so that justice can be served to the people. Justice delayed is justice denied is and must be a legal maxim. Regarding collaboration, how we promote it, I think it is important that, at least from my point of view, to mention that in the judiciary we have had and or occasionally still have unpleasant experience with the media and politicians, as they often do not respond respectively and objectively to court cases they present. The role of media in reporting good news should be acknowledged. This will enable faster progress towards restoring trust in the judiciary, we must be aware that public trust in the judiciary is responsible of the entire society. Very important question is also what are the implications of people-centered justice approaches for our understanding of the rule of law. It is the duty of all governmental and other institutions to respect and observe the independence of the judiciary. Likewise, the judiciary courts and judges must protect their independence and respond to attack mainly from the media and the political parties. I'm convinced that attacks on the judiciary must be responded to common accord by all, the government, parliament, and the judiciary as a third branch of power. The media, as a fourth branch, also plays an important role in this. The issue of fiscal constraints can result in a threat to judicial independence and denial of justice. The modernization of justice system could be a good tool to reduce costs, but with a long-term perspective in mind. The OECD can support countries in this, taking into account best practices among countries and in the use of the modern technologies. This tool have evolved even more since the pandemic. It is important that we continue to use these tools and develop the new ones. To ensure the latter, in the digital era, we must observe the digital divide, a gap between those who have access to digital technology and those who do not, and preserve the constitutional principles and access to justice for all. These elements should be part of the digital culture. No one should be left behind. To conclude, the lessons we learned were the importance of the bottom-up approach and the transmission of in-house knowledge and skills among us and the newcomers. Thank you for your kind attention.
Thank you very much, Mr. Widmar. And now I'll pass the floor to Ms. Rachel Rossi, our colleague, Director, Office for Access to Justice, Department of Justice, United States of America. Yes, please.
Thank you. Good morning. Thank you, Deputy Prime Minister Bordans. Thank you, Director Pachowski. Thank you to OECD and to our Latvian hosts for coordinating this important gathering so that together we can explore how to strengthen and improve access to justice. I also want to thank the distinguished colleagues and participants who have joined this convening. You are all important partners in our efforts to fulfill the promise of access to justice for all. Today, I am pleased to join you on behalf of the United States Department of Justice's Office for Access to Justice. You may know that last fall, Attorney General Garland reestablished the Office for Access to Justice at DOJ, and earlier this summer, I was honored to be named the office's director. Our office's mission is to engage in transformative and systemic work to ensure that all communities have access to the promises and protections of our legal systems. We aim to achieve this core mission with 3 pillars of focus. First, access. We work to promote access to courts and legal systems, including through expanded support for legal assistance and counsel. Second, innovation, a topic raised by many of my colleagues today. We work to pursue data-driven, stakeholder-informed, and innovative approaches to judicial process. And third, integrity. We pursue accountability and reform of our legal systems with the goal of creating more holistic and equitable approaches to justice. A through line of our office's work is the pursuit of racial equity, and we're working to embed people-centered stakeholder collaboration and engagement with historically marginalized and underserved populations across all of our work. Through this urgent mission, the Office for Access to Justice leads and collaborates across the United States Justice Department on many of the goals and principles that have framed this morning's discussion. First, I'd like to talk about the prioritization of a collaborative, whole-of-state and whole-of-society approach to justice system transformation, which is core to our office's mandate. Attorney General Garland has directed our office to coordinate and lead a whole-of-government approach to closing access to justice gaps in the areas of criminal defense, civil legal aid, and pro bono services. Our office staffs and directs the White House Legal Aid Interagency Roundtable. This is a collaboration interagency of over 28 federal United States agencies. The Roundtable works to expand access to justice across our government, including by promoting civil legal services as a part of the agency's funding streams. Our office has also led work for the Reentry Coordination Council, which is a collaboration with 6 other federal agencies focused on eliminating barriers faced by individuals who have been impacted by criminal justice systems. Second, the Office for Access to Justice also works to collaborate across the Justice Department and with our external partners to ensure that justice system reforms are evidence-based. Evidence-based approaches are critical to the success of any reform we intend to implement. For this reason, Attorney General Garland has charged our office with exploring methods to conduct research and data collection to better understand access to justice needs and to expand innovation and best practices. As our office grows and develops this work, we are partnering with existing research and data evaluation efforts being conducted within the Justice Department and partnering with external stakeholders to close data and innovation gaps. For example, collecting and analyzing disaggregated data or data broken down by race and other categories is critical to identifying the causes of racial disparities or discrimination that can prevent equal access to justice. The Office for Access to Justice serves as a partner for courts, for legal service providers, and for others who are committed to identifying responsive, effective solutions to legal challenges. And finally, I would like to address the central and critical theme of today's discussion, the role of people-centered justice in rebuilding trust and deepening culture for the rule of law, which is core to the work of our office and the work of our Justice Department. A people-centered approach starts with an acknowledgement that our legal systems have failed too many people. In part, these failures are the result of structural inequities that are deeply embedded in our society and in our legal systems. It then requires consistent collaboration and engagement with those communities and people who have been most impacted by those legal systems. I know many of my colleagues discussed this today. When we trust the experiences of impacted communities, solicit their ideas, and carefully tailor our approaches, we can then form honest and empowering partnerships and invest together in long-lasting solutions. For example, the Office for Access to Justice worked with justice system impacted people, or people who had been in the criminal justice system, and with reentry experts to host a reentry simulation for high-level officials from across the United States government. This simulation allowed government leadership and officials to attempt to better understand the complex hurdles and barriers that are faced by formerly incarcerated people and to help inform policy changes to mitigate against those barriers. This is the kind of transformative work that we intend to lead to bring about meaningful improvements in legal and life outcomes for historically underserved and marginalized communities. In closing, I want to commend the OECD for bringing us together today and for urging us to have these searching, difficult conversations with ourselves and with each other. We look forward to working with you this week and in the future. Thank you.
Thank you, Ms. Rossi. And now I'll pass the floor to Mr. Florian Geyer, Head of Unit Justice Policy and Rule of Law, Directorate General for Justice and Consumers, European Commission. Yes, please.
Yes, thank you, dear Deputy Prime Minister, dear esteemed speakers. I would like to thank the OECD and our Latvian hosts for the invitation to this high-level dialogue. I may be professionally biased, but I find the structure of the OECD framework and good practice principles for people-centered justice particularly appealing, as they underline the importance of the rule of law and fundamental rights as the foundation of the 4 pillars of people-centered justice. As Commission President von der Leyen said during her State of the Union speech last week, It is the Commission's duty and most noble role to protect the rule of law, and she assured that we will keep insisting on judicial independence. 2 years ago, the Commission introduced the European Rule of Law mechanism, a yearly cycle with the annual Rule of Law report at its center. And our distinguished speakers from Romania, from Finland, from the Netherlands, other speakers already referred to it in their interventions this morning. The report examines developments in all 27 EU member states in 4 key areas for the rule of law: justice systems, the anti-corruption framework, media pluralism and media freedom, and other institutional issues linked to checks and balances. It is aimed at promoting the rule of law and at preventing challenges from emerging or deepening. In its 3rd edition, the 2022 Rule of Law report was published on 13 July and included, for the first time, country-specific recommendations to the EU member states. The purpose of these recommendations is to help and support EU member states in their efforts to uphold the rule of law. All member states have received recommendations, and while the report notes that challenges exist with varying levels of severity, we have also seen positive developments that support and contribute towards a people-centered approach. In this context, the recently published 2022 OECD report on building trust to reinforce democracy underlines how perceived judicial independence is positively correlated with public trust in courts and the legal system. And I can fully subscribe to that finding. And in our annual report, annual rule of law report, we also specifically look at the perception of judicial independence. And so when it comes to our findings and recommendations, we encourage the EU member states to engage with these and discuss them at national level. We want to support and foster a culture of rule of law on the ground. And I can report that in yesterday's discussion in the General Affairs Council, the ministerial discussion, where the rule of law report was discussed, it was a very positive, a very constructive discussion among the ministers, which is a very welcome sign of the engagement on the rule of law report. But people-centered justice needs more than just the rule of law foundations. It needs reliable, evidence-based data, which is an important pillar of people-centered justice, as many of you have raised this today. Since 2013, the Commission has been monitoring justice systems in the EU member states with the annual Justice Scoreboard. Again, our speakers from Malta, Romania, the Netherlands have referred to the scoreboard, and we are very happy to have reached the 10th edition this year of the scoreboard. Prime Minister, you mentioned the 20th anniversary of CEPEJ. We are very happy to have the 10th anniversary of the scoreboard, and the cooperation between CEPEJ and the Commission in the development of the scoreboard is a very strong and positive one, and we are very grateful for this cooperation. The Justice Scoreboard provides objective, high-quality comparative data on the efficiency, the quality, and the independence of the justice system in the EU member states. And for example, the 2022 scoreboard looks at issues like court fees, legal fees, accessibility of legal aid across the 27 member states. It presents specific arrangements for access to justice for persons with disabilities and for children. We also have data on how the use of information and communication technologies make the national systems more accessible. And we think it is a very useful contribution also for the debates, just as you are having today, to have this from a horizontal perspective for all the 27 member states. Of course, you are much wider than just the EU. The Justice Scoreboard data feeds not only into the rule of law report, but also the country-specific assessment carried out within the European semester, the economic coordination between the EU member states, as well as in the evaluation of the member states' resilience and recovery plans following the pandemic. And also a number of speakers have referred to this, because very concrete justice reforms on all aspects of efficiency, quality, and independence of justice are fostered through the mechanism of the recovery and resilience plans of the member states. To conclude, I would like to welcome the ongoing work to advance people-centered justice, possibly via an OECD recommendation, which, as I understand, would be the first such OECD recommendation in the area of justice. And we will continue from our side to follow this work with the greatest interest. And I would like to thank everyone for the attention, and I wish a good conference. Thank you so much.
Thank you very much. So, and we almost have finished our roundtable, and those discussions, I think there will be long time to review and rethink. But before that, I would like to give floor to our high-level OECD representative, Ms. Elsa Pilechovsky. How would you reflect on those discussions briefly and give us your overview? Thank you.
Thank you very much, Deputy Prime Minister. And of course, it was a fascinating discussion, and I think we've all learned a lot from different countries' practices and all these commitments to improve access to justice. So that was, for me, a fascinating learning. And whether, it's about digitalization, whether it's about trained professionals, legal literacy, using plain language, facilitating access, some focus on anti-corruption in some countries, working with associations. I think there are so many examples that we've heard today that it's absolutely great. Maybe some key takeaways for me. First, I think there's some agreement in the room that there's room for improving trust in the justice system through access to justice. And in this regard, you also emphasize, and that might be a little bit self-serving, but the importance of international cooperation and collaboration in this regard, and also learning from each other, as usual. Second, how much people-centered access to justice is fundamental to the sense of fairness in society, and how this delivers broader outcomes, whether they are economic outcomes, whether they are democratic outcomes, or even economic welfare outcomes. Third, I would say the delivery of people-centered justice services enhanced by digital transformation, obviously, improving monitoring and performance measurement through integrity measures, skills and capacity building are all priority areas of the OECD and of yourselves. And we will need to continue helping you on that. And also some of you mentioned the need to pay specific attention to make access to justice to all without leaving some minorities behind, whether it is ethnic, cultural groups, youth, elderly, or other groups. And I think that will be very important. Just two things to mention for us. The OECD recommendation has been mentioned. For those who are not fully familiar with OECD processes, the recommendation is a legal instrument of the OECD, not legally binding, but a high political commitment that countries have to abide with and are monitored against. So this recommendation is in process. It has been discussed in the Public Governance Committee already, and it will go through a process of public consultation, and you're very much invited also to take it, to comment and to get engaged in that work. We will be also doing additional analytical work to support countries in identifying core pillars to enable your justice systems to respond to different priorities, including on digital data, skills transformation. And also we have developed practical tools to collect data, including on the legal needs of children and businesses. And I think that will be very important in the future. Finally, I mentioned the ministerial meeting that is taking place on the 18th of November. We have, prior to that, a global forum on the 17th of November, which is a more open forum, open to other members, open to civil society. And you all, and obviously governments will be present, but you're all absolutely invited to come to this forum that will look in depth at trust in public institutions. With this, Deputy Prime Minister, I hope I did some justice to this very rich discussion.
Thank you very much. Yeah, indeed, from my side also, I would like to, first of all, thank you, each of you for your contribution to this really important issues and discussions. And what is mostly important, I think, that I heard that each of you spoke and expressed your personal experience, personal knowledge from your practical work and life, and also from your practical looking on our common values. And the common values are all our democracy and rule of law. I noticed that very much the issues and challenges are all the same all around our countries and our world. Also, we are facing now similar challenges politically, economically, and also, of course, people are the same, and reaction and demands are the same, and therefore it is very important to share our experience and our thoughts. And number of solutions oriented to practical approaches, what we noticed are, and I could mention some of them, it is in-depth usage of data, data-oriented justice, justice service built on the data approaches. And that is new digital era privilege to relatively easy way to collect the data. Of course, there are challenges use the data in proper manner to observe all human rights, but still we are collecting and we are data and we are using technologies for democracy and for rule of law, and not for personal interest. And this is our possibility and our really possibility that gives us this progress and mechanism to track progress in our daily work. And this is also was mentioned necessity of the establishment of KPIs to measure access to justice. You know, this is also very important, I think, to reach our plans and to create plans if you can measure, and further implementation of ADR and digital solution to reduce court fees. That's generally a general approach that most of our countries are using and then understanding better and better. Enhanced cooperation between legal and non-legal services, development of joint intersectoral projects, interagency cooperation, and then analysis of court proceedings from the perspective of the actors involved, which means user centricity. And then the continuous monitoring of trust, also interests of young people, dialogue with civil society. And then, at least in Latvia, from our perspective, can say we're really monitoring this trust of different public institutions and not public institutions, and that gives us also this measurement. And then the importance of capacity building for legal professionals. And I also heard the necessity of the importance of international debate. I fully share, and I'm sure that our dialogue, this joining legal professionals, is very important and to be continued in different levels. So we also are thinking here in Latvia and Riga how to be in a collective in our whole society and get best and better knowledge and know-hows and that we can reach in the way that we all cooperate. We all cooperate internationally and in our organizations and regionally, which is very important. And some of you mentioned that to reach this access to justice is important to acknowledge importance of culture and to do it like this is not very original anymore, but this expression that think globally but act locally. So, and this would be my short conclusion. You will have still more to work, but in the meantime, I invite you to attend our photo session, and then to have some also break. Thank you very much. Thank you for this roundtable, and so we will meet, as I understand, somewhere outside to this hall. Am I right?
Yes, actually, we meet for the family photo on the way to the first floor on the stairs. So thank you very much. Thank you.
So, dear colleagues, let us resume our work and announce the first session of the Roundtable dedicated to the justice, inclusive growth and business development. And I would like directly to provide the floor to the moderator of this session, Professor Felix Stefek from the Cambridge University. So, Felix, the floor is yours.
Thank you very much, Anna. It's a great pleasure being here today and opening the panel on justice, inclusive growth, and business development. My name is Felix Stefek. I'm an associate professor at the Faculty of Law of the University of Cambridge, where I also serve as co-director of the Center for Corporate and Commercial Law. This session, as you know, will explore the connection between responsive and effective justice systems, sound economies, and business development. It will review the role of justice systems and enforcement for promoting vibrant competition, innovation, a facilitating investment climate, and inclusive economies. In addition, this session will explore the principles and practices that govern justice services, which are responsive to business needs and sound competition. The background of this panel is formed by the forthcoming OECD working paper on supporting business through better access to justice. It has a particular focus on SMEs and entrepreneurship. The working paper raises the issue whether we need to question the common approach to treat all businesses the same in dispute resolution. In particular, micro and small business often show behavior in dispute resolution that resembles that of consumers. They have little resources for professional advice, and so there's often no active participation in the justice system. The result is no effective access to justice. This is concerning, as across the OECD, SMEs account for 99% of businesses and between 50 and 60% of value added. Almost one person out of three is employed in a micro firm with less than 10 employees, and 2 out of 3 in an SME. Against this background, this panel will also aim to share country practices and experiences in improving user centricity of justice pathways from a business perspective. As you can see in the session notes, we will explore 3 things in particular. First, links between justice, the rule of law, and growth. What is the latest evidence on the links between justice systems, the rule of law, and inclusive growth? Second, investment climate and competition. In what ways can justice systems promote a positive investment climate? How can justice systems and the rule of law support sound competition? What mechanisms and practices need to be put in place? And third, user experiences and good practices. What are the experiences of businesses in accessing justice? What are good principles and practices to improve the responsiveness of justice systems to the needs of businesses? What are examples of user-oriented pathways, and what works for responding to legal and justice needs of micro and small businesses? We have the great privilege of an impressive panel representing diverse perspectives on justice, inclusive growth, and business development. They bring to us the latest research as well as valuable experiences in managing justice institutions. I will introduce them as it is their turn to speak. We'll first have 2 panelists present in person, followed by 3 panelists speaking remote. After the panelists have contributed their views, there will be time for a discussion, taking questions from the floor. So please, do note your questions as they arise, as they will be very welcome in the discussion. I'm now delighted to introduce the first speaker. It is Paul Prettitori. He is a senior specialist at the World Bank, and he will report in particular on the World Bank's work on the impact of access to justice on inclusive growth. Paul, please.
Thank you very much. Okay, first problem
dealt with. Thank you. It's very nice to be here, and I just want to start off by adding compliments to OECD. And as someone who's been involved in the access to justice work for, I think, quite a few years now, I really appreciate the fact that OECD has maximized their convening power and been able to keep this group together and all the governments that support it. And without this happening, I don't think we've been making anywhere near the progress on these fronts that we have. So just a big thank you and congratulations to OECD. And I am from the World Bank, but I'm a lawyer. I'm not an economist. So Alejandro Ponce, who was supposed to give the first presentation, is an economist, and I like presenting with him because he can explain the economics parts of these things much better than I can. But I work with economists all day, and a lot of the work we do around access to justice deals with economic principles like growth and inclusive growth. But for me in the bank, the issue has always been around how we use access to justice as a tool for inclusive growth. And then where do SMEs fit in as part of this? And at least from the bank perspective, when we're talking about inclusive growth, we're looking at primarily equality of opportunity. So does everyone have a somewhat equal opportunity to access markets, to access resources? And is there a fair regulatory environment that governs all of these economic activities? And for growth to be sustainable, it needs to be broad and it needs to be inclusive. But what we know about inclusion is there's a lot of different dimensions of inclusion, and it's not always a binary, black or white, rich or poor. People have very many different dimensions that impact their inclusion or exclusion. So when you think about things like identity or wealth or disability or gender or language spoken or ethnicity or education levels, these all impact people's ability to access opportunities on a somewhat fair basis. And when we're talking about inclusive growth, we need to make sure that we're addressing all of these different dimensions that would drive exclusion in the first place, but trying to use this as a way to promote inclusion. And from my experience in lower and middle income countries, SMEs are a lot like people. They also have different dimensions of vulnerability that promote either inclusion or exclusion. You may have, in some cases, a small tech startup with 3 or 4 people that is well-financed and well-educated is very different from a woman who's setting up a small business to sell food on the streets. They are going to have very different obstacles when it comes to accessing opportunities, and those need to be taken into account when we're designing legal services. So, access to justice for SMEs is important in and of itself because access to justice is important for everything, not just SMEs. It's such an important pillar of good governance. But the question is, how do we really use this as a tool to promote SMEs in a more positive light? So the SMEs in countries often reflect the disparities in opportunities. So for example, in countries where women's labor force participation, at least formal labor force participation, is low for social reasons or education reasons, women may be more often forced into small and medium enterprises. Ethnic minorities, linguistic minorities, people with disabilities, anyone that has problems accessing regular opportunities may more often find themselves being forced into small or medium enterprises as really the only economic opportunity they can access. So quite often, small and medium enterprises are run by women, they're run by lower income people, but they're also incredibly important in developing countries with the economic role, especially around employment. Felix already mentioned a lot of statistics about the importance of SMEs for growth, but from World Bank research, the proportion of employment that's generated by small and medium enterprises, particularly in developing countries, is very high. And, despite all the debates internally about what is good and not good for poverty, I think one of the constants is that employment is one of the best ways out of poverty. So small and medium enterprises in developing countries play this very critical role, but they don't always get the resources or the opportunities that larger enterprises get. Small and medium enterprises might look very different in low and middle income countries than they do in high income countries because of all of these different levels of exclusion. And also small and medium enterprises, I mean, there's a huge gap between small and medium. So even just looking at, you know, the opportunities and obstacles that each one of them face for different reasons is important in and of itself. And then even the differences, you know, within small enterprises. Based a little bit more on the somewhat limited experience we've had in the bank on this is primarily through the lens of legal aid. So a lot of the support we've given in the realm of access to justice, one of those streams has been funding legal aid, whether it's state-run legal aid or legal aid by civil society organizations. And it's actually a funny story because we once had a convening of civil society organizations from the Middle East and North Africa at the World Bank, and we were talking about different models of service delivery and sustainability and legal needs and gaps and what the main roles were. And a colleague from the bank who was invited to attend came and started talking about small and medium enterprises, and I just kind of rolled my eyes and thought, why are you bringing this up? This is not really important. We're talking about access to justice and vulnerability, and all of the legal aid organizations started saying, yeah, we get people from small and medium enterprises coming all the time and asking for assistance because they can't afford lawyers and they don't understand the structures, and a lot of it is informal. So, I mean, I was very pleasantly surprised to find that, well, not pleasantly surprised that it's a problem, but pleasantly surprised that it could be somewhat of a solution. But what we found were kind of the biggest needs and where legal aid could play a role proactively with small and medium enterprises was compliance. So especially in middle and low income countries, compliance with regulations, people might not be aware of what the regulations aren't clear, it's not always clear who the regulations to apply to if you're a small enterprise. So just proactively educating people who run or are employed in small and medium enterprises about how you comply with local regulations on tax. Another really big issue was access to Social Security and pensions. They didn't know how they could enroll their staff in Social Security and pension schemes so that when they retired, they would have access to all of these things. Addressing informality, how do you bring your business from the formal, from the informal into the formal? And another very interesting thing we found more on the entrepreneur side was that in countries where the rule of law was less strong, there was a disincentive from medium enterprises to try to grow into large enterprises because of corruption. And if you're a medium enterprise, you can stay under the radar. You make enough money, no one's going to bother you. You become a bit bigger, you start generating more revenues. The government is interested, financial elites are interested, and all of a sudden people want a part of this. And if you can't defend against this, it negatively impacts growth. And then finally, I read in the OECD report, which is really a great report on SMEs, and it's great to get this dialogue moving. The survey on the business legal needs that they did in Latvia and access to the Latvian enterprise registry and all the obstacles, and it would be really interesting to be able to break down that data and that information on different types of small and medium enterprises and see how these obstacles face them differently. Because I think how we've moved from the broader access to justice to also access to justice for vulnerable and other people, we can do the same for SMEs. They're not a monolith, like people aren't a monolith, but it's really great that OECD is starting this work, and hopefully we can move it forward. Thank you.
Thank you very much, Paul. And it's now a great pleasure to introduce Maurice Wajnowskis. He is a senior partner in Eu Justice, speaking here in his role as a member of the Foreign Investors Council in Latvia. Maurice, the floor is yours.
Thank you very much. Right, yes, I'm indeed Maurice Wajnowskis, and I here represent the voice of the business. So, yes, I am part of Foreign Investors Council, and I lead a court efficiency work group there, We cooperate with the government already for more than 10 years. It's basically a mutual investment of thousands and thousands of hours to get the court system better. And there has been really great progress, and I mean it. So there has been insolvency reform, going from really wild circumstances to organized insolvency procedures. There has been, for instance, reform related to arbitration courts. Guess how many arbitration courts did Latvia have, our big country? More than 300, can you imagine? So clearly a reform was needed in that respect. And also many improvements in terms of procedural efficiency, which bring quality and speed, which is extremely important for the businesses. Businesses big and businesses small. I mean, we do not differentiate because, you know, a person, there isn't always a person in the courtroom. And when businesses invest in a country or set up businesses, they look not only to the market, not only to the tax system, not only to the access to labor, but top three on their investment checks the boxes is security and protection of their investment as provided by the functioning justice. So that is extremely important in their decision-making matrix. So I have put 7 points for my 7 minutes here on the slides. I already touched upon the efficiency and the progress achieved. But I would like to highlight a few other items which have been very important and remain very important for Latvia. First, I would like to highlight the specialization of the court system. And many thanks to OECD for your support for setting up economical affairs court in Latvia. This is a fresh reform which is already 1.5 years approximately, a little bit less in operation. And this is a result of the leadership of the current Minister of Justice that this reform was implemented, and the results are there. Businesses big and businesses small see the change. And so Latvia and our great neighbors, Lithuania and Estonia, were always a little bit in some competition. Now, Estonia said that they will make their court system to review a civil case within 100 days in the first instance. Now, Economical Matters Court in Latvia reviews a case in approximately 80 days in the first instance. That is a clear achievement. But this is not only the speed. The speed is not the main denominator. It is basically the quality that the businesses, big and small, are looking for. And based on the feedback we have got, the rulings, not only of Economical Matters Court, but generally in the court system, they tend to become clearer, they tend to become more understandable. Because what the businesses basically say, so they say, we need to understand in order to trust, right? And we need, when we trust, then it brings security, then it brings predictability, then it brings protection. So this is a clear voice, and therefore we very much welcome even further specialization of Latvian court system. No, our country is not too big for specialized. Actually, it is an asset that the system gets more and more specialized. I already touched upon the clarity. We very much welcome this discussion, including the leadership of the Supreme Court, but also all levels of the courts, that basically judges are working together and discussing something about a formula of the judgment, what we mean. So how to convey the message to the businesses in as clear way as possible. because, you know, lawyers like these long sentences, and young students which also come to our law firm, I say, well, that is a sentence, half a page, and you start reading it and you get to the end of it and you have no clue what they meant, right? So basically, and every lawyer, you know, about, you know, structure is key. And we know that the courts are basically working, and this is bringing more access to justice, more understandability. This is very, very important and to be continued. Obviously, access through technology. Very important is this constant advancement of digitalization, which ensures more and more actual efficient access to the court processes, to the system. Furthermore, I think our state also should continue pursue this, let's say, fair use of artificial intelligence, not to replace the judges, right, but to help the judges to get better and more structured access to basically theses and jurisprudence and case law examples which they need in order to resolve this particular case on their table. So that's, I would say, that's a fair use of artificial intelligence. Also, we're talking about small cases that AI can help, but AI will never ever replace a human person who needs to understand what the case is about and all the relevant details and apply the facts of the case to the law and then get the ruling. AI will never, I think, do that fully. So then, of course, case law. It's so important, again, predictability means that you can rely that your case will be resolved in a similar fashion, right? So it so much relates to predictability, and our Supreme Court doing a great job from historical, because Latvian historical Senate, it was pre-war Senate, and our courts should apply also those historical interpretations because they are good and they also ensure the continuity of Latvian state. Yes, cooperation is extremely important, like public and private sector dialogue, institutional cooperation among the judges, and also I know that Supreme Court justices and other, you are just going around the schools and asking children, you know, showing this direct link with children. The children are our next clients and businessmen, so that they should get as early as possible. And to finalize it, there are new areas, new challenges for our legal system. Now, for instance, the ESG, all the greenwashing. You know, what is the fiduciary duty in sustainable finance? All these are new topics, and the system should continue learning together with the businesses, yes, and in order to apply the law in a professional manner in those, so that our businesses are not scared of the European Green Deal and how the businesses actually apply it in practice. Thank you. This concludes my initial remarks, and later happy to reflect on any questions.
Thank you very much, Maris. We are now moving on to our remote speakers, and there are three of them. The first is Felix Braun. He's the director of the General Conciliation Body in Germany, and he will speak on ways to make dispute resolution more friendly for businesses. Felix, I hope you are there remote, and we are looking forward to hearing from you. We can see you, but we do not have an audio signal.
Oh, that is quite bizarre.
Yes, now it's there. Thank you. It's coming up. Thank you. We can now hear you.
Perfect, yeah. So I was just thanking you for introducing me, Felix, and to OECD to have this dialogue today, because of course I'm also convinced that access to justice is a very important thing also for businesses. And from my own experience, I can tell you that I totally share the opinion that small and medium-sized enterprises are also to some extent vulnerable, and the legal situation is rather complicated for them. So as Felix said, my perspective concentrates today on how mechanisms to make dispute resolution more friendly to businesses. And maybe we can have a look on my slides, because first of all, I will tell you about some challenges. Thank you. What I do at the Universalschlichtungsstelle des Bundes, in fact, I'm also a lawyer, is to enable both parties, businesses and consumers, to resolve their disputes out of court by way of conciliation. So when I started in 2009 with my first steps into conciliation, I rather naively thought that every business should be delighted about this idea, because it's much more easy to go to a conciliation process, especially for SMEs, than to go to court. Of course, in Germany, we have a rather efficient court system, but again, SMEs, like consumers, are afraid of formalisms. They have to travel for disputes with a low sum in dispute. So I guess an online-driven conciliation would be much more interesting for them. But I can tell you it is rather challenging to convince people that our dispute resolution is a better way for them. And this is quite a paradox, because they all agree that access to justice is too difficult to them. But what I find surprising is that the existence of the classic system with lawyers, attorneys, and courts is so much in the head of everybody that it's hard for them to move on to another system. So what can we do about that? I think it's very important to identify in the first place the needs of the companies, the SMEs, and by that create an attractive pathway specially designed for their needs. But of course, not only for their needs, there's also an abstract level of the importance of the law, as we have seen, because as it was said before, when you have trust in a legal system that you find in a state, you will invest there. So it's important also to have compliance. That is why also I like very much the idea of compliance that we do. It always goes along with a very intensive legal assessment of the case, very transparent for both sides. And we are nominated by our Federal Office of Justice, so we are not just mediators or conciliators in some way, but also our neutrality and our independence is checked before that we can act. I think this is key for if you have a system where two parties come together to solve their case, they have to have absolute trust in the neutrality of the third part. And this goes along with competence. Competence and expertise, not only maybe in law, but also in the way of dealing with a case. Because when you look at my slide on opportunities, when it comes to finding other ways of resolving a dispute, you really can think out of the box. And maybe for some cases, it is more appropriate to have rather emotional, empathetic debate of the case to bring parties together, especially if they have a long-term relationship. As it was said before, you have always humans behind the case, and therefore emotions can play a role. But parties should clearly know what kind of dispute resolution procedure they're in. Is it more a mediation process where emotions and empathy plays a huge role? Or are they, for this specific case, interested in having a legal opinion? That would be rather what I do with my conciliation board. Or do they really want to go to court, do it the classic way, because they need security for the future, so they need a judge and they need a judgment in order to comply for the future with it. So you see, there are different ways of accessing justice. That's why I included on my slide the picture of a delta of a river, and it's symbolical for there are many ways to access justice, but you need exactly to know why you navigate on which river. Do you prefer the classic branch or do you want the new branch? And you have to know what this stands for. And therefore, what is important again is to convince those who will use this system about it. And how do you do that? You have directly to involve not only governments, but also associations representing the SMEs or businesses involved, or consumer association involved if it concerns B2C cases. And they have to do the publicity for their people to go to such a system. And as you can see on the right side, there's another picture that I included in my slide. It's a kind of alternative dispute resolution body from the 17th century. It's in Italy, in Bolzano. And this is a city where there was a lot of trade already at that time, but cross-border trade. Traders from all countries came there to sell their stuff, and they moved on. So when a dispute arose, it had to be solved within maximum 3 days. And they also played with different notions, like you could have a judgment, but you also go through a mediation process. Of course, today we have a lot of possibilities with digitalization. That's a big chance, I guess, because this also can ease up the access to this different systems. So you can have a legal tech tool to guide you through this, a signposting office, because again, the SMEs will not exactly know what conciliation is, mediation is, and court system is. You have to tell them what it is, and in simple words, and then they will have to find to the correct body, especially if there are, for instance, like before in Latvia, 300s of them, it's not so easy to find. So the access has to be simple. And why not add to such a pilot or signposting tool another self-help tool, because legal situation is complex. And from my experience, many SMEs, they want to comply with the law. It's only too difficult sometimes. So even before a dispute arises, you can use such a platform for SMEs to familiarize with this platform, to find useful information there that helps them to solve their cases themselves, to be compliant. But if this doesn't work, it's also an access to the different ways of finding a solution to a problem. Yeah, in brief, that is all my experiences I wanted to share today. Thank you.
Thank you very much, Felix. And I'm now very pleased to hand over the floor to Despina Pachno. She's a policy analyst and competition expert in the Directorate for Financial and Enterprise Affairs of the OECD. Despina, I'm particularly pleased to have you on the panel today because it is not very often that competition law experts and competition experts are actually speaking on access to justice. However, I do think that is really relevant. We're looking forward to hearing on the role of sound justice and enforcement mechanisms for promoting competition from you. Despina, the floor is yours.
Yes, thank you. Thanks, Felix. I hope you can all hear me. Good morning to everyone. It's a shame I couldn't be there in Latvia. So yes, rule of law and access to justice from the point of view of competition law. So we've looked quite extensively at that because access to justice as a mechanism to appeal against competition decisions is a huge power in the hands of businesses that want to make sure that their rights of defense and their rights to an impartial, independent, and fair process have been respected. Let me share my slides. After years of work, the OECD last year adopted, I hope you can see it now, a recommendation on transparency and procedural fairness in competition law enforcement, which is basically a long name of saying due process, fair process in competition law enforcement. This is a recommendation that covers all aspects of decision-making in competition. So anything that has to do with rules, up to the opening of cases, including the investigation of cases, the decision-making, the party's right of defense, and finally, access to justice. You will see there on the screen that there are 7 principles in this recommendation for competition law enforcement, and the 7th is access to impartial judicial review. So this, without going through the recommendation in the interest of time, just to say that the gist of it is that if you want to have rule of law in a particular area of law enforcement, that is competition law, but which can be translated and applied in other areas of law enforcement, so the same principles you could argue would apply, for example, to any white-collar crime or like combating bribery, combating money laundering, you need, first of all, good rules, right? A good legal framework that is, and it has been touched upon by speakers before me, transparent and predictable. You don't make rules as you go. As a business, whether an SME or a bigger business, you need to know what rules apply to you at the time when you're taking a business decision or an investment decision. This is particularly important for businesses that are investing overseas, that need to know what law will apply to them in that other territory. Then, broadly speaking, again, you need independent, impartial institutions that apply the law. In the case of competition authorities, these agencies are independent from central government, but in whatever area of law, you need the subject of a case, of an investigation, in whatever area, needs to know that it will be dealt with independently, impartially from the point of view of its ownership, from the point of view of nationality, and professionally. So that it has to deal with public sector officials that apply sound legal and economic principles. And then the third big bulk, and more closer to what we're discussing today, is rights of defense, representation by lawyers throughout an investigation, and access to an impartial court. The major reason and the major link to investment, and something that we have found consulting with the private sector for our work, because we talk a lot to the International Bar Association, we consult with business at the OECD, is that broadly speaking, a business would not take the decision to invest overseas unless they were satisfied that they will be dealt with impartially, right, professionally, and they have access to independent court review, because they want to make sure that if a decision against them is unfair, they have the means to challenge it. And my second big point is, why are we working on it? It's a case that the OECD does not always work on the rights of the parties. We have a long history, and certainly in the competition division where I work, of looking at the organization of the public sector to enforce competition law, but not so much at the needs of the private sector when faced with the enforcement of such law. The reason we started working on it, and it's been like 10 years now, but very intensively in the last 4 years, is that as business becomes more globalized, it becomes international and crosses borders, there is push by the private sector to make sure that when a company faces different systems when you have, let's say, a transnational merger, a company acquires another company in another territory. In order to go across the border, the investing company needs to have clarity on its rights and obligations, because that's the basis of its own investment decision. And also there is an acknowledgement also by the public sector, our delegates, our representatives that are competition authorities, that indeed, independently of the culture and history of each country, which dictate the structure of law enforcement, right? Not every country structures enforcement in the same way. Not every country structures courts in the same way, and this will be my final point. There are, nevertheless, minimum principles of universal application on due process and access to court. So there is a consensus that you need a minimum. You need a minimum because parties need it in order to feel secure. Competition authorities need it in order to make sure that they investigate properly, that they have heard all the arguments, that when they reach a decision, it's fair, it's comprehensive, and it's strong enough to be able to withstand the judicial challenge. So it's important as an independent authority to have heard the parties. So when you have to defend your own decision before a court of justice, you have to make sure and make the judge understand that you have taken all arguments into consideration. And the only way of doing that is through keeping a transparent and fair process. And you also need it for the something that we don't maybe often mention, the general citizenry. You need it for all the citizens to have respect and trust in the rule of law. So even those citizens that are not subject to investigations, that do not use the court system or are not challenged before the courts, they need to know that no matter what, the law is observed. And the persons and institutions that follow the law are bound by a fair process. Basically, having a fair system and having access to justice creates respect and enforces the legitimacy of law enforcement, whereas a defective law enforcement breeds disrespect in the law at large. My final point, in view of time, but I will be very happy to take questions, is that in particular when we discuss in this recommendation that was adopted last year, court review, and we said that we wanted to recommend in this soft law instrument that we have at the OECD to countries to make sure that the court review is impartial, we particularly recommend that courts are timely, and Maris has mentioned something about timeliness just before me, and they review both facts and legal arguments. So basically the recommendation from the OECD is that when you look at enforcement decisions coming from the public sector and you are the private sector that challenge them, what the judge should look at is not just whether the law has been applied correctly, but also whether the assessment of the facts has been right. Now you have, in our countries, you have differences. There are countries that are focused on legality review, but even these countries allow some review of the merits, of the real grounds for reaching a competition decision. You have other countries that allow a reassessment of the facts, meaning that the judge will reassess the case from scratch. In our experience in working with countries, we have seen the value of specialized competition courts because obviously they have expertise that the general courts don't have. At the same time, it's important to note that specialized court, while quite competent on their topic, they are less familiar with the application of general legal principles. So, you know, there are upsides and downsides in the specialization of the courts. But what we are sure is the case is that competition law training and generally specialized training for judges is useful. And in the absence of in-house expertise, there is value of calling in external experts and also calling it as a third party, in the case of competition law enforcement, the competition authority to submit briefs called amicus curiae, but to submit briefs to explain why they have reached a particular decision, even if the case, the court case, is not between the competition authority and a party. And with this, I stop, and I will take questions for the later if there is time. Thank you very much, Felix.
Thank you very much, Despina. It was a great pleasure having you in the panel. And I'm now delighted to introduce our last speaker. It is Alejandro Ponce, Chief Research Officer of the World Justice Project. He made great efforts in being here in person. Unfortunately, trains and planes, rather, got in the way of that. So he's speaking remote, and he'll present on the latest research on the links between the rule of law, access to justice, and growth. Alejandro, we would have loved to have you here in person, but we are delighted to have you here on the screen, and we can see you already and look forward to your presentation. Thank you.
Thank you very much, Felix. And hello, everyone. I'm sorry that I cannot be there. As Felix mentioned, my flight from Washington, D.C. to Brussels was canceled after 8 hours at the airport. And there was no possible way for me to get there, so I'm sorry. But I'm glad that I'm speaking to you virtually. And as Felix mentioned, just what I'm going to talk about is essentially just trying to look at the links between rule of law, access to justice, and inclusive development, just the latest research, and just really just abstract a little bit from some of the more detailed discussions that we have had. First to have these links, and then to show you a little bit of the work that we have done just on how to think about this. So first off, just what is the rule of law and how do we link it to access to justice and development? So we understand the rule of law as a principle, equilibrium, ideal in which everyone is accountable to laws, and the laws just are publicly promulgated, equally enforced, independently adjudicated, are consistent with human rights, and so on. So essentially, the rule of law, what it's doing is preventing the arbitrary use of power so that everyone enjoys their rights. So, and essentially there is in every country, in every society, just obviously actors and processes that help with this. And essentially they do it through two different mechanisms. So one is that whenever I have a problem, just whenever someone violates a right, that I have a recourse, that I can go to the legal system, I can go to the justice system and really try to solve my problem. And that's one of the mechanisms just by which the rule of law operates. And the other one is obviously that just to provide an environment in which problems are prevented from happening in the first place. And all what we have been talking about essentially are about these two broad mechanisms. On one hand is making the justice system more accessible, more efficient, improving the quality of the decisions. And on the other hand is really just providing an environment so that problems are less frequent, whether these problems are crime, corruption, dispute with another party, contract enforcement, etc., but really providing an environment in which this doesn't happen and is easy to resolve when this happens. And let me just share my screen just for a moment. And once we understand this, there are links, obviously just from the rule of law to inclusive development. And we can think about two different mechanisms in which this can operate. So one is what we call a direct mechanism. So what that happens is essentially when a problem arises, right? So that problem is going to have costs over the parties, right? I mean, and this can be just the cost of legal problems, the cost of crime, corruption, and this can be manifested in many different ways. This can be economic costs, but this can also be relationship costs. This can be health costs. I mean, just there are a lot of different ways of thinking about this, that when this happens, it imposes costs and just the parties have to spend resources that otherwise could be used for something else. And essentially just all the different policies directed to improve the legal certainty, the enabling environment. Essentially, the mechanism by which they are influencing the inclusive development is by reducing these costs, because the problems do not happen in the first place if we have an enabling environment or legal certainty. The second one is the cost themselves of legal processes. And we know that this could be related to having access to the mechanism, whether this could be access to assistance, or the process itself, just having access to a dispute resolution mechanism. And the other one is the indirect mechanisms. We know that just because sometimes the processes can be costly, this can affect investment decisions in the first place. So just sometimes just firms may not necessarily want to invest because of that. So just there is some evidence on the direct mechanisms for individuals, and that's what I'm going to show to you, because we also, and this is something that we have been talking in the previous roundtables, there is very little evidence on the cost of legal problems for businesses. And the paper of the OECD and the Legal Needs Survey that Latvia produces very interesting examples of where to go in this direction. Just on starting to provide evidence. And on the indirect mechanism, there is some evidence, some research on this. There's some research that improving efficiency may improve investment. There are some examples in India, or entrepreneurship in Pakistan, or that improving access improves the business environment in Brazil and in Kenya. So what is new? We have been talking about this actually for a long time. What is new, I think, is the people-centered perspective. I think just putting really just the people at the center of these problems is really what it's at the core. So as I mentioned before, so on the direct mechanisms, we have made some progress on the cost for individuals. You may remember a couple of years ago, 3 years ago, just that the OECD and the World Justice produced a paper on the business case for access to justice, analyzing data that we collected at the time in 44 countries on legal needs surveys and essentially the processes that people have. So while we have updated that paper during the last months to include first more countries, to add more questions. So we added more questions to try to refine a little bit the costs, to just also refine the calculations. And I'm going to present very quickly some of the results. Essentially, just we can have the economic cost. We divide the economic cost in 3 parts: the income cost, which is essentially the cost that people, the income that people lose when they have problems, the health cost, and the resolution cost, which is essentially the cost that people may face when trying to resolve the problem. And what you can see is, as compared to the previous estimation, the estimation that we came up with is much higher. So the previous estimation was about, on average, 0.5%. And this estimation now is almost close to 2% of GDP, the economic cost of access to justice, of the cost of problems in terms of GDP. And this is in part because we have included all problems that people may face. So something that we have done as well is trying to disaggregate these costs by people. So, and this is an example, rather than seeing it as percentage of GDP, is seeing this as the percentage of income just of people. And what you see here is by income quintiles, just with questions that we ask about the income of the people, just the percentage of the costs. And what we see is, just for poor people, for people in the lowest quintile, just the costs are much higher than for people just in the highest quintile. So, which essentially just confirms this idea that we have seen, I mean, that poor people have more problems and face more difficulties. Well, they also face more costs just when facing these problems. So just obviously there is much more research to be done with these, particularly to identify just the cost for people who have different levels of access. And this is something that we're going to be working just to refine this paper. And I'm going to stop here. Thank you.
Thank you very much, Alejandro. That was fascinating, but in particular, trying to estimate the costs of lack of access to justice. We now have around 10 minutes for discussion, and I would be very grateful if you raised your comments or questions. Please just show up your hands, and then do remember to turn on your microphone, and you're very welcome to join the discussion. Is there interest to speak? Yes, please.
Oh, is that working? Thank you for the really interesting presentations. I just had a bit of a general question for the panel on sort of on evidence and data, really. We've got quite a good narrative, haven't we, really, on individual legal needs, all sorts of data, legal needs surveys, quite a large body of evidence on things like the importance of early intervention, consequences of legal problems, etc. It's not perfect, but that big picture is probably reasonably well understood. It feels like we're lacking quite a lot of that on the business side, and that's becoming increasingly important. There's examples of business legal needs surveys, but they're kind of the foundation, aren't they? There's so much more. There's things like, evaluations, data linking, cost-benefit analysis, and I note the interesting stuff that Alejandro just talked about. But it just feels like we're a long way behind on that kind of that weight of evidence. And the question, I suppose, is do people feel like we are at that kind of starting point, putting those basic building blocks together on links between businesses, access to justice, the economy, and the wider issues that we're experiencing now on the fiscal situation, cost of living, etc.? Or are we actively doing things to integrate that kind of data collection and evidence gathering into our access to justice strategies, and specifically our evidence and data strategies? I guess the question is, do people know about things that are happening, and do we think there are ways that we can kind of make that happen better, if not?
Yes, thank you very much for this really important question. I had similar thoughts when I heard Alejandro's presentation and saw the numbers. For example, Alejandro, I also wondered, the difficulty of measuring indirect costs of lack of access to justice. So perhaps, I take this as a call both to the panel. Alejandro, perhaps you'd wish to comment. But in particular, the issue of measuring the costs to businesses as opposed to the costs to vulnerable groups or individuals that are not business entities. But also perhaps to the floor, are there initiatives, projects to work towards a more systematic understanding of the cost of lack of access to justice to businesses? Are there any takers for that? Alejandro, perhaps, or someone else?
Yeah, I can talk a little bit about that. I think I would love to have had a presentation showing just the case for businesses. Unfortunately, there is very little information on this. This is something that we are just starting to understand. And there are very few countries that have conducted this kind of studies, in part because the approach is new. I think that just before, when we were talking about access to justice and businesses, we were immediately thinking about courts. And I think the difference, similar to what we have done just with the legal needs and the people-centered approach, is really looking at the whole journey that businesses are going through and really trying to understand their needs, the demand that they may have for different types of services. And then as a result, there is very little information on this. I know that Latvia has been conducting a study. I know that some countries in Eastern Europe were going to conduct studies with the World Bank. But it's still just an area that needs to develop. In part, is more challenging. There are some parts that are more challenging than non-individuals, then just the data collection is more challenging, needs to, obviously it's more difficult in many cases to identify businesses. There is the situation of who responds the surveys. For example, just you need to have the right person to respond to really being able to identify all the different problems. And in some cases, understanding that some businesses are quite small. Indeed, in one of the surveys, in one of the questions that we asked to the individual legal needs is whether the problems were related to their business for small entrepreneurs. And surprisingly, about 25% of the people responded that the legal need problems that they have are related to their business, mainly self-employed or micro enterprises. So, but still there's a long way to understand where we are to incorporate this data into the design of policy. And this is only to estimate or to try to provide information about first what's happening, then the cost, the direct cost. I think, Felix, to your point on the indirect cost, that's even more difficult because that's about decisions that may happen or may not happen because of just particular situations that we see in the environment or the rule of law environment or the justice environment in the country.
Thank you very much. I mentioned those in particular, the indirect costs, because based on theory, we would expect that these indirect costs of lack of access to justice are very high for, in particular, small businesses, but I think it's very difficult to put a number on them. Are there any other comments or questions? Tatiana, please.
Yes, good afternoon, everyone. Really fantastic to see all of the familiar new faces. Just a quick comment on this point that at the OECD, we are currently working with the Committee on SMEs to actually deepen this work. We agree that we are just at the beginning of this journey, but nonetheless, the journey has started. You have all seen a paper by the OECD prepared in collaboration with the University of Cambridge on understanding the legal needs of SMEs. So if you haven't seen it, I encourage you to read the paper. It provides the elements of a policy framework for access to justice for SMEs, which again can be a starting point to understand what it actually takes for SMEs to access justice, but then also to think about the cost of lack of access. And for the countries that are interested to actually do empirical work in this space, the OECD has developed a legal needs survey module specifically tailored to the needs of businesses. So if you're interested in deepening this work specifically for your country, we stand ready to work with you. Thank you so much.
Thank you very much, Tatiana. So, perhaps, questions or comments could concern, yes, please, there's one. Why access to justice matters for businesses or how it can be achieved? Please.
Thank you. Questions et réflexions.
Oui.
Tout d'abord, merci beaucoup pour les interventions. J'ai trouvé ça vraiment passionnant.
First of all, I would like to express gratitude to everyone who were the speakers, and I found out many interesting things, and sorry for not knowing this, but I never thought that for the companies there might be problems to go to courts. In Belgium, there is no such thing. We're not thinking about maybe legal entities. We're talking about private persons' side on individuals. And now I have a following comment. Usually in courts, these simple things, like there is a principal judge, and then there are consulting judges or justices from the entrepreneurship environment. And these consulting judges, they perform part of the duties on their own. And for example, they survey or gather data. And now I have a question. I have a question whether we have a possibility with such assistant judges to actually satisfy this need for justice? And also one more question is whether the time of the entrepreneurs is the same as time for courts. Like, it takes a lot of time because they have to diligently review the case for the courts. But for the companies, the solution must be found quickly, and they need it right now, right here. And couldn't we promote that the conflicts in entrepreneurship environment would be solved through mediation, through alternative ways?
Litigation and court justice are inherently face inherent difficulties actually to adjust themselves to the needs of businesses and what the importance of alternative dispute resolution could be. Are there any participants or panelists who would like to comment? Perhaps Felix, because I think you, I thought, you know, when I listened to the comment, I thought that perhaps the online dispute resolution you were talking about could be a way forward to bring these two worlds, justice and businesses in particular, perhaps even the courts and their online efforts together. But Felix, I don't want to impose, of course, only if you wish to contribute.
I really would like to react on that, and I totally share this point of view. It's a big opportunity for businesses to have access to alternative dispute resolution mechanisms for various reasons. And you don't need a legal solution for everything. Well, it always has to apply with the law, of course, but you don't have to go in depth. And this is why what just came from the Belgian side, and thank you for that. The importance is that people know what everything stands for. And think back of my map of the river delta. There are many accesses to a solution, but you know, you have to know which way you go, and you know what this means to you. So somebody who goes on mediation, he must know that he will maybe find a solution within short notice, but it's maybe not the best solution if he has 100,000 cases of this per year, and he needs really to have a definite legal point of view on that. So information is key.
Thank you very much. I would very much love to continue this discussion, but there's also another panel waiting to start. So I'm trying to be disciplined. And instead of summarizing, I would just like to thank everyone for their great participation and efforts, Alejandro in particular for really trying. It is much appreciated also for the comments and questions. Of course, the discussion need not end because there's also a coffee break that we could use. But now I'd like to close by thanking the OECD for putting this really important topic on the agenda and giving us tools and briefings to carry this forward. I hope we can stay in communication and touch about this. So thank you very much. Thank you very much also for Latvia to hosting this, and I hand over to the next panel. Thank you.
Thank you. And while we're waiting for Anna to join us, I'd like to maybe invite a short coffee break, 2-3 minutes technical break so that we actually change the panel. Thank you so much.
push.
Oh, that's good. I'll stop on this. If it's possible for everyone to return to your seats, we'll get the next session started. Thank you very much. The best session of the 2 days is about to start, so please take your seats. All right, ladies and gentlemen, thank you very much. We might get started. As I said to you, I promised you it's the best session so far of the 2 days. All right, the session we're going to move on to now is entitled Designing and Implementing People-Centred Justice. There are 3 reasons why this is probably, well, it's a very important session. The first reason is that this actually goes to the heart of what the actual Roundtable is about, that is moving forward with the People-Centred Justice Framework, implementing it, what do we need to do to implement it, and so this session is really central to the core of the Roundtable. The second reason it's important is that it's a bit of an overarching session because, as you'll all be aware, there are sessions over the next 2 days that deal with specific elements, if you like, underneath this implementation agenda, from interagency cooperation, people empowerment, what works, how do we work out what works for, in what circumstance, for what person, and to design services, data and measurement frameworks, and others. So this session is a bit of an overarching session that really sets the scene for those that follow for the next 2 days. So it's important in that regard. And the third reason it's important is that our final speaker is from the health area. And you'll all be aware from the framework that lessons from other sectors were incorporated in the development of the framework and health in particular. And so, and health as in other sectors, but health in particular, I guess, leads the way. They're ahead of where we are, if you like, in the journey of people-centred services. And so we can learn a lot from the health sector. So for these 3 reasons, this is a very important session. We're very fortunate to have actually quite a very experienced and a diverse panel, reflecting perhaps the scope of this session. We've got a couple of representatives giving a country-specific good examples and reference. We have 2 of the leading researchers in sort of legal needs and implementing people-centred services that have been around this area, this sphere of research for quite some time. We have a representative of the Court of Justice of the European Union, and finally, of course, we have that health economics, health policy perspective. So we have a really exciting panel, and I'm sure we'll all learn from it. Time is tight, and so we'll move straight on. And so I'd like to begin by introducing Jean-Paul Janssens, who you've all met already today, the President of the Federal Public Service on Justice in Belgium. Jean-Paul.
Thank you, Geoffrey. Rebonjour à tous. Je voudrais... C'était compliqué de choisir.
Good afternoon, everyone. There is a wide range of issues we have to discuss, so I had to either talk about everything fast or go slower and focus on a specific aspect. I chose the second approach. This is why I will be talking only about 2 specific cases which in Belgium have received a lot of public attention. I will be talking about the victim state. On the one hand, due to family violence or violence against women. When we discuss family violence, and the ministry has established it with statistics, family violence has increased by 15%. It is quite a considerable leap. It is a very specific type of violation, and the Ministry of Justice attempted to take the bull by the horn by introducing amendments to the legislation, improving the judicial system, improving the provision of information, and stepping up victims' protection. The victim of violence has to be at the center of the situation. Since 2013, the royal prosecutor has been empowered with special authority. If the family violence is established, the perpetrator is separated from family for 10 days. It means from his spouse and the children. It means that the perpetrator is forbidden to show up at his home. It was the first step. This was a way of resolving violence in family. It was just the first step, and we needed specific tools to implement any changes. We also use the artificial intelligence in our services, including chatbots, which can analyze whether any violence is repeated if the perpetrator has committed similar acts before, and then this information is forwarded to the judge. This way, the judge can protect the victim better. By the way, the issue of repeated offense is researched at our scientific center. We cooperate in a team, law enforcement, scientists, and the judiciary, in order to be able to reveal repeat offenses better and protect the victims. There's another innovation we introduced this year. The victims receive the so-called alert button, either a smartphone where they can push this button, or a device. Senior citizens often receive if they live alone. So if a button is pressed, the responsible services receive alert immediately. We have distributed over 4,000 smartphones or alert buttons of this type. All of that was introduced to protect victims from family violence and to rescue victims from this unfortunate situation as fast as possible. We also use legal instruments. For example, we have a special section in the Penal Code on sexual violence and sexual abuse. For example, it can also be related to sexual abuse without the consent. So the sexual act has happened without the consent, or sexual behavior has been imposed without the consent, and it is clearly defined in this legal norm. We have a lot of elements. I'm just outlining the most important ones. Next, we reviewed the sexual rights of people of age, and we punish individuals for forcing others to solicit sexual services. However, providing sexual services as such are allowed. The providers of solicitors of sexual service themselves, sex workers, are not punished. And another important aspect, shelters for victims or reception of victims. Since summer, we have a new practice. We send out an informative letter, an information file about the victim to the victim. It means that the victim can get acquainted with all the information about them at our disposal. But that's not all. Give me another minute, please. We encourage judges to undergo a special training in this field. For example, with regard to victims of human smuggling, you maybe noticed I have a badge at my lapel. It is the UN badge which draws your attention to fighting human trafficking. I would like to tell you more. I wanted to tell you more about the law office I told you in the morning session, but I don't have any more time. If you have any questions, ask me later. I believe that the biggest enemy of rule of law is delaying justice. We know that the wheels of justice turn slowly. If we find out that the victim has filed a claim and the final decision will be accepted and will be adopted in 6 or 7 years, what kind of trust can we talk about? This trust can be regained only if the victim receives due process in due time. Thank you.
What your country has been doing with issues of family violence, human trafficking, which are problems in all of our countries, and indeed delaying justice for those victims is a big detractor of trust. So thank you for that contribution. Our second speaker is Johanna Surpa, and Johanna is the Director General for Department of Democracy and Public Law in Finland. Johanna.
Thank you very much, Geoff. And as you mentioned in the beginning, we were asked with Jean-Paul to pick up a few perspectives or national examples in the more general context. And of course, that's not easy to do, but what I propose to do in these 7 minutes is, first of all, to look at how we understand a human rights-based approach and what that would mean in practice. Look at openness, transparency, and stakeholder cooperation. Again, a little bit more in detail than in the morning. And thirdly, look at some examples of strengthening knowledge-based decision-making, and in that context also impact assessments. So the public authorities, of course, are responsible for ensuring that rights are not just words on paper, but instead that they are realized equally in people's day-to-day lives. If you look at the Finnish constitution, or if you look at international law, it's clear that we have an active obligation to promote the realization of rights. The advantage of adopting a human rights-based approach when we talk about developing the justice sector is that it brings you to the level of the individual. And it becomes very clear that when we talk about the public, general public, you are not just talking about the general public, you are talking about individuals who have their individual features and in many cases also special rights connected to their status. So you have to then look at issues like, well, disability that already raises some very concrete issues regarding access to justice in also a very physical sense. you have to look at issues related to language and how can you access justice from that angle. Finland, for instance, is a bilingual country, so we have to safeguard that both the Swedish and Finnish-speaking populations have an equal right to get legal services and access to justice in their respective languages. There's the issue of age, for instance. We've talked about the sort of issue of digitalization being both an advantage from the point of view of gaining access to justice and making it more understandable also for especially some of the younger sectors of the society. On the other hand, possibly also potentially a hinder for some, especially the older generation. You shouldn't be to stereotype, but these are just some of the examples where the human rights aspect will lead you to think about, and therefore you will encounter thoughts about where the problems are. And in Finland, as in many other countries, and we just heard also a little bit from Belgium, there's the cost of proceedings, which is a real problem. A length of proceedings are related and also a real problem. If you are a sort of not maybe very low income, because then you will receive legal aid. You're a medium income person. You have a smallish money-wise claim. It's a real risk to go to court at the moment. So, and especially if you belong to some of the more vulnerable or minority populations, it will be a risk for you to go through the normal proceedings because of the cost risk mainly. So I think we have to be a little bit more creative and look at the situation again from the point of view of the various groups. What we have developed in Finland, for instance, and I think in many other countries as well, is low threshold mechanisms for certain kinds of cases. There's a special tribunal for consumers, another for victims of discrimination on various grounds. So you don't need to go to normal court to be able to establish that you are a victim of discrimination, which again is important. It's cost-free, it's faster, and I think this kind of models, also including the specialized ombudsmen, where we have many in the area of equality, old age, children, etc., is something that we'll have to work on in the future. Use our imagination, of course, at the same time, striking the right balance between those needs and the sort of really the fair trial principles that we also, of course, need to take good care of while we go. But this is an area where I think it would be really interesting to hear some more examples of how other countries have dealt with this balance that I was mentioning. Theme number 2, openness, transparency, and stakeholder cooperation. Again, from the basis of trust in society. We talked about this already in the morning, but I want to just stress that trust is created and preserved best when citizens can trust that public authorities are working openly and transparently, and that people also can genuinely participate, exercise their participatory rights. And it's very important to look at where and when this can happen. For instance, when we are talking about legislative procedures, we, of course, all have the tradition of opening up the legislative proposals for comments at a later stage. But from a citizen point of view, this may be a little bit late because the normal citizens would probably have a lot to contribute on the issue itself, but less when it comes to legal drafting, for instance. So it's also really important of how you hear people, when you hear people. Also, we have created e-based electronic democracy services, which have proven very popular, especially the Finnish citizen initiative has really proven very popular, and we've been able to reach groups in the society that are normally not taking part in for instance, legislative hearings. These will go directly to the parliament, so they are law proposals. We also have a special body in the ministry, or with the ministry, representing civil society with different population groups. We have another one on ethnic relations, so especially minority population brought up in context with us to be able to express their views. There's one on linguistic rights where we again put special emphasis on linguistic authorities, thus making sure that we are actually hearing all sectors of the society, not just maybe those who normally have a voice without our reaching out to them that actively. I mentioned earlier the network of media judges, so I will not go into that anymore, but I think it's an important aspect as well. So the third theme that I would touch upon briefly is strengthening the knowledge base for decision making and also law drafting. And as has been noted, it's really vital to develop data collection to be able to strengthen knowledge-based decision making in legislative and policy projects that are significant for the realization of fundamental and human rights. This is a major enterprise, of course. We have recently put out a government national action plan on human rights and fundamental rights, concentrating on knowledge. So we are currently in the process of creating human rights indicators. I don't know if colleagues have been involved, but it's a major exercise. We've looked at international practice that's out there, including the UN or OHCHR guidance for human rights indicators. It's a lot of work, but I trust that when we go forward, there will be also from the point of view of developing our justice systems, something that we can then base our views on in a more reliable manner. I also wanted to mention the development we've been doing on human rights impact assessments in legislative drafting, which is of utmost importance in developing people-centered justice, because if we do not do proper impact assessments, how are we going to be able to say that we are taking into account the needs of various groups of the population? So we've done this through strengthening the competence of law drafters in fundamental and human rights, and in developing guidance, for instance, for gender impact assessments, rights of the child impact assessments, etc. And also these impact assessments in law drafting cover both ex-ante impact assessments when preparing legislative proposals, as well as ex-post assessment after the entry into force of legislation. And again, you will need to do this in cooperation with stakeholders, judicial authorities, and the civil society. I'll stop here. Thank you.
Thank you very much, Johanna, for excellent points. I think the point about the human rights approach bringing it to the individual, that really does bring it to the heart of people-centered justice. Openness and transparency, of course, but also the third theme you mentioned there, that strengthening the knowledge base and impact assessment. I know that in my country, Australia, that's a huge challenge. The use of indicators is not very far advanced, but I think that impact assessment, to see if you make a difference, to determine what works, which we'll cover at another session later, very important. So thank you very much for that. We now go to our first remote speaker in this panel, and I hope Leila is there, but I will now introduce Leila Medina, who is the Advocate General of the Court of Justice of the European Union, and invites you to speak.
Good afternoon, everyone. I hope I can be heard.
Yes, you can.
It is a great pleasure to be kind of back to the realm of OECD, as I was a frequent visitor of this organization in my previous capacity. So thank you for inviting me now when I am representing the European Court of Justice. And in my short speech, I will try to show how also supranational courts do have to think about becoming closer to the people and think of the aspect of people-centered justice. And I'll just start from reminding the very basic, why do we at all talk about it, that there is a need for people-centered justice, because both EU and OECD at their start were organizations which were meant to enhance the economic cooperation between their member states. And that was not exactly the human rights or the fundamental rights of the people, which were at the agenda at the time. But when you look at the EU last 10 or more years, especially the European Court of Justice judgments, you see there's a fundamental change in the paradigm where we put a person in the center, its fundamental rights in the center when interpreting the EU law. And why is it so important? Why do we speak at all about people-centered justice? And in my view, that is actually the very premise or the very reason of having a democratic country, whereby general elections, we give the power to public bodies, and then those public bodies have to think about the needs of people who have given the power, who have empowered those organizations, those public bodies to work for our needs, for people needs, and to bring those services closer to people. And that is the only way how we can also enforce democratic country and the rule of law and the protection of fundamental rights. And that's why I'm so happy also to see that OECD, which is, in my view, the best organization in gathering, analyzing, and sharing best practices all over the world, is also now taking up the issue of the access to justice as part of the fundamental right of the people, and looking what is best in the world, and also looking maybe what is best in supranational organizations, what can be helpful for people get closer to justice. My first point, which I wanted just a little bit to stress, that the balance between the courts and the alternative measures. That's when you read the documents developed by the OECD, one might get an impression that since the majority of disputes are settled outside the courtroom, the courts are maybe not that important anymore. And there I would want to stress that that's not the case. The courts and their being independent body who can settle the dispute along the basic rules of the democratic country is also the core for all the alternative measures to respect the rule of law, to respect the main principles, how disputes have to be settled. And I see three ways how the courts are there to be as a central element. And first is the courts themselves should be as a sample. There you could see really how to settle a dispute in a democratic and just way, so by that guiding the other alternative ways to follow the route. The other way, it is providing the jurisprudence, the judgments, where you can see the content, how you interpret the law, how it is to serve the justice, so the other alternative routes can follow that realm. They can follow the way how to understand the laws which are adopted by respective parliaments. And the third, I think almost maybe the most important, by having a trust into court as an independent and an organ that delivers the justice, it is in a way of guarantee. If all the other measures fail, there is a court where I will be served justice. But these are all big words, but what are the practical ways how the court, especially when we talk about the international or supranational court as it is the European Court of Justice, what can we do to come closer to people? And I think there are two ways. One of them is by opening up the courtroom. And that is a great way how we can use digital tools where people can see how justice is made. And the other one, which perhaps has been less talked about, it's actually the education starting from the childhood, starting from the school children, to explain how justice system works and how I can protect my rights in a respective legal system. But they're turning to the digital tools. Just a little bit to throw in a little bit of voice of caution, and I think some of the previous speakers mentioned that already, that digital tools should be, in my view, seen like a fire. If used wisely, it gives all the benefits we could wish. It brings the court closer to people by, like, for example, right now I can be present, although I have not made the distance from Luxembourg to Riga, but I can be part of this wonderful event. But at the same time, if used recklessly, it can actually increase the gap. It can actually take away justice because people don't have the knowledge, the people don't have the means to have the access to all those digital tools we offer to make justice more accessible. So whenever the digital tools are put in place, one has to keep in mind not to marginalize those who might not have the knowledge or the means to use those digital services we provide. And now I would just want to conclude my little intervention here by telling some of the little samples the European Court of Justice has developed to become more open. I opened my speech with a reference of the change of the legal paradigm. That is, that the judgments of the European Court of Justice when interpreting EU law has now put a person in the center. But sometimes when you just think of the content of the judgment, but don't deliver that to people, people cannot learn about those judgments, or they cannot learn how the court operates, that remains only on the table of narrow part of the experts who know the EU law. So one of the very, in my view, very interesting steps the court has taken from the April of this year, it is the web streaming of court oral hearings. Now it's possible for everyone to get connected, and I think it is maybe difficult to imagine, but when you take the EU, it's only a few countries around Luxembourg can actually send people to participate in oral hearings in person. But if you can do it remotely, it's the whole EU and beyond EU. If you are interested, you can follow how the court is deliberating and how the judgment or justice is delivered. And what is maybe a little bit unique in the case of European Court of Justice, that's a question of languages, which was also mentioned by the previous speaker. As you know, in EU, it's more than 20 languages in which we speak. And the system which the European Court of Justice provides, it allows to follow the court proceeding in all languages which are actually used in a particular oral hearing. So this also safeguarding the languages and language regime present in EU, also when you use the digital tools. The other aspect which I talked about, the education or teaching about how the justice is delivered, is a very special initiative by European Court of Justice, which actually came in as a result of COVID when the court doors were closed. This is the digital visits to court and digital webinars, which are addressed to any member of the society, and some of these members specifically designed for children, to show the court, to show the processes of the court, to explain how court works and how you can bring in action, how you can get the court judgment, and all the matters related to that. And the final aspect I just want to say a few sentences is that not everybody is capable of reading all the several hundreds of judgments of the court which are delivered per year. Therefore, the communication, the court communicating with the society via cooperation with mass media or by producing its own materials, where it explains what are the judgments, what are the ways how the judgments protect these individual rights of the people, are of utmost importance. And I am glad to say that in near future, we will see a big improvement in the way European Court of Justice actually talks to people. And I invite all of you to follow those developments. Thank you. And I hope that was also a little bit some ideas for future discussions in this panel. Thank you.
Thank you, Leila, for updating us on the advances that the court is doing, and also alerting us to some of the cautions that you raised and the importance of courts and including the supranational courts. We'll now turn to the first of the two researchers in the area for a slight change of pace. I'd now like to invite the first speaker, Rebecca Sandifer, who's Professor and Director in the School of Social and Family Dynamics at Arizona State University, to speak. Rebecca. And we have some slides, I think, somewhere.
Thank you, Jeff, and thank you to the OECD for continuing this really critical conversation. One of the things that you'll see, I hope, when I start my remarks is that this conversation has allowed us to see some convergence in what we know and in what our next steps of needing to know are. And I want to talk about those today. Over the past 15 or 20 years, from a whole range of sectors, from civil society, from government, from NGOs, from the OECD, from the academy, we have a whole range of research that's pointing us in very similar directions. And part of the reason it's pointing us in similar directions is because the OECD and others have created this common space of conversation. And part of the reason it's putting us in similar directions is because when people agree and they're coming from different points, it means they're probably onto something, right? We're probably learning things that are actually true. One of the things where we are now is that we actually understand a lot about people's justice needs, much more than we did 15 or 20 years ago. We don't understand them perfectly, but we understand them very well. And a lot of that comes from legal needs surveys that have been done in jurisdictions around the world. So we know that there are some very similar patterns across jurisdictions that are repeated with local variations, but they're very, very consistent. One is that if you look in any jurisdiction, yours, mine, those that are not represented here, civil justice problems are common, they're widespread, they're experienced by all groups in any given population. And we know that those problems, those common problems, are common everywhere, even though they might be institutionalized in different ways or go under different names. So there are problems about buying and selling things and engaging in consumer behavior. There are problems in relationships, whether those are neighborhood relationships or family relationships. There are problems about making a living. There are problems about dealing with credit. And there are problems about space. And so in some places, the space that's important and becomes a legal dispute is about land, and in other places it's about housing, and in other places it's the intersection of those two things. But very common problems manifested in slightly different ways around the world. We also know that everywhere, my jurisdiction, yours, and those that aren't here, people face barriers to access to justice, and they tend to come from the same kinds of sources. So people don't have information, or they don't have access to understanding. People are separated from the providers of justice solutions by time, by space, and then sometimes justice solutions can be very expensive. We often think of lawyers as being very expensive, but court itself can be very expensive. Across jurisdictions, we also see inequalities. And although those inequalities reflect the particular vulnerabilities in specific places, so who is socially excluded in one country is not necessarily the same group as in other countries, we know that groups that are disadvantaged are more likely to experience civil justice problems, and when they experience civil justice problems, the consequences of those problems tend to be more severe and more expansive. And we know that we also see inequalities of access to meaningful assistance, whether that's institutionalized assistance, informal sector assistance, or sort of legally adjacent assistance. And we also know that part of those inequalities come from the design of legal institutions, the formal design. So for example, in my jurisdiction, the amount of controversy determines whether you're going to be in a court that is ever going to have any lawyers at all, including lawyers who are making the adjudication decision at the top of that tiny little legal pyramid. There are all kinds of ways in which the way we design justice systems magnifies and creates new inequalities, and that's true across all the justice systems that we know about. Another thing we know across the world and in every context is that even though most of our attention has been to formal legal institutions, legal institutions are in a certain way minor players in access to justice. They're peripheral, whether you're talking about lawyers or courts or alternative dispute resolution of different kinds. Those are peripheral to most justice problems. So one way to see this is to think about what actually happens to people, all of those justice issues that they experience, as a gigantic iceberg. And what courts and lawyers see is sitting right at the top of that iceberg. It's the stuff that floats up to the surface and is captured by the formal justice system. But what we know about icebergs is that somewhere between 80 and 90% of the ice is below the surface, and that's the part where the Titanic runs into you and the entire ship sinks, right? That's a really important part of justice activity, and it's most of justice activity. And this is true, as I said, in every country, in every place where we've decided to study this. That's what we know. And now this has given us an evidence base that starts to think about what the next generation of solutions is going to look like, and Maurits is going to talk about some of those, but also what the next generation of questions to design those solutions needs to look like. And so one way of thinking about these new solutions is that they're just solutions, right? They assist people in communities in resolving the issues that come before them in ways that are within the bounds of the law. Just solutions are evidence-based. So I talked a lot about the evidence base that tells us who has what kinds of problems and what kinds of consequences those have. Just Solutions take that evidence and use it to design systems and services and interventions that assist people in dealing with their issues. Those kinds of solutions will privilege what we know about what people actually need over existing institutions. So over what is already being done in the justice sector, over what already is being done in the NGO sector, over what clerks and judges and bailiffs already believe about justice. Instead of taking that as our starting point, we take people's actual experiences as our starting point. And we also step away from stakeholders' vested interests. So, for example, licensed legal professions have a vested interest in being the central providers of justice services. Courts have a vested interest in being the central providers of justice services. That may not always be in the best interest or the greatest need of the people who could use access to justice. The second thing we know from research about what works is that services, interventions, dispute resolution fora that are effective at achieving people-centered access to justice have some common qualities. And they go under different brand names, but they are very, very similar regardless of where people are looking at them. One way to think about them is as the 4 T's. So these solutions or interventions are timely. They show up when someone realizes, or when a community realizes that it's in trouble, that it has a particular kind of issue and could actually use some help. They're targeted to those specific issues. So it's not about everything you might possibly need help with, it's about what you actually need help with. And they're trustworthy in the sense that when people encounter them, they come through routes that those people believe in. And sometimes those routes are trusted formal justice systems. We've heard a lot over the course of the day about how access to justice increases trust in the judiciary. It's creating the judiciary and the court system and lawyers as a trustworthy source of access to justice. But there are other sources that are also trustworthy. Community organizations, religious organizations, informal justice systems. Those are places where people can achieve just solutions because those solutions are timely, they're targeted, and they believe in them, they trust them. And then finally, effective solutions are usually transparent in the following sense. People understand what they're getting, what the next steps are, and if there are costs, they know what those costs are. They have some capacity to understand what they're entering into and to make somewhat informed choices about which way they want to go within the context of that process. So we know that these are important elements of things that we would like to design that would be effective in helping people achieve access to justice from the perspective of people and their needs. The other thing we know about just solutions is that they're outcome focused. And this is really in contrast to the way we thought about access to justice for a very long time. So traditionally we think about access to justice as about, some people talk about it as about inputs. So it's access to process, or to a service, or to a technology, or to a forum. But that's not actually what people want. What people want is access to some kind of resolution. What they want is access to a particular outcome of receiving a service, using a technology, engaging in a process. And so just solutions, when we think about them, are not about how can we give you access to an experience that might get you somewhere, but how can we give you access to an experience, to information, to resources that will get you where we all want everyone to go, which is to solutions that are just and lawful in the context of any given set of laws. So we know a lot, actually, but what we know less about are 2 things, I think. So one is, we know the elements of effective solutions, but we're currently terrible at figuring out how to scale them. Scaling turns out to be incredibly important for a range of reasons, but one of them is that the world is very, very big, and it has a lot of people, and a majority of them have unmet justice needs, and therefore spend at least part of their day living outside the protection of the law. So being able to scale the things that we know is effective is critical to meeting that enormous unmet need. The second thing that we need to understand is how to make rules that let us give people access to effective solutions at scale. This we're terrible at, absolutely terrible. What we typically do is we think about how to increase access to justice by starting with lawyers and courts. And if we think about the 60 to 80 years in which we've tried to do this, it has a very robust and consistent track record of not working. And there are two reasons for that. One goes back to that iceberg. Most justice activity is not making it to lawyers and courts anyway. So why was that where you would look to try to solve the problem? Let's look where things are not happening, right? It's the classic thing about looking for your keys under the light post, even though you know you dropped them in the dark. The second reason that a focus on lawyers and courts won't work is they're very, very difficult to scale. It's very, very difficult to create enough resolution fora to deal with the billions of justice problems that are happening in the world every year. It's very difficult to create millions and millions of skilled workers who have a 5-year education, a 7-year education. It's just incredibly expensive. So we know that if we want to create just solutions, we're going to have to do 3 things. They're going to have to be evidence-based, they're going to have to be outcome-focused, and they're going to have to be re-regulated to achieve goals that are people-centered. And the goals that people need are competent providers, regardless of how they happen to be licensed, expanded access so that people who have no access to any kind of law right now can get some, and equalized access so that some of those inequalities we know about from every legal needs study that's been done in the world can start to moderate, and we can actually have the access to justice that we all want. Thank you.
Thank you, Rebecca, for that very efficient run through what we know through all the research over the last 20 years and your stark presentation. And I'm sure that will give everyone some food to thought, even those of us from the tropics without icebergs. I'll now like to introduce our next speaker, Moritz Barendrecht, who's the Research Director from the Hague Institute for the Innovation of Law. Moritz.
Thank you, Geoff. Thank you, fellow panelists, Rebecca, for setting the stage. I'm Research Director at the Hague Institute for Innovation of Law. That's a foundation funded by Dutch ministries, the city of The Hague, a city like Riga, also promoting itself as the city of peace and justice. And we also funded by international ODA partners for our international work. I will talk about our experience in people-centered justice programming. Before getting into that, you might ask, programming, why is that needed? Will it not happen by itself in our current legal systems? We explored that. And the starting point is, I think, what we all share here today. The case for people-centered justice is very, very strong. People need just solutions in the way Rebecca explained. Judges, prosecutors, lawyers, government officials are often seen as conservative, but that's not what we see. We see that these justice practitioners, especially the ones who are working the front line, they want to solve people's problems. They are often stuck in the complex laws and procedures in the same way as people are. They want just solutions. And I think nobody in this room wants a law that can only be understood by the smartest of lawyers. We want faster problem solving from our citizen perspective. It's good for practitioners, it's also good for the economy. If we can solve conflicts of interest, the environment will benefit. We also know more or less how to do that. The OECD has done fantastic work on that, getting together the best practices of people-centered justice from all over the world, leading to very high quality guiding principles and guidelines. So the question we should ask next is, if we all benefit from people-centered justice, why is it not yet happening? Why hasn't it happened already? And it's probably good to look into your own country's situation and look at how and which organizations could make that work. Maybe in your country you see also the judiciary doing a lot of pilots and wanting to be effective, but also having no resources and incentives to implement at scale. Rebecca mentioned it. Look at ministers and ministries. They want impact. They have ideas, but they are mostly held accountable for the flaws of the current system every day. If we look at moderate politicians, we know how difficult life of moderate politicians is right now, but often they strive for effective systems and evidence-based working. But they have very few innovation tools. They can make even more legislation, they can shift maybe a little bit with budgets, but what can they really do at the ministries? Academics and innovators in your countries, they want to develop better procedures. They want to develop the tools for better access to justice for all these 5 billion problems. But do they have a route to implementation? How can a startup, a small academic project, how can it scale up? Law firms. Law firm partners, I was one earlier in my life, feel very uneasy about access to justice. But look at their consultancy business model. How can they ever contribute to better access to justice for a large number of people? Private foundations, finally. How many private foundations with the big money from the big entrepreneurs do we see moving in this field? It's really very hard for them to go into a complicated political field like justice. So our question is, who can take the lead? Probably that is an issue. And if we look for people-centered justice, aren't we waiting for miracles? Aren't we waiting for a new Nelson Mandela, a Gandhi, a Martin Luther King to stand up and try? We at Hill, we started to think about maybe a different approach is needed. Maybe tackle this rigorously. If we take the OECD guidelines and principles seriously, how can we build this into a mission with a targeted set of people who can do it? How can we move this sector to what is normal in every other sector, 3% spending on R&D, developing new stuff? And how can we do systematic programming? In our report, we have we have a few copies with us and summaries. You will find thoughts about this experiment. How would it look like if we put people-centered justice in rigorous programming? You will find things there like making the case, because we saw many people already trying that, quantifying the burden of injustice, how to calculate contribution to GDP, how to establish ownership, how in this very special sector can we create a collective that is independent but also trusted enough to move forward? How can we formulate a mission? One way to do it is to make just solutions a indicator and work for it. If of a certain problem, 80% would be resolved by agreement or decision within 1 year, would that be a target we could work against? We talk about resourcing a program like that. We talk about the justice innovation traps, because we all saw a lot of failure. One of the traps that we see a lot is digitizing existing procedures. We all know from IT experts that we shouldn't do that, but it happened a lot in the past. what kind of game-changing models are around for scaling? Because scaling is indeed a big problem. Which types of justice services are able to reach 1 million people, or at least a number of thousands? And how can this work financially? What are the financial models behind effective, scalable justice services? How can we define and monitor outcomes? Rebecca spoke about this, and how can it be done in practice for personal injury cases, for a family separating? How do the outcomes that they need look like? How does peace and justice look like for their situation? We saw a lot happening in the world about how startups try to become scale-ups. What type of leadership you need for scaling, because it's very different from the initial ideas of starting something new. And regulation, indeed, is a big issue. In the healthcare sector, there will be spoken more about this in a few minutes. We saw safe vaccines being rolled out to billions of people in 1 year. Why can't we copy their regulation system to deliver safe stuff? I hope you will take a look at how all these data people, these researchers, these judges, these mediators, these prosecutors are already producing the components of people-centered justice programming. Because what we did is collect what all of us around the table are doing and monitoring. How the ideas of ministers, director generals, social workers, and procedural justice experts can be integrated. How they can work together to serve the people, the businesses, the communities, and the governments of their countries with better problem solving, less polarization, more peaceful and inclusive societies. We must ensure just solutions and cooperate in a systematic way. Thank you very much.
Thank you, Moritz. Whilst I don't think he used the word, in fact, I've forgotten the word myself now, so I won't say it, but inertia, sorry, was the word I was going to say. I don't think he used the word inertia, overcoming inertia. I think that's what some of the early part of that presentation was mentioning. Miracles, but I think Moritz also mentioned too the scaling issue, which Rebecca had mentioned, but I also introduced a concept which, from my old military days, rings a bell. There's end state planning, or in other words, what does success look like? And working back from that, rather than working from what you've got and working forward. What does success look like? That's the end state, and that's how we should go forward. Thank you, Moritz. And his segue into other sectors of learning is a fabulous one, because we now move on to our final speaker, and that is Eliana Bahenio, I hope I pronounced that correctly, from the OECD, who's health economist, policy analyst, Health Division, Directorate of Employment, Labour and Social Affairs at the OECD. And so, Eliana, welcome, and I'd like to invite you to speak.
Many thanks. First of all, I would like to confirm you can all hear me well. Can you hear me?
Sorry, yes, we can. Sorry.
Oh, perfect. Many thanks. Good afternoon, everyone. It's a real pleasure to be here. Unfortunately, I cannot join you in Riga as I would love to. And Geoff already introduced myself. I'm definitely the outsider in this conversation, but I'm very glad to be here, and hopefully I can share with you some food for thought on how health systems are actually advancing an approach to people-centered health systems, as well as with some struggles that we are still very much working on. So I have prepared a few slides to share with you today, and I'm going to share my screen. I think that's the idea. And I would like to confirm you can all see my screen. I hope that's the case.
Yes, we can see it.
Perfect. So I would like to first of all set you a bit on what are the main challenges at the moment regarding health systems. And health systems have to meet actually an increasing changing of needs of increasing assertive population of citizens and patients. In the current circumstance, as you all know, in a even more complex health policy context, where we are facing mega trends, some of them our colleagues in justice also refer to, mega trends on digitalization, a population aging that has an increasing prevalence of chronic conditions, new pandemic threats, and growing expectations, particularly in democracies, to access to some sort of extensive basic health care, very much and increasingly questioning how that healthcare is delivered and what healthcare is delivered. So in these respects, the OECD has worked and has put forward a framework for people-centered health systems, which identifies 5 core dimensions to benchmark the progress countries have made towards a more people-centered approach to health. And this people-centered approach to health has been seen to offer answers to some of these major failures that health systems face today with these mega trends I mentioned. The first dimension is voice. Patient voice remains, in fact, weakly embedded in the decision-making process of health systems by policymakers, but also by the providers of care, including clinicians. Second is choice. Countries have increasingly adopted some policies to increase choice by patients to decide where to have access to some health services. But in fact, in practice, access and affordability of some solutions hamper that free choice. Third, co-production. Patients are increasingly seeking control over their health information and challenge and influence decisions about their own health. You could be surprised that only 2/5 of the OECD countries systematically allow patients to interact with their own personal health information. Fourth, the pillar of integration. And that's crucial, particularly in an aging population, chronically ill, really needing a permanent interaction with various parts of the systems to actually work together. And despite of some progress, some countries have achieved to use and to leverage digital health to kind of link the various parts of the system to work together. We are far from actually achieving an overall success in that area. And finally, respectfulness. The idea that people should be ensured they are valued in the health system. So most countries have, in fact, a formal definition of patient rights, and they have established the role of the Ombudsman to actually help to mediate some disagreements. But nonetheless, there are some failures still in this respect. The big shock we've been living recently, that health systems and how our societies have lived with the current pandemic, actually shed light on common features needed to promote people-centered health systems, to start the empowerment of patients to actually being able and literate to manage their own care and navigate through the system. Secondly, the possibility for systems to allow devising novel institutional arrangements to deliver care in the right place. And that's not necessarily close to the traditional places where care is delivered. Countries have, in fact, like Slovenia, adopted new models of care, namely home-based care and hospital at home, to maintain routine care and to even deliver a combination of services, including long-term care for the elderly. Thirdly, importantly, to align financial incentives across providers. Some countries are actually moving towards some financial integration and the design of innovative payment models to incentivize providers to work effectively together. Finland is, in fact, developing a capitation system across regional and local administrations to bundle payments for providers to deliver to patients health and social care together. Fostering collaboration across professions, and many of the professions that are actually part of this healthcare system. Several countries, for instance, Spain, have adopted care integration through setting up multidisciplinary teams to proactively offer and target community-based care to vulnerable populations. Important, crucial, develop fit-for-purpose information systems. Actually, the pandemic has highlighted the failures that are still persistent in this area. But in fact, 92% of the countries have improved timeliness of data. That is definitely huge when we have to use evidence-based to put in practice interventions. 63% of the countries in OECD have, in fact, implemented new rules to improve health data availability, access, and sharing. A last point on digitalization, where countries like the US have used solutions such as smartphone apps linked to self-monitoring kits to monitor blood pressure or oxygen uptake, which allowed, at distance, healthcare professionals to act and to prevent signs of deterioration of health for patients that required eventually an hospital admission. It was mentioned here by colleagues already, a transition to people-centered approach, in this case health systems, is by all means a transition for measuring what matters to people. The OECD, in the area of health, has launched a very big initiative called the Patient Reported Indicator Surveys, PARIS, to systematically measure outcomes and experiences for what matters most to people. To guarantee the survey is relevant and valuable for the main stakeholders, the OECD has engaged from the beginning with civil society, and important stakeholders have been involved from the beginning in the design, and now we are facing the phase of the implementation of the survey. And these are patients, providers, an established international consortium of experts, academics, and implementers on site. This survey is an important joint effort of countries to bring people's voice to health policy. We are awaiting the first results of the survey very soon and excited about what it brings. I want also to tell you that while countries have made significant efforts to support the OECD Council recommendation to integrate health information to enable better integrated care, people-centered approaches to health, despite that progress, still only half of the OECD countries is able to link the majority of their national administrative key data sets. So the OECD is leading internationally work on comparison integrated care delivery with the people-centered approach, seizing opportunities for countries to leverage their data infrastructures and be able, for the benefit of patients and systems, to trace the patient journey throughout the entire system, looking at the various interfaces that the patient does have with the system. And we have recently published the first set of indicators that leverage on this linkage, and we are now undertaking work to, in fact, move towards linking health with non-health data to enable us understanding better the unmet needs of vulnerable populations that don't necessarily reach out to the system. Let me finish by the hurdles that actually the COVID-19 has been just a big mirror in showing what are still the failures when it regards to delivering people-centered integrated health systems. To mention just a few, the continuing fragmentation between hospitals, primary healthcare, and social care. We have a constellation of providers in healthcare, and they continue to be very much fragmented in the way they optimize their processes and they actually deliver care, which in fact undermines the delivery of appropriate safe care to people. We all remember the death toll on nursing homes that actually exposed many OECD countries didn't have in place institutional arrangements for those populations to actually being heard and integrated in healthcare systems. Second, siloed information infrastructures that limit the possibility of integrating various data that is already placed in the system. And that those failures in the health data governance are actually exposing issues, legal concerns about data privacy of patient data, which is far from being solved. One more word regarding the role of the private sector that many times moves faster than the regulatory frameworks that should be in place, stand ready to ensure sustained solutions to improve the delivery of healthcare to populations. An inadequate skill mix in the health workforce that is not necessarily prepared to the digitalization boom we are facing, and the not necessarily capacity to work collaboratively across professions, training skills, and sorts of providers. To finish with the still persistent inequalities that exist in health outcomes and access to health systems, to give you just some points for discussion. Hopefully this is useful. Thank you.
Thank you, Ileana. Very interesting, the similarities and some key differences. I liked in particular the issue of the designing novel institutional arrangements to provide the type of service needed when and where it's needed at the right time. I also thought it was interesting the point about measure what matters to people. And it's something we might take on board, is to think about are we measuring what matters to people? Okay, thank you for that. All right, now the good news is that I've proven that you can trust me because I said it was going to be a great session with great speakers, and it is and was, so you can trust me. The bad news is we've only got 10 minutes or less for questions. And so can I have anyone like to ask a question and of the panel? And if you do, I'll nominate you if you could say who you're from and keep it a very short, sharp question if you could. First candidate over there. I'm sorry, I don't know your name, sorry.
Thank you so much. I'm Seçkin Koçer from Turkey. Thank you so much for this very informative session. I have already taken lots of notes. I have many questions, but I will not take your time too much. I have just a question to Jean-Paul Janssens. You already mentioned about the 10 days separation in terms of violence in a family. Do you provide any place to stay to those who have perpetrated violence against women or men in your country? Why I am asking that question? Because sometimes you are taking some measures in terms of violence against women or men, but it turns out that it could deepen the conflicts between the parties. So do you have any concerns regarding in terms of that issue? And instead of that kind of measures, do you think that the family mediation would be a better option? Thank you.
Ok. Bah, d'une part, ce que je tiens quand même à dire, c'est que le procureur du roi qui intervient et qui prend une...
I would like to say that in most cases, we need an approval by the royal prosecutor about sufficient evidence of violence. It does not mean working only in one direction. Sometimes the family conflict is so severe that woman actually manipulates her husband. However, this fact has to be established by the police. Except for very severe cases, we always take any precedents into consideration. For example, have there been any previous complaints which enable to create an understanding of what the situation is? The separation period is only for 10 days, as I said. It is a chance for the parties involved to calm down and for the police to investigate. In the worst case, the perpetrator is incarcerated for these 10 days. I hope I answered your question.
Mike Sousa, Canada. Jeff, you're right. The panel didn't disappoint. I was particularly interested in hearing the researcher's perspective. Rebecca, great presentation. My question is more for Moritz at Hill. In one of the slides, you talked about the quantifiability of the benefits of access to justice. I think it was financial, environmental. And we just so happen to have some conversations with some colleagues who have access to justice directorates in their government. And when we pitch to our masters or political masters for more resources, or even just preserving the resource that we have, it'd be good to get your views on that. Of course, there'll be benefits from corrections, benefits, social benefits rather, but wouldn't mind hearing your pitch and even maybe chatting elsewhere within the discussions. Over to you.
Yeah, thanks for this great question, how to quantify the benefits, and are we focusing when we pitch people-centered justice on cost savings or on benefits of society for society? In our report, you will find outcomes of research that was commissioned by the Dutch Ministry of Justice on a target of 80% resolution. How much would it benefit society? And the main benefits they found was in raising productivity. When people are in conflicts, they are doing something less productive than they otherwise could do. There's transaction costs, the time they spend in dealing with disputes, in sitting in conflicts. And the calculation was done on the basis of data that were available for separation and for work conflicts. Extrapolating this data to environmental land conflicts and bigger issues is still work to be done. But the basic model has been developed by an agency which has economics experts in it, and so that's the stage we are in. A final big benefit is also quality of life. We are all moving towards not only measuring GDP, but also quality of life, and following the quality of life measures that are also developed in the healthcare sector. The gains are really very impressive.
We've probably run out of time, which is unfortunate, and because I've been convinced that we all need coffee. But as part of the deal that I'll give you for allowing a coffee, I'm going to ask you all the question that I was going to ask the panel to answer quickly. This session was really about priorities in a way. And over coffee, you can ask one of your colleagues what their answer to this question would be. And my question is this: imagine you are the Minister of Justice, Attorney General, or whatever in your country. And the President, Prime Minister, whatever, calls you in and says, listen, we've found an extra €500 million in the budget over the next couple of years. Didn't expect it, don't know where it came from, but we've got it. I want to know what to do with it. Minister of Health's going to build extra hospitals and all sort of stuff. But I'm interested in this people-centred justice. It sounds like it'll get me votes. So what would your priority be? What would you spend that money on? You get 15 seconds to answer. Anyway, if I can, I'm not asking the panel, I'm saying it to you all. You can all think about that and ask your colleague over afternoon tea, what would you spend that money on to promote people-centred justice? Thank you all very much for your attention. As I said, you can trust me. It was a great session. We had some wonderful speakers, quite diverse and really fascinating speakers. I thank our two remote presenters. Thank you very much for your time and all the complication that involves. I can't offer you coffee, but you'll be here in spirit. And I'm also just saying that there's been a lot of work by the OECD. Some of the reports in the back of the room, I'm told, and I'd encourage you all to look at that material. Once again, I'd like to thank all the panelists very much. It's been a fascinating session, and I'm looking forward to the rest of the roundtable as a result. So thank you very much.
And we try to come back in 15 minutes, so 10 minutes past 4.
So for the next session on interagency coordination for access to justice and more enhanced approaches and cooperation between the different agencies responsible for the access to justice, it's my pleasure to present moderator Imants Krastinch, advisor to the Minister of Justice of Latvia. Imants, thank you very much. The floor is yours.
Okay, ladies and gentlemen, nice to have you all for our afternoon session. The title is very challenging if you have had a very good conference so far, but we already talked with our esteemed panelists that we're going to try to make it more fun by concentrating on practical aspects. But the total title, as it sounds, is Interagency Coordination for Access to Justice. Ambition is high. There are need for, well, what we can read in all the legal needs surveys already for 20 years. People, only 10% of them, using the iceberg principles, actually only 10% of them have what we see, good access to justice systems. And as our esteemed speaker, Rebecca from Arizona State University, showed us that 90% of them actually never surface. They never surface. And the title of this panel is how we can actually implement our great ambitions of making agencies, governmental and private sector and NGOs to work together so they can actually already influence the lives of our people, of SMEs. And it touches the broad perspective, starting from health to legal to social security and all other aspects that you can imagine. So in essence, it's a holistic approach, and you know how it happens in our everyday lives. Each new year we try to make these promises. I'm gonna eat healthy, work hard, but then I will take breaks, play with children, and do sports, and how it often ends. It's very challenging, and it's even more challenging if you are taking together all these ambitious plans, how we can make a holistic approach to all these various governmental agencies inside each country and add to them private sector and NGOs. How to do it? Today we have three very esteemed and full of leadership governmental officials from United States. That's Rachel Rossi, and about each of them I will introduce a bit later when they will speak. But Rachel Rossi is Director of the Office for Access to Justice, Department of Justice. Then we have Mr. Michael Souza. He's from Canada and Senior Assistant Deputy Minister, Department of Justice. And the third speaker will be Jacques Wijnen. He's Senior Policy Advisor from Netherlands, also Minister of Justice and Security. And as I already told, each of our participants perhaps will focus more on those examples, practical examples, and that's our collective question and challenge to all of you. During the group discussions, please bring up your success stories. What has worked in your country, and perhaps even more importantly, where you tried to make an interagency cooperation and what went wrong? What were the stumbling stones, and then how you got up, how you saw the problem? Today we want to learn from your success stories because this ambition is high, but practical implementation is still in its pampers. So please, we will start with our first keynote speaker, Mr. Michael Souza. And as I promised, a brief introduction to his responsibilities in Canada. So he is responsible for cross-sectoral cooperation initiatives and mechanisms. And the purpose is to advance access to justice, including justice and housing, family justice, and so and so. Please, floor is yours.
Thank you, Imants. When you're talking about the level of ambition that governments have and maybe getting distracted by kids and other things, I thought you were maybe talking about my workout resolutions in the new year, but I don't think you were. I have to say I'm already so pleased to have been here a very short time, but still making quick connections and having conversations about access to justice, people-centered access to justice, and I hope to make have more conversations regarding the work that we can do. But today's presentation is about interagency coordination, and this in fact is one of the key roles and responsibilities that my Access to Justice Directorate and my director, Catherine, who takes that access to justice lens to all of the policies that the Department of Justice in Canada reviews, but also more and more doing some reach out to other federal departments and agencies to ensure that they have that lens as well and that instinct to cooperate. We know that legal problems are frequently embedded in a cluster of daily issues related to family relationships, finances, health, schooling, and employment. And in fact, and I think as Rebecca mentioned earlier, often the people that experience them don't really see them as legal in nature. I think that understanding alone suggests that an interagency coordination is essential. There's just too many connections to be made and ways to solve things before they become a legal problem. And on that note, I'd quote one Canadian researcher who has aptly reflected on this. His name was Ab Curry, and he said, "A legal problem does not begin with the filing of a statement of claim. It does not begin with a court or tribunal appearance when a lawyer serves to represent you. A legal problem has a natural history in people's lives as they encounter problems navigating their daily activities." Recognizing this, the Department of Justice engaged in what we called the Canadian Legal Problems Survey in 2021. And what was significant for us is the different approach we took with respect to that survey. So we sought to get information on any problem that could have legal implications or a legal solution. However, it did not limit the scope to problems that were resolved through the formal justice system or even referred to the respondent as a legal actor. Instead, the survey referred to serious problems, not legal problems, serious problems. We didn't even use the word legal in the survey so that we can capture all relevant situations, kind of the iceberg that Rebecca had. The survey results showed that 5.5 million adults in Canada, out of the 38 million that we have, experienced serious problems in the previous 3 years. And while they're anxious to resolve those problems, not many resorted to traditional legal actors in the system. In addition to searching the internet and consulting with family and friends, what the findings showed is that often they would go to community organizations or government departments. And for us, that just demonstrates how important cross-sectoral collaboration is to resolving some of these problems and understanding those problems. As a basic example, we noted that even public libraries can play an important role in the municipal towns and cities, of course, to provide access to legal information in terms of what they may be dealing with. The consequences of serious legal problems also underscore the need for coordination. For example, the survey found that many experience significant physical and mental health aspects with respect to their problems. And I don't think that's relatively new. We often see that, particularly in the criminal justice system. But what it does show is that the importance of multidisciplinary teams, not just in the legal sector. And in this way, having both legal and health professionals assisting on a file, that we can reduce negative impacts by supporting early identification of legal problems and actions to resolve them. Following the model in Rachel's jurisdiction in the United States, Canada's implemented a number of medical legal partnerships in recognition of the frequent linkages between justice issues and health problems. In some of the provinces, we'll have pro bono medical partnerships at hospitals, etc., to deal with problems in that particular situation. So Imants, for actual concrete examples in Canada, we have what's called Child Advocacy Centers, CACs, They're also known as Child and Youth Advocacy Centers in Canada. And this gives you one example of the interagency collaborative approach. This model, again, originated in the United States and provides a coordinated response to meet the needs of children and youth and their family where abuse has occurred. Although these community-based centers are each tailored to meet local needs, one of the key aspects is the multidisciplinary approach, the cross-sectoral approach, which brings together, as you'd expect, law enforcement, child protection services, victim advocacy and support, mental health, medical services, and where appropriate, even the prosecution. Many of these services are located on site, but there will be times when they're not co-located. But the one key aspect, again, is the multidisciplinary teams that continue to work with the families to ensure that there's coordination and to maximize the support in those roles. Working out of child-friendly facilities, the CACs, the Children's Advocacy Centers, seek to minimize system-induced trauma by limiting, for example, the number of interviews where a young victim has to answer questions about their experience. Again, a concrete example. A 5-year study that analyzed the CACs found that the CACs help to address gaps in the system and reduce both non-financial and financial hardships for clients, including decreasing anxiety and stress, offering referrals, and helping clients complete applications for government support. Another concrete example is our government, the federal government, working with the provinces to support community justice centers. Similar to the CACs, these centers coordinate health, justice, and social services to collectively address the root causes of crime and improve public safety and community well-being, and are tailored to meet the needs of that particular community. An even more tailored model in one of our biggest provinces in Canada, British Columbia, we have an Indigenous Justice Centre, and that provides culturally appropriate information, advice, and support, primarily related to criminal law and child protection matters. And this provides important links with other mental health, employment, and housing services. One of the key aspects of this program, as you'll see with others, is a way to divert Indigenous people away from the criminal justice system and to support better integration into the community after incarceration, and then to refer them to Indigenous organizations. We are also doing this, supporting the province in a remote project that we have, because some of the Indigenous communities are in remote locations. So the BC First Nations Justice Council supports a virtual Indigenous center to offer that remote delivery of legal services. One further mechanism that we're doing is to support cross-sectoral collaboration across Canada is Canada's Action Committee on Access to Justice in Civil and Family Matters. This group offers national leadership and plays a catalyst role in advancing people-focused approach to justice. This committee brings together, through its membership, a broad range of justice sector stakeholders and equity-seeking groups, and promotes cross-sectoral collaboration and knowledge sharing. And one example in this year's summit, we heard from someone who's very well known in Canada, an infectious disease specialist, a medical doctor by the name of Dr. Isaac Bogoch, to draw on his lessons in terms of communicating in the medical field about COVID. And I thought this was quite a relevant insight, and again speaks to Rebecca's referral to the iceberg, and I think my colleague from Estonia, in terms of how to better explain the situation when we're trying to have these reforms or get a better understanding of what we're dealing with. And he said one of his main messages was the importance of including social scientists, marketers, communication experts in our justice sector communication. It's this multidisciplinary approach, not necessarily interagency, but getting these other stakeholders and actors in the system to ensure that there's that proper understanding. Because as we heard today, when you start with understanding, you start to deliver that, you start to engender that trust from the public. And I'll speak lastly about a couple examples in my everyday life. Just last week, we met with the Deputy Minister and a federal delegation that was heading to Halifax in a few weeks. That's in Nova Scotia, one of the provinces in Canada, to work on a national restorative justice conference. And that's going to be a meeting of a federal delegation as well as senior levels of provincial and territorial officials, including deputy ministers. And so that'll have its own importance and relevance to what we're doing on access to justice. But my deputy minister tasked our group to come up with a mandate, terms of reference, for an assistant deputy minister-led committee where we start looking at strategic, efficient, non-duplicative conversations at a more granular level among federal departments in terms of what we're doing on restorative justice. But I'm going to dig deeper into that and look at how do we approach collaboration with our federal departments with an access to justice lens, and then even work with our federal, provincial, territorial partners and see what we can do with them. Because the work that we do with our federal, provincial, territorial partners is quite significant. As I mentioned to some colleagues, we have ministerial level meetings quite frequently of the ministers of justice and the ministers of public safety. And I'd say at least half of the topics involve access to justice issues, and even more can include that lens. So Imants, hopefully that provided some examples for the panel and for our colleagues around the table. Thank you.
Yeah, thank you, Michael. Straight away, one of the questions, and I will start first, and please, dear participants, if you have already questions for Michael, follow my lead. Do you have any data on a change of quality of life after you introduce those justice centers in local areas? Have you measured it, or maybe you have some gut feeling?
I don't have that with me, Amants, and I'm not sure if we do have it. I'll certainly undertake when I get back home to look at it in terms of the quality of life, because I know that that's one of the things we want to make sure that we are capturing is how do you capture quality of life indicators to make sure that the child, these children advocacy centers, even the justice centers are working. But I don't have that with me, but I'll certainly explore that. Thank you, Amants.
Okay, and the question, second question. What is your opinion on the role of leadership to actually implement these new ideas and bring together these various agencies and also the dreams come to practice?
Well, that I think we can spend an hour on, but the short answer is I forget which one of our colleagues said something to the effect that what we need is leadership and not management, and I think that speaks to the task ahead of us. I think management will develop, and we all still need this, management will develop the secretariats, the action plans, etc., which is foundational, but without strong, committed leadership all throughout the chain, including our political masters, we won't get very far. But I think that goes to something that we don't think about is selecting people like our colleagues to get in these tables. We have to put more of a focus when we do our staff and ensure that they do more than manage, that they can be inspiring leaders to inspire the change.
Thank you, Michael. Do you have any other questions straight away to the Michael? If not, at this point, then our next speaker is Rachel Rossi, and she's expert in actually, and will share us about lessons learned in from legal aid interagency roundtables, how it affects and strengthens access to justice, to advance employment, family stability, housing, consumer protection, etc., etc. Please, Rachel, floor is yours.
Thank you so much to our esteemed moderator and distinguished panelists. It's an honor to be here. So I'm really pleased to talk about this critical issue about interagency collaboration. Our office, the Office for Access to Justice at the United States Department of Justice, has been charged with not only looking at pursuing access to justice within our office, but across the Justice Department and across the federal government. The truth is that we know breaking down silos across the government allows us to see the interconnected nature of all of the issues that we see impacting the most vulnerable in our communities. All too often, it's the same communities that are impacted by criminal legal systems who are also experiencing housing insecurity and also experiencing the loss of children in the child welfare system. When we come to the table together, we see the interconnected nature and we find ways to break down silos and to find transformational change and reform. Particularly, we look at partnerships across the departments of health, housing, education, food and agriculture, transportation, labor and employment, and so many other cross-sector federal agency partners. Today, I'm going to take the advice of our moderator and try to give you very specific and concrete examples of some of the models that we've been leading at the Office for Access to Justice and at DOJ. So first, the Legal Aid Interagency Roundtable. The Legal Aid Interagency Roundtable was initially convened in 2012 and was elevated to be a White House initiative, the White House Legal Aid Interagency Roundtable. The purpose of the roundtable is to improve outcomes in federal programs that serve low-income and other vulnerable populations and to safeguard their rights. It's a collaboration of over 28 federal agencies, and it deploys a range of strategies to advance its mission. The strategies largely fall into 4 categories. First, leveraging resources and federal funding streams to strengthen federal programs by incorporating legal aid. Second, developing specific policy recommendations that improve access to justice across government. Third, facilitating strategic partnerships to achieve enforcement and outreach objectives. And fourth, advancing evidence-based research, data collection, and analysis. So what does that look like? What does that mean? By all accounts, the Legal Aid Interagency Roundtable was initially an immediate success. Some of the early accomplishments included clarification that dozens of funding grants involving healthcare, domestic violence, citizenship, homeless veterans, reentry, and much more can be used to provide access to legal aid because it furthers the program goals. So for a lot of the federal agency partners at the Legal Aid Interagency Roundtable, they may not initially see the importance or the need for legal services in their sector, but when we come together and we bring that perspective, it allows us to expand the reach of the federal government funding streams. It also created more than 100 webinars and other presentations to federal grantees, the civil legal aid community, and federal agency staff about how legal aid advances federal priorities. The roundtable also implemented new training and technical assistance to grantees and legal services providers, and developed research about the impact of civil legal aid. And finally, the roundtable worked to launch a website, toolkit, and other online resources that provide information about civil legal aid and how they can advance a broad array of federal objectives and available federal funding opportunities and other resources. The roundtable also received international recognition as a U.S. national best practice on the rule of law on the United Nations Rule of Law website. So after a brief pause in its work last fall, White House Counsel's Office and Attorney General Garland reconstituted and restood up the Legal Aid Interagency Roundtable. In doing so, they recognized the urgency and the need for modernized justice delivery systems and collaboration across the federal government. Last year, the roundtable had its first principals convening and issued its 2021 report, Access to Justice in the Age of COVID-19. This report is online and you can review it if you'd like. It considered the devastating impact of COVID-19 on access to justice across federal government. It also analyzed new and innovative policies and programs that were developed by federal agencies to ensure access to justice within federal programs, policies, and funding in the face of the new hurdles created by the pandemic. It also described U.S. efforts to work with partner countries to expand access to legal assistance and to tap technology to support courts and justice systems around the world. And it signaled our continued work ahead, which is underway for 2022. So you'll see we'll hold another principals convening and issue another report this year. Very quickly, a second example of interagency collaboration that is a little bit different is the federal government pro bono program. This program directly focuses on the coordination of resources and knowledge across the federal government to maximize and expand access to counsel and pro bono work. The federal government pro bono program has been operating within the Department of Justice for over 25 years. In January, we moved the program into the Office for Access to Justice, and we expanded its resources for the first time in over 2 decades. Our pro bono program coordinates an interagency working group comprised of over 50 federal agencies to provide guidance and support in identifying and arranging pro bono opportunities for federal employees. So essentially, we work at the Department of Justice with all attorneys across federal government to identify sources for them to engage in volunteer pro bono work, and we help to vet those opportunities and to help with conflicts checks and things of that nature. So that way we're maximizing the power of pro bono across federal government. A third example, and I'll end with this, is more focused in the criminal justice reform space, the Reentry Coordination Council. We at the Department of Justice launched an interagency effort focused on eliminating barriers that are faced by individuals who have been impacted by the criminal justice system and exploring alternative partnerships and responses to public safety. Last year, through this effort, the Office for Access to Justice assisted in launching this Reentry Coordination Council, and we were joined by representatives from 6 other federal agencies. That included our Department of Housing and Urban Development, our Department of Labor, our Department of Education, the Department of Health and Human Services, the Department of Veterans Affairs, and the Department of Agriculture. Together, we engaged in briefings and we engaged in research and learned from experts about the many different impacts of the criminal justice system across many different sectors of the federal government and society. The Council then issued a report to Congress this year that highlighted specific barriers to reentry for people who leave incarceration, how those barriers have been exacerbated by the COVID-19 pandemic, and included specific recommendations on what we can do to further mitigate against those barriers by partnering across government. And as I talked about before, in conjunction with the issuance of that report, our office engaged in a reentry simulation with senior officials from all of these agencies to bring more understanding about the layers of complex hurdles faced by people leaving incarceration. To date, I'll just highlight a couple of notable concrete achievements that have resulted from this interagency work. Our Federal Bureau of Prisons partnered with our U.S. Department of Labor to develop a national initiative to provide comprehensive workforce development services to those in federal prison. Our Department of Education is collaborating with the Justice Department as part of a full restoration of financial aid in approved prison education programs, which will expand opportunities for people who are incarcerated to access and engage in post-secondary education. And in April of 2022, the Office of Housing and Urban Development announced that it is conducting an agency-wide review of all existing regulations, guidance, and policy with the goal to propose amendments that will reduce barriers to housing for people who have criminal histories or who are leaving incarceration. So I'll pause there, and I'm happy to answer any questions.
Thank you very much, Rachel. I have a question, and let's hope we have some more. The first is about the Roundtable. Right now you have received this award, it's best practice, but it's already been on the floor for 10 years. We have this in OECD, this framework on people-centered justice, where it's especially stated that there should be introduced processes and protocols for coordinated decision-making. And now I'm just trying to imagine this 2012 when all these leaders of agencies came together around the Roundtable, and they are leaders in their own respective areas. How did you actually manage it to work? Did you have in place some also protocols that they have to find the common ground, and how it actually also followed during these 10 years the growth? Is there like a room of improvement for these roundtables, and what would you say for us who are trying to follow into the footsteps of the United States? What are essential ingredients so we would get the most of your 10-year experience and already do something like that in 2 years? So it's best practice in our countries. Please, Rachel.
So an important component to ensure success for a large gathering of that nature is to put resources behind it. So one of the things that is really critical about the Office for Access to Justice is that we, by presidential mandate, we staff the roundtable. So this means that it's not just the staff of each of these principals and officials from each federal government coming together, but we, behind the scenes, will work with all of the offices prior to a meeting to drill down on what can be the outcome from this meeting. What can we do here? And we try to bring our expertise in access to justice for agencies who may not regularly engage in this space and may not have an idea of what they can do to collaborate. So while I'm sure many who have put this convening together know, staff are often the driving force of success of a meeting like this, because you have to have a goal and you have to have a plan and you have to have resources and people working towards that goal. So for example, for our 2022 convening and report, our office is actively working behind the scenes with all 28 federal agencies that are involved in the roundtable and helping them to think through what have you been doing, what must be done better, where can we collaborate, and developing sort of a structure so that when we come to our 2022 convening and report, we sort of have that all figured out in advance.
Okay, thank you. Anyone has a question for Rachel? Yeah, please state your name.
Thank you very much for your very comprehensive presentation, and particularly with respect to the re-entry effort that you highlight some of the achievements, which are really commendable. My interest is about some particular group of offenders who may in need of a second chance for re-entry. And I'm not sure if this is too sensitive for the United States jurisdiction, but for instance, sex offenders, they have particular issue, particularly with respect to psychological issue. And I have heard that it is quite a challenge for the US to tackle this kind of particular set of offenders. So I wonder if you can share what do you have in terms of your view. Do they deserve a second chance, or do you have separate measures at work to deal with this particular group of offenders? Thank you.
So I would say one of the benefits, sometimes a benefit, sometimes not a helpful fact, is being in the federal government collaboration in this manner. We're not as directly connected always to the actual offenses. So what we're doing is looking at, in general, what are barriers that exist and how do we, from where we sit in the federal government, eliminate those barriers across the board. And it may apply differently depending upon the jurisdictions and the states. But you're absolutely right that mental health is one of the factors that we look at in this Reentry Coordination Council and something we address in the report. So when you look at, in general, the statistics about how people in criminal justice systems have higher rates of mental health issues, substance use disorder, collaborations with our Department of Health and Human Services is particularly critical because we can think through in ways that the Justice Department does not have expertise, right? Because we are not treatment counselors, we are not health professionals. We can collaborate with our colleagues who are to develop solutions to allow for people in the justice system to be able to have the resources and the help that they need. So it's an ongoing effort. We can always improve and get better, but that is the purpose of this collaboration. We look at people leaving incarceration have higher rates of houselessness, have higher rates of overdose. And so partnering with our Department of Housing and Urban Development, partnering with our Health and Human Services, there's higher rates of food insecurity. So partnering with our agricultural department on, how do we ensure that benefits, federal food support benefits, are accessible for someone with a criminal conviction. These are the ways that we, in somewhat of a removed manner, are able to impact across jurisdictions in the United States.
If I may, Rachel, one more question about your famous roundtable. So these 28 agencies at the table, right? They come each with its own budget, their own objectives, and let's say you arrive at collective new policy initiative. Of course, for it to be implemented, it also needs resources. And even though there were like 28 decision makers and you all clap your hands and say it's a great idea, but how do you actually allocate resources later and how it's connected to the total budgetary process? Because initiatives cost money, but only perhaps some of the agencies will mainly spend their budget on them. Do you allocate additionally to their own budgets? How this whole process goes? The essence of the question is we don't want these initiatives to stay on paper, to just stay on paper. How do we assign budget to them effectively?
So one of the most tangible impacts of the roundtable is that one of our approaches is to look at existing funding streams and look at, are they providing access to justice? So when federal government agencies have an existing grant funding program, we will work with them to look at that grant funding program, to look at, can recipients of that funding use that funding toward legal services? And if not, how do we change it? How do we modify the way that you're wording that grant funding stream so that we can expand access to justice for recipients of that grant funding? So in one way, part of what we do is look at existing resources to ensure that they are actually effectuating access to justice and getting into the hands of the people that they're intended to get into the hands of. The second thing, what I referenced earlier, is that by embedding in the structure of the roundtable that it will be staffed and have an executive director and be directed by the Office for Access to Justice, that includes resources when the Office for Access to Justice is resourced. So in our office, we have staff dedicated to looking at what can we do with these partnerships, how do we effectuate them. But you're right, if we just had a roundtable and there wasn't staff dedicated to it, you wouldn't have as much of a strength and ability to effectuate actual change.
And one more idea, I heard that you have extensive monitoring process, I understand, yeah? So there's like a third party behind, like an auditor or someone, some institution who actually measures on a daily basis if the concrete program has achieved its purpose, and according to that, they kind of reallocate or leave the same, right?
So that's a little bit tricky because for each of the federal agencies, they generally have their own different mechanisms to track where their funding streams go and the success of their programs. But we certainly work with federal agency partners to do that exact calculation through the different mechanisms that they each have within their agencies.
Thank you very much. If there are not any more questions to Rachel, then our third speaker, Mr. Jacques Wijnen. There
was a question over there.
Oh, sorry, yeah, please state your name and...
Okay, Seçkin Koçer from Turkey. Thanks so much for this presentation. My question to Rachel again, and maybe I missed that, but I'm really wondering if you have any specific study or work or policy or recommendation regarding the bias in a society against those who committed crime, especially after being released from the prison. So do you have any specific policy or any recommendation, or, you know, I'm not sure if it's related to your department, but I'm really wondering about that. Thank you.
That's a great question. I'd have to take back to see if there's any study to make you aware of related to bias, but I think we all just know that that bias exists. We know that it is harder to get a job. We know that it is harder to get housing. We know that there are, beyond the legal barriers, there are stigmas attached to having a criminal conviction that makes it hard to be successful, and we know contributes to reoffending and to decreased public safety. So one of the things that we do in interagency partnerships is we elevate the issue, and we elevate the need for cross-sectoral partnerships in a new perspective and understanding of a criminal conviction. A lot of what is successful about the partnership is bringing other agencies to the table who may not think that the criminal justice system has anything to do with them, may not think that they have to think about criminal convictions. And when we when we come together and show how the data reflects that there is increased housing insecurity, food insecurity, lack of employment when you have a criminal conviction, then it also allows other sectors of society to reduce their stigma and their bias as well, including in their programs, but also in their policies and in the way that they speak and how they engage with justice system impacted individuals.
Thank you, Rachel. Anyone else? Or if not, then the floor is yours, Jacques Wennen, and he's a senior policy counselor and works with initiatives and mechanisms in Netherlands to advance access to justice. Please, Jacques.
Thank you, Imans, and it's an honor to be here and to have the opportunity to talk with you all about this kind of things. It's also good to know that we, in all our society and all the speakers, we are struggling with the same problems everywhere, and that's good in a way. So we can learn from each other how we can do something. For quite a long time in the Netherlands, we thought everything is okay in the Netherlands. We are a happy society, no problems at all. Of course, there are some problems, but we have arranged that all quite well. Trust in courts is all the World Justice Forum, the European Scoreboard, the annual review says this. Trust in courts is very high in the Netherlands relatively. The independence of the judiciary is great. We spend, according to the European Scoreboard, not the last edition, but the editions before, we spent after the United Kingdom, in absolute sense, but also in GDP, the most in Europe. So how can there be a problem in subsidized legal aid in the Netherlands? As my Director General this morning pointed out, we have some societal earthquakes in the last years in the Netherlands. And some people, and I think Maurits is one of them, said it already for a quite long time, it is not that good as it seems. We thought, okay, we have enough money, so everyone can find a lawyer and he can go to court and then the judge will have a decision and then the problem is solved. But practice is that a lot of people can't go to court. They can't find a lawyer. They sometimes even cannot identify their own problem. Slowly, the last years, the government is becoming aware of it, the Minister of Justice. So, and to make it more practical, one of the things we are now doing for quite a few years already is try to reshuffle the subsidized legal aid system. That's quite difficult to do. Nowadays we are working with, I think, 25 or 30 pilots to see what is the best thing to work. And probably it will be something, there will not be the best way to solve something. And a big challenge will be in the end, because all these pilots should be evaluated and ended next year, and next year. And the big challenge will be then, how can we put all the things we learn from these pilots, how can we bring it in a new law, in a new system? That's now, for this moment, still a question. In a way, we are going from a demand, from a supply driven system to a demand-driven system. Supply-driven, we were thinking in the ministry is, do we have enough lawyers to provide everyone legal aid? Do we have enough money? Do we have enough courts? Okay, that's fine. Now we try, and this is the purpose of all these pilots, to be honest, not all of these pilots, but most of them, is to find how can we identify what is the real question by the people? How can we really place the citizen in the center of our attention? And so the next years we have to do that. That will be a different, a lot of ways. Of course, we try to do more with artificial intelligence. That could be a solution. But also, and that's, I think, for us very important, not always the judge is the best solution for a problem. Because a lot of judges, they say, okay, this is my case, I thought about it, everyone could say something, and this is now my decision. You have to do it, you have to deal with it. In practice, people cannot deal with it. And what we also saw for a lot of times is that someone has a problem with his renting company, house renting company, eviction is an opportunity of could be there, and then there is a judge who looks at the eviction. And then the judge says yes or no. But it's not a real solution, because the real problem is unemployment, no income, problems with social welfare, who cuts the social benefits. And that's the second new initiative I want to talk with you about, is the overall name is Neighborhood Judge, and it has now 7 pilots. Again, we love pilots in the Netherlands, and they are all slightly different. In some pilots, the criminal aspect is more important, and other the social welfare situation is more important. But the overall is that we try to find a way in which everyone is working together. So if it is a criminal case, prosecution office, probation officer, mental health care, because a lot of these people have mental health issues, social workers, housing companies, they are working all together. And the judge is in this case a little bit like the director in a movie. He is the one who can say, now we do that. You don't get your renting money, so you want to evict, but I say no, you have to wait. You have to wait till we find a real solution for this case. And this is working quite well. We have the first evaluations of these programs, and it's working so good that we now plan, and I have to give a big part of the honors to the Judiciary and the Council of the Judiciary, that we will expand this to 16 in total. And so along this way, we and we see it really works. Of course, we have also in the Netherlands a lot of problems with what's the proper English term? Undermining. That's good. The criminals who try to undermine society, and for them, especially youngsters, young people are a target. And then again, especially young people who are working in or living in poor neighborhoods with a lot of problems. And by these kind of programs, we try to help them to come out of the circle. And again, it's working. So these two things, legal aid, subsidized legal aid, I have to tell, and on the other hand, the neighborhood judiciary, these are two policy activities we are now undertaking to help us to help people better.
Thank you, Jacques, for very motivational and full of ideas speech. we are gonna perhaps try even something right away in Latvia. It sounds very down to earth and goal driven. But now, ladies and gentlemen, yeah, question to Jacques, please.
Sorry, can you hear me now? Trevor Farrow from Canada, Osgoode Hall Law School and Canadian Forum on Civil Justice. I think it's actually a question for the panel. My question is about money, funding, and I'm picking up on Jeff's question from before coffee. If we had $500 million more, what might we do? I was listening to the different speakers, and Michael, for example, talked about the really important interagency examples that add real value, which sounds right to me. One of the things that we do know from the same data is that civil and family problems are frozen out from most money and most services. Generally, I'm overstating, but not by much. But we also know from the data that if we had earlier legal interventions, we would benefit. We wouldn't have the impact, for example, on healthcare or some of the other services in the intergovernmental agency partnerships that we're looking at. So I'm just wondering, is there any talk or good examples of not just sharing the problems, but also thinking about how we might redeploy funding? Simply put, a lot of our money goes to health, education, and police and security. Not much goes to justice, and in particular civil and family. From the data, we know if we did that, we could lighten up the burdens on health, education, police, security, but we're not doing that. Is there any space for that kind of intergovernment partnership when we talk about funding?
Please, who would like to answer?
It's completely true what you were saying. And for quite a while, we were cutting a lot on these kind of things in the Netherlands. And slowly, there is a change in mind, there is a change in awareness. If we really like to solve problems, we have to spend also money on these kind of activities. And we have to look that things are coming together. And for what the Judiciary means and the Ministry of Security, Justice and Security, we are now providing from next year on the Judiciary with quite a lot of extra money to deal with this kind of solutions. And I know that other ministries in their field are also aware of it. And our Ministry of Interior Affairs is dealing also a lot with this kind of thing. So it's slowly going the other way, but it took some time. It takes some time.
Please, next to... let's start with you, sir, and then you, madam.
Besides money flows, one of the issues that was brought up in the earlier conversations is the regulatory environment for new services, new solutions. How is the panel working on that as a priority?
Thank you, Mertz. Is your question about how do we look at the people-centered access justice lens in regulatory matters within our respective governments? Is that the question?
Yeah, what the researchers often find is that new types of court procedures, new types of legal services are blocked by very slow regulatory processes. And we miss something like we have in the healthcare sector, where if you have a better process, you know that it will be certified and that you will be able to bring it to the country. And my question is that already on your radar as the central access to justice departments in your country?
I'd say that in terms of what I understand you're asking about is, can we make access to justice more efficient in the processes that we have now? I'd say that in response to COVID, we have a National Action Committee chaired by our Minister of Justice and our Chief, the Chief of the Supreme Court of Justice of Canada, to look at those efficiencies to ensure that there's, I think someone raised this at the panel earlier, to find out that there's a more accelerated process to justice. I think there's still more work to do at the front end of that process, but I think that's still ongoing. But it's certainly, we're alive and alert to it for sure, Moritz.
Lady here.
Hi, Lydia Rabinovich from Israel, Legal Aid, from Legal Aid in Israel. My question is for Jacques. About the pilot of a neighborhood judge, I have two questions. One, what is the criteria of a case to go to this court or to this tribunal? And the other question that's a big I would say, hurdle or challenge in Israel, we have a community court that's quite similar to what you're describing, but it's only in criminal cases. And one of the big challenges is how you get the other services that are not within the judicial system, in the justice system, to the table. Because you mentioned mental health services, you mentioned public housing services, and to get them in a room and cooperate and listen to the judge director is one of our biggest challenges. And I think I deal with child protection law and children, representing children. That's one of the biggest challenges for children that depend on these services. Thank you.
In a way, it's very slowly started. In the beginning, as I said before, we are talking about neighborhoods, about big parts of big cities. And there, everyone noticed we have a lot of problems. Mayors could see it, the prosecutor officer could see it, the police saw it, everyone in a moment, and slowly they start talking with each other and said, hey, but if I solve my problem, you don't solve your problem yet. So how can we find a way to, so it is very organic, it growed very organic. And I have to say that a lot of judges who are always at the end of the chain, who always saw the end of the problem, they say, okay, yeah, I can now grant it eviction, but that's not a solution. So they were thinking about what can we do, and they took a lot of effort in this. And initially the government said, no, we don't pay for that extra because your task is to give a decision and not to do social welfare or whatever. So it's a very organic, it slowly grew, and it's now a success in these 7 places. And yeah, that's the answer.
Almost sounds like a short list from this OECD framework on people-centered justice, yeah, you know, these 8 or 9 points, but it seems that that is the only pathway. Yeah, gentlemen, please.
Hello, Jeff Mulheron. Could I ask the 2 other members of the panel to have an opportunity to answer Trevor's question? And effectively, Trevor's question was, are there any examples of sharing resources, even transferring resources to achieve a coordinated response? Now, it's even harder in Canada than the US, like Australia, because you're federations. It makes things doubly hard. But there's one thing to sit around a group and with people who want to be there and you agree to do things, but I'm sure you'll each say that for political reasons, one state might not be happy with what the Commonwealth, the Federation wants to do and so forth. And that's just, but still, at the end of the day, if I'm working with the health department, I'm working with the education department, they might say, oh yeah, look, we can see that helping your justice problem might be useful, but I'd still get better value for money by spending on health expenditure. I'm going to spend more money on hospitals and nurses and things and not justice. Are there any examples where you've actually got resources being shared and actually changed, in our democratic systems?
Sure. So we do have a mechanism in the United States that allows for intergovernmental transfer of funds. And one example, specifically the example I raised earlier about the partnership between the Bureau of Prisons, our federal prison system, with the Department of Labor. So in order to do that partnership, the Department of Justice, which is the Bureau of Prisons is within the Department of Justice, we transferred funds to the Department of Labor. And in response, the Department of Labor is going to take that funding to have personnel go inside the prison to coach and help people to be able to get job training and skills on their way out. So there absolutely are ways to do that. We have to expand and look at new opportunities to be able to do so, but that's one example.
Thanks for re-raising that, Jeff, because I did want to speak to the question, because I think Trevor, you had two parts to that question. First, the redeployment of funds, and then the 4 months that I've been the Senior Assistant Deputy Minister, I haven't heard conversations from a federal, provincial, territorial perspective. I did give the example earlier about senior officials within federal departments to look at efficiencies in the restorative justice area that I want to look at to see if there's any efficiencies and maybe repurposing of funds, because I think every government department has a process to repurpose funds. But as I mentioned earlier, we're having federal, provincial, territorial meetings in 3 weeks, and it's certainly a conversation I'd like to start exploring. I was more intrigued by the second question, Trevor, that Jeff, you asked the group about if you, actually there's a Bare Naked Ladies song, anyways, I won't go there. If I had $500 million, a multi-layered song, I'm laughing because Trevor's laughing because he knows the song I'm talking about. It's a multi-layered, I think, issue, right? Where do I start? If I had funds, I would speak to Aitor, a Spanish delegate who just showed me all the wonderful data and the computer engineering that they do in Spain to help my colleague help with his goals there. So I think capacity, new capacity, more conferences like this to understand whether or not there's things that are immediately deployable and more strategic, so medium long term. But those are just some of the ideas that I had, Trevor. But a lot of the ideas we'll collect here, I think, over the next few days. But it will involve resources, planning to get to know the problem, the data issue, but then start, like my program issues $500 million of funds a year to different places. So that would be another way. How do we get this extra capacity to folks understanding where the needs are, whether it be with indigenous organizations, with provinces, additionally subsidizing legal aid. So that's some preliminary ideas from what I can see right now, Trevor and Jeff.
Okay, ladies and gentlemen, sadly we have to stop this discussion right at this point because we already we are ahead of schedule. But today with us we had very interesting and practical discussions, and we hope that our ambition to share with you practical examples went as we anticipated. And we heard very interesting, just to name a few, from Canada Justice Centers, and Roundtable from United States, and community judge pilots from Netherlands. And if you have your own country success stories, let's share with them in our coffee breaks and on personal contact. Thank you very much.
Thank you.
Thank you very much for this wonderful discussion, and I would like to ask you to stay on your places to maybe we can start the next session right now in order to finish the round table today in time. So we would like to ask the next panel to move forward, and we will swiftly prepare the panel. Thank you very much.
Okay, I've been asked to start because we're running late. So I will just very quickly introduce myself. I know you're not here to hear from me, so I'll be as quick as possible. But my name is Michael Grant, and I'm a U.S. federal prosecutor with the Department of Justice. I currently serve as the regional resident legal advisor for the Department of Justice here in the Baltics, and I have the pleasure of working in all 3 Baltic countries on technical assistance projects, but I'm very fortunate that I live here in Riga, Latvia. We have 3 very distinguished panelists who I will introduce shortly that have a lot of experience in this area of people empowerment and legal capability, which is the topic of our final panel this afternoon. I have 2 of my colleagues in the room, and then we have one of our presenters who will join us virtually. So as I mentioned, our final session today is on people empowerment and legal capability. And as we've already heard from several of the presenters today, legal systems and formal justice institutions can be difficult to navigate, and in some cases can be very intimidating for ordinary people. Even before the COVID-19 pandemic aggravated legal service barriers and contributed to an increase in justice problems, research had confirmed a massive global justice gap, with an estimated 5.1 billion people having unmet justice needs globally. This includes people who cannot obtain justice for everyday problems, people who are excluded from the opportunity the law provides, and people who live in extreme conditions of injustice. For those people, the law is an abstraction or a threat, but definitely not something they can use to exercise their basic rights. And historically, for those of us who have worked in justice reform projects, the discussion has almost always been focused on top-down government-centered programming, not on people-centered justice. People empowerment is about reversing that trend. It's about giving people the power to understand and use the law and equipping justice actors in developing a people-centered system. It's really about shifting the power, with justice institutions, justice actors, and communities working together to expand access to justice by keeping the community in the lead in defining the justice they seek. And similarly, when you talk about legal capability, that really goes hand in hand with people empowerment. It's focused on helping societies build personal characteristics or competencies necessary for an individual to resolve legal problems effectively. And likewise, providing justice sector actors with the robust skills and attitudes to deliver effective, modern, and people-centered services. So for the panel today, we've asked the panelists to focus on the best practices, lessons learned that promote people empowerment, what skills are needed by individuals to participate in the justice system effectively and proactively, and what capabilities justice system employees need to effectively implement people-centered justice. So I think because we have a small panel, I will just very briefly, and I know we're running on some time issues, at least with one of our panelists needs to be done a little earlier. So I'll just do very quick bios for, give you a background on all 3 of our presenters, and then we'll move into the substance of the panel. So I will start with Dr. Daniela Piana. She's a research director and chair of the political science department at the University of Bologna. Dr. Piana received her PhD in 2001, and in 2003, she was a Fulbright Fellow at UC Berkeley, and she currently holds the chair of political science at the Department of Visual and Performative Arts at the University of Bologna. Dr. Piana is currently a member of the OECD Research Conference on Justice, where she carries out international research activities, and in 2019, she was appointed as a member of the Office of the Studies of the Council of State. We also have with us Dr. Piset Sard-Yen, who is the Executive Director of the Thailand Institute of Justice. Dr. Piset began his career as a university lecturer and then changed course and joined the Ministry of Justice as a Special Case Inquiry Officer. He later served in several management positions in the Ministry of Justice, including Director of International Affairs and the Director of Legal Affairs at the Office of the Permanent Secretary of Justice. From 2014 to 2018, through a secondment to work for the Thailand Institute of Justice, Dr. Piset served as the Director of External Relations and Policy Coordination before returning to the Ministry of Justice to serve as the Director of the Information and Communication Technology Center. Dr. Piset was appointed the Executive Director of the Thailand Institute of Justice on 25 February 2021. And last but not least, we have Mr. Pedro Tavares. Since April of this year, Mr. Tavares has served as the Portuguese Secretary of State for Justice. Previously, he worked as General Coordinator at the Portuguese public agency responsible for the expansion of a new cadastre and registry initiative using a digital approach. From 2015 to 2020, he served he was the Senior Advisor at the Cabinets of the Ministry of Justice and of the Secretary of State for Justice, where he managed different innovation and transformative projects. Mr. Tavares was the ministry's contact point for the OECD report on justice initiatives in Portugal and for several international projects with the European Commission. As I mentioned, we have three very esteemed colleagues who will present on this people empowerment and legal capabilities. So I think what we want to do here is, I will start with you, Mr. Tavares. In the modern environment, digital transformation and organizational rethinking often provides opportunities for people to seek access to justice. And I know that Portugal has many projects addressing change and innovation, both through digital platforms and developing strategic management tools. And so I'd ask if you could share with the group some of the latest initiatives undertaken in Portugal to strengthen the skills of the everyday person and the justice sector stakeholders.
Thank you, Michael. Good afternoon. So I would like to start by obviously thanking the OECD for bringing this theme of people empowerment and legal capability to discussion on this global forum, as well as the invitation to participate in this very relevant reflection. So I'm with great pleasure sharing here some of the Portuguese experience right now. So we have a significant opportunity in the current context to go further and faster of the reform in justice. I'm just sharing, so as Michael just mentioned, I've worked in the Ministry of Justice, in the previous Ministry of Cabinet for the last 5 years, and we had this great ambition of doing major reforms on public administration, and obviously supported by a digital transition program. The problem obviously were the resources, the human resources, obviously they are necessary, but also the financial resources. Right now we have this great opportunity, this unique opportunity of meeting the political will with significant financial resources with the support of the Recovery and Resilience Program. But the time frame is very short, very narrow. So, saying that, how can we be sure that being more ambitious and accelerating change requires this new approach? One that not only starts and follows the justice purpose, but also asks us to revisit our why and rethink the requirements to bring justice services to the new era. At this session, I will focus mainly on these two major areas, people and developing capacity. We simply cannot change and ensure quality of the justice system without these two areas. So, the modernization and simplification measures that have been undertaken in the last years under the justice reform programs entail more and more technology skills, but also capabilities in managing change and innovation, which go far beyond technologies. The measures imply a change of culture, of ways of thinking and working. They require new ways of looking to old problems and the capacity to keep pace and respond to a fast-changing world. Innovation is not just about digital transition, and it's also mainly about people and culture. Moreover, due to the lack of human resources or skills and knowledge in the public sector, as well as to the short deadlines that we face, that we all face to implement needed reform measures, is often necessary to rely on external service to execute projects. We all learn from these experiences. At the same time, we know that we cannot change from the inside if we don't assure skills, if we don't share and communicate enough and our vision, if we don't build roadmaps and monitor our accomplishments. I will show 3 examples that can help tackle these challenges based on the Portuguese reality. So, as it was mentioned, I've managed a challenge in Portugal that is the digital land cadastre. In Portugal, most of the land is not known. We don't know who are the owners. It generates a lot of problems, including, obviously, fires, forest fires, that we don't know how to contact landowners to help clean the fires, to help develop these areas, to help build new economies. So we build this different approach, this new approach, this digital one, where we use databases, we use satellite information, we use remote sensing, and a lot of, obviously, a lot of simplified legal system that with a free registry help landowners to register their land. To accomplish this challenge, it was absolutely essential that the network of more than 800 local technicians had access to the platform roadmap, to be transparent on that roadmap, and had regular on-the-job training, as they were central to the citizen satisfaction with this project. The second example are the frequent forums and workshops for instance, communication professionals. We know that for us to better communicate what we're doing in justice, for people to use services, for people to access to justice, we need to make sure that people do know and understand what they have available as services. So for the professionals, we need to make sure that they have skills. These are examples of some latest skills that we've done with some of the team. One's based on digital marketing, for instance. It is important for all of our 18 bodies, and including the General Prosecutor's Office and obviously the Supreme Court, that they do know and understand the challenges of digital communication. And 2, on IT, making sure that we call them the CIOs meeting, the CIOs forum, they gather together and they discuss and they learn with external information, with external examples. They also face similar challenges. And still to address the required transformation projects that are already starting with this ambitious agenda, we needed a more comprehensive approach. Last week, the Portuguese Ministry of Justice signed an agreement with 2 of the major business schools in Portugal, Lisbon School of Economics and Nova School of Business Economics, in order to enable what we call the Justice Lab, the first executive education program tailor-made for the justice sector, focused on 3 main areas: strategic management, digital transition, and leadership in a changing context. Justice Lab is an advanced program of innovation and culture. On the previous session, we just heard and learned with the speakers, especially with our colleague from Canada, that told us that we need, obviously, not just managers, we need leaders. So we need to combine management with, obviously, leadership in a changing context. The curriculum was created from scratch and designed according to the real challenges of the justice professionals, which needed, for example, to incorporate emerging technologies as machine learning, or to assure court management information with tools and transparency, or obviously change management and everything that is necessary in order to deliver more effective and accessible services centered on the needs of people and businesses. From October to April, 100 leaders and project managers from 18 justice bodies, including prosecutors and the Supreme Courts, will attend this program. We plan to extend it to other profiles and needs in articulation with the horizontal programs of skills and public innovation. And this lab, this innovation lab, is being developed within the Justice Hub program. It is a shared, not only a concept, but also a shared physical workspace that aims to promote cross-team collaboration by joining different teams from diverse public administration areas, as well, obviously, as external teams that include project managers, designers, and development teams, all working together on digital and innovation initiatives. And now, you can see that on these small pictures, there are even 3 small labs at the Criminal Police Headquarters and Industrial Property Institute, and 1 at the Central Ministry. The Digital Justice Platform, or the new interface for judges, the new registry service model, or the simplified digital registry, BUPI, that I just mentioned, are some of the projects already developed at the Hub. This project will also evolve to enable more teams to join in a larger space, but also will be the starting point for a broader practices change movement in different justice entities. We also foster development of new GovTech and legal tech policies with more cross-collaboration projects within the Justice Hub. We cannot do things just from the inside. We need also to work with the justice environment. The challenges that we face today require us to be able to keep up with the digital evolution, as well as answering to citizens with higher expectations. In the justice sector, these changes must be translated into better management tools, apps with excellent user experience, customized for the different personas, more task automation, and more integrated services for business and citizens, among many other improvements. To successfully manage this challenge, we need to ensure that our professionals are at the center of change and support the development of the necessary skills and knowledge into our organizations. We believe this is the way to bring justice services into a new era, and I'm happy to answer all the questions. Thank you.
Thank you, Pedro. Very interesting presentation. I'll open it up to the audience first, cognizant of the fact that we're short on time, but let me open it up for any questions. Please.
Just a question about the working environment that you just showed, the public spaces and hubs. This is just a short-term project that staff from various entities in the ministry join together, or this is like the normal working environment that you're kind of changed into?
It's actually both. So it started in the beginning with the challenge to create more agile space where we could meet teams from different areas, from different entities, and ensure that they could all meet together and work together for the time frame of the project. So that was the beginning. And then we thought we need this change movement, this change management and change movements to be also brought to the entities, because otherwise they just felt it, oh, it's just outside. So we need this change culture from the inside. So that's why you can see that now we're going further on going to the police criminal headquarters and having these places, and also in all the areas, all the working areas, we are expanding, and obviously the methodologies that we use there are to be also used at their offices.
Thank you, Pedro. Any additional questions? Pedro, I'll ask, you mentioned these initiatives that you've launched and the importance of getting the word out to the public of these services and initiatives. What were some of the biggest challenges you all faced in making this known to the public?
Well, I would say that two things. First is reaching the public. So in the justice sector, and I would say in the public administration, it is quite difficult for us to understand, to see what differences do they have. How can we reach them? Because we know that we cannot reach judges the same way that we can reach the general citizen. So we need first to make sure that we segment and make a segmentation of all the public that we have. Second, making sure that the experience is really customized for them. So right now, what we did on this approach was, rather than just going and developing services, new portals, new applications, everything is observing, making sure that we observe, interviewing citizens, creating journey mapping, all that to make sure to understand that we fully understand the context. Because some of the projects were developed like 10 years ago, where we didn't have these expectations from the citizens that we now have. So we need to understand what are the constraints. Is it just technology? Is it legal? Is just the employees or the public servants? So we need to understand and then design these services. And finally, making sure that we communicate on a clear language, making sure that the language is simple to the targets that we are communicating to.
Thank you. Okay, thank you very much. Now I think we'll turn over to Dr. Piana. Daniela, are you there? Oh, excellent. Excellent. We're very happy to have you here with us today. I know you have a lot of experience with OECD and this topic, and so I'll just turn it directly over to you for your intervention.
Thank you. Thank you very much. It is a pleasure to give a contribution to this, I would say, extremely timely and important debate. And thank you so much for having me in this debate, even though it is virtually, my presence is online. What I have prepared for you is a short PowerPoint, which I'm going to share. Okay. So I think that you must be able to see my screen. Does it work?
Yes, we can see it. If you want to maximize it. And then
I'm going to do it.
Great.
So I think that here there are some keywords that we needed to have with us. I've been also following with a lot of interest the previous session, and I've enormously appreciated also what we have been, listening from the Portuguese experience. There are many things that today we are called to do, especially if we want to take the best out of the experience of adaptation that legal and justice institutions did have during the pandemic. And at the same time, we know that people are more and more asking for an effective capacity from legal and justice institutions to meet their needs. First needs, even before meeting rights enforcement demands. So what I'm going to share with you very briefly is basically drawn from three different actions where I have, the chance to be in a way part of. It depends as principal investigator or coordinator of teams. And there is a research results. There is the development of methodologies to measure the gaps at plural, that we do face in terms of people empowering and legal capabilities building. And also a few experiences where you will see research institutions, training institutions, among which universities, but not only universities, and institutions in the strict sense of the words, such as legal and justice institutions, in order to make sure that what we learn from the research is immediately shared and used to empower the the capacity of the legal and justice institutions to improve themselves in a way that is, based on awareness. At the same time, we have experiences targeting lay people, and especially people that are suffering very much from barriers, not only barriers in, going to the courts, but even much earlier in the pathway, where barriers means simply the fact that you as a person are aware or not of which rights do you have. So we have evidence, empirical evidence from comparative research that have been conducted and coordinated on the gap that exists between the needs of people and what people do know about the significance of their needs from the legal point of view. We have experiences, for instance, trying to translate in common sense categories what is, from the legal point of view, absolutely to be taken for granted. But this is something that is not at all to be taken for granted for lay people. Many times people simply do not know which is the legal category that fits their need. Second, we have done a lot of research, and when I'm saying we as Italy, but I have the chance to coordinate scholars organized in, international teams. So we have comparative data on that. And there is definitely evidence on the gap between the first step, that is, I do have access to the legal services or the justice services, and what happens afterwards. Because one of the points that is absolutely underestimated, simply because we have maybe not enough evidence about this, is that even though lay people may have access to the legal services and the justice services, then afterwards, this may be extremely expensive, not only from the economic point of view, from the material point of view, but it may be expensive in terms of life cost. And it is absolutely not to be taken for granted that people have at their disposal the endowment, the resources, and also the awareness that they would need in order to make the experience of the justice system all along the way until the end, including the execution of the final decisions. Then it is true that when we speak about people empowerment, we do have in mind lay people, and especially more vulnerable groups in the many different ways that they may take a shape in the many different communities that we do have in the world. But people empowerment means also to take seriously the idea that also within legal and justice institutions, people are a crucial and essential and vital resource and I would say point of action in making the quality of justice something that is real and effective. So today, if we observe the encounter between simply the staff of legal and justice institutions and the technologies that we do have, artificial intelligence, semi-automations, there we have a need. That is the need from the staff of legal and justice institutions to be empowered in order to be sure that they can have the capacity to control what's going on, but also to delegate if this is, something that must be the case. And there is a gap there, a gap both on the side of the skills, but also on the side of the awareness of the skills that we do have most of the time implicitly in the legal and justice institutions. So in this respect, this is just to say something that it has been already highlighted, but I think that is important for us at the end of our day to say, okay, we do need a framework. And this framework must be helpful and is helpful for the governmental institutions in order to ensure that there is a sort of intertemporality in the way legal and justice reforms are designed. It doesn't mean that you must have all done at once. This is absolutely not possible. But you may have a sort of a long-standing temporal perspective and an engagement in order to measure an incremental convergence toward the objectives that we have, on which we have agreed upon. Awareness is a key word, especially from the point of view of the staff that is in service within the legal and justice institutions. Many times, from my minor, if you want, point of observation, what I have been able to witness is that people that have learned to do things within the organizations that are not aware, and the colleagues are not aware of what they all together are capable to do. So there is, in the end, through this idea of intertemporality engagement and awareness building, a way to build trust. Very briefly, 2 initiatives. This is an initiative that have been already presented over the last 2 years in the OECD events. And it's something that we have been set up within the Italian justice system. And the first reason was, 15 years ago, we didn't have enough data in order to make really a data-driven governance approach. Today, we have many data also because of the digitalization. So there are many, contents that are on digital format, but we are not, or we were not capable to take out of this data the best in terms of knowledge that we do need in order to make a better governance of legal and justice institutions. So what we have done first is to map and polish and structure all the data that we do have concerning legal services and justice institutions, including all the resources that are related to the human resources sector. And then what we have built is a tool to train people that do have responsibilities in organizational terms within the legal and justice institutions, especially in the courts, and especially, once again, in the appeal courts, in order to provide them a sort of an intersectoral monitor to map the improvements that they reach in the services, the way they organize human resources and the way they can reorganize human resources, especially after this injection of human resources that has been massive in Italy from people that have been appointed over the last 2 years. And of course, when you appoint a lot of new persons, the point is how you reorganize your staff. So we have provided a sort of a compass, data-driven, but not only quantitative data-driven, with qualitative methodologies taught to chief justices. And we have set up a pilot research, which has been concluded. And now we are in the second stage, when we are spreading off the results of this. The interesting of this experience is that at a certain point, my ambition is that people that do have responsibilities within the justice institutions can become aware, and therefore they may be autonomous, because this is something that is extremely important. The second initiative is on the side of the lay people. This is something that is very much global, is international. It relies on a network of universities that has been awarded by the UNESCO. The OECD justice team is associated simply because there is an interest, of course, in this type of methodology. The idea is very simple. There are many contents all over the world that are ready. Simply, they are done PowerPoint, video, contents that do refer specifically to the rights, the law. The point is that many times these contents are absolutely not accessible, either because they are not intelligible or because simply people do not know they are there. So this initiative, which is called World Educational Heritage, where many universities are engaged, they are engaged simply because they build small contents out from these contents that are more technical, and we create interactive methodologies for people that do suffer from specific barriers, especially barriers that do refer to cognitive, physical disabilities, but also barriers that are more general. As we know from the data that we have from the United Nations, many people do suffer from educational barrier, worldwide. And educational barriers do matter also in the legal and justice sector. So just to give you an idea, which are the streams of small contents, micro augmented contents of knowledge that we are making available on the platform. Access to rights for women in MENA countries. We have engaged the NGOs to set up this small stream. The same on the right for children. And this is interesting because you need to change, the way you offer this content, because you need to reach out to children. And of course, this is not the same thing that where you do it with adults. We are also building a stream on rights in South Africa. And we have been already launching the same thing for refugees and the basic rights of people when they cross borders as refugees, especially in the EU. How we do it? Simply, we partner with NGOs or organizations, associations that decide to make available their contents. We award to them, the authorship of this, but simply we work on the accessibility, worldwide. Last word, and I've finished. I think that from the point of view of the governments, there is something that may be extremely helpful for them, not to to assess and to evaluate, but to support, to help, and also to listen people that are in service in the legal and justice institutions, because they know, these people, that they are facing a challenge. Over the next 5 years, the way of working will be changed enormously, and they know. But not always they know what does it mean in terms of daily routines, because at the end of the day, people are working each day. So I think that what we may build and share and spread is a tool to empower people to know which skills they have, which is something that they may build, day after day. And we do need to have not only, a long-standing approach, that's something that I've already highlighted, but also an approach that is intersectorial. We do have many data. We need to have a one entry point focusing on what does it mean to have a legal justice, system that is, in a way, nourished by the knowledge that we get about the needs of people from all the data that we have from all other sectors. Thank you very much for your attention. Thank you very much.
Thank you Dr. Piana. I'll open the floor. We have a few more minutes with Dr. Piana before she needs to get off the line. Do we have any questions? Yes, in the back. Please introduce yourself.
Yeah, thank you very much. My name is Felix Stefek, University of Cambridge. Daniela, thank you very much for your highly interesting intervention. I have a question that is, I think is close to what you spoke on. It's a little bit associated. So apology if it doesn't exactly meet what you spoke on, but I think it's relevant in this context. And my question concerns this. I think we're using more and more technology to make law and access to justice more accessible. Now, I think then when we use technology, this then, when it comes to application, raises the question how we empower people using that technology, because there are two ways. One is to provide more information on the law, on justice, and the other is to use technology in a way that a problem can be solved, but without people actually really understanding the law, engaging with it. To give the well-known comparison, we use Microsoft Word, but at least I don't know how it really works, but I'm using it. It helps me, write texts. I'm driving. I can't build a car. So in a similar way, I think what the challenge that we see more and more is a design challenge in which the question is, do we empower people by actually making them engage with expert knowledge, or are we actually designing institutions and applications in a way that they work, they solve the problem, but actually, under the hub, the expert knowledge is hidden? And I would be interested in your experience, or kind of in your view, how you would solve that problem.
Thank you. As you know, that this question is a question that is very close to my research interest and also to my institutional interest or engagement. I think that we need to find a balance between two poles. The technology design must be, in a way, participated and inclusive, but we cannot be trivial nor, blind. I do not think that the entire answer, lies on the side of having a perfect design, because a perfect design, even if we consider perfect design, a design of a technological tool or an interface or a platform or a device that is totally understandable from, the people, generally speaking. Perfect design doesn't exist. But we may subject, and this is something that is very, dear for me. It is dear to me, and I'm very committed to promote this approach. It's a sort of a 2 steps or 2 stages approach, where you have an institutionalized, mandatory moment of evaluation, which is a never-ending exercise. But what you evaluate must be the use of the technology. And this is something that is necessary because technology doesn't structure in a deterministic way, we know, the behaviors of people. And we may go further by saying that people needs may change over time. But let's say we make it simple. At least we know that technology provides a sort of a regime, an overall framework, but you do have in the use this room of maneuver that lies on the shoulder of people, individual behaviors. So I think that the answer, it may sound easy, but it is not easy when you want to make it, real, when you want to implement my suggestion, which is a method where you have a participated design, where you have, the civil society that is anyway listen, and there are ways to listen, and the voice, as a sort of a preliminary feedback, which would never resolve entirely the problem. Then we need to assess, to make the assessment public, and to be in a way obliged, to respond to the gaps that we have empirically observed and try to resolve. I think that there is not any other way. By the way, technology is advancing at a speed that is absolutely too rapid, and in some respect, the design, when we want to make it perfect, is already, shortcoming. So that's my experience, and also what I would suggest in terms of method of governance, if we may use this word.
Thank you. All right, any last question for Dr. Piana? All right, so I'll turn it over now to Dr. Pisset, the Executive Director of Thailand's Institute of Justice. Dr. Pisset, I know one of the core beliefs in the Thailand Institute of Justice is that you must invest in human resources if you want to build an effective and fair criminal justice system. And I also know that many of the initiatives that you all work in is to promote assistance to vulnerable populations. And so I'll turn the floor to you to discuss some of those initiatives.
All right. Thank you very much, Michael, for giving me the floor and for your kind introduction. I'd like to, in the interest of the time, first thank the OECD and the government of Latvia for the kind invitation for me to join this important roundtable. The Thailand Institute of Justice, or the TIJ, for which I am representing today, is a public organization. As some might be aware, we are partly government and partly NGO in a sense, and our core mission is to promote the adoption and the application of the international good practices by the justice actors in not only Thailand, but also to some extent government in Southeast Asian region. And we do this as a means to promote better access to justice and strengthen the rule of law. And our approach are mainly through research, capacity building, and evidence-based advocacy. TIJ, we are affiliated with the United Nations through the status as the Program Network Institute with the United Nations Office on Drugs and Crime. And this status allows us to focus on the role in promoting the international cooperation and domestic uptake of relevant United Nations standards and norms, particularly those norms that govern the treatment of female inmates. And due to that particular role and origin, TIJ, I think we are able to work with actors in the justice system from the outside in perspective. And this allows us to, when trying to bridge the gap between the local practice and the international standards, allow us to adopt a different kind of perspective and provide additional support for the criminal justice agencies, because they are maybe too embedded in the existing problem that it hard to realize the broader picture, and we step in providing that resource. And my presentation today will focus on only these three points that I think some sort of reflections that emerged from our works over the years in trying to bridge such of the gap. And I hope this will help provide some necessary ingredients for our further discussion into realizing the people-centered justice approach, particularly through the help of enhancing legal capability and empowering people. I have to admit that the Thai justice system, we are not at the state of perfect capability to promote access to justice. The idea is there, and it welcomes a certain degree of support as a promising practice, but we still have not seen enough concrete steps taken to realize this in terms of reform initiatives taking place. I guess putting people at the forefront and the center of the justice system, particularly for criminal justice system in Thailand, where it has long been operating under certain sets of values that tend to emphasize the legal technicalities, procedures, and to some extent embracing more or less a top-down approach. These elements make it very difficult for the people working in the justice system to see people in their day-to-day operation. And I think without radical change in this kind of paradigm, it would be quite challenging to expect results. But I think we are gradually making small progress, and I would like to share some of the work that we have been doing in this regard with you today. So first point is that we have to be really empathetic in our mindset in working with the vulnerable group of society. This is particularly important when, as I mentioned, the mainstream status quo is not yet embrace people in the center of their operating day-to-day work. And empathy that I would like to emphasize here, it signifies the sentiment not only towards others, but also something that we can expect from others as well. And at least there are three types of stakeholders that are possible that we need to think when we talk about empathy. The first is, of course, the end users, or the people who seek access to justice, who seek justice as a service. And particularly when we work with prisoners, these are the immediate persona that we have to be mindful of. Second, I think there must also be a certain degree of empathy towards the practitioners in the criminal justice system as well, because they are also the people that face very difficult challenges in terms of organizational values that may not be conducive to be people-centered, yet they may have to operate with the incentive structures that are not inducive. And thirdly, I think for the broader stakeholders, people like in ordinary citizen, people in the broader public sphere, they also need to have a certain kind of empathy so that they can be sensitized towards the issues and challenges that the criminal justice system faces. So to illustrate this point, let me walk you through the realization that we at the TIJ had working with a selected group of beneficiaries, which are the female prisoners. We really came to realize that an important set of perspectives are needed, and we learned as we undertook several initiatives working with them and working for them, that close attention must be made and paid not only to what goes on inside the prison. And by inside the prison, mostly what we try to do is to support the criminal justice system, the prison regime, to adopt the gender-sensitive approach when they deal with the female inmates. But also, we need to pay attention to what happened beyond prison. And by beyond prison, I mean one day they need to be released from the prison and return to societies, and the community acceptance plays an important role in determining the fate of them, whether or not they can reestablish themselves as the productive member of society, or they fall back to the old cycle and return to prisons. And also we need to be mindful of what can be done besides prison. I am talking about the alternatives to imprisonment, which are very, very important, particularly in the context of Thailand, where we are overwhelmed by over-criminalization and overcrowded in prison. Also guided by this empathy mindset, much of the work at the TIJ evolves and expands to embrace more areas which may be characterized as following the second point that I would like to talk about, which is the need to foster collaborative attitude. Over our experiences indicates that such an attitude emerges once the risks perceived by those involved are buffered to an acceptable level. And for this, we need to build an assurance that collaboration has sufficient benefits and that the partner involved in the whole collaborative scheme can adopt the ways to manage the risk and that they can align the benefits. All these are important, and we realize that a lot of the time it can be done not by the partners themselves involved in the partnership, but through an establishment of a managing body or the clearinghouse. A simple solution like that sometimes solves the very nasty issues. There are several examples of successful and promising work in this area of collaboration that TIJ has championed or facilitated over the years. For instance, there is one program that we provide, a job creation program for ex-offenders. We gave them training and we gave them a food store that they can do self-employed practice. In Thailand, the food culture is rich, particularly on street food, but we want them to be sustainable and hygiene, so we add this additional element to the program. What we found is that in terms of return on social return on investment, we were able to prove that we can get a 4 times benefit compared to the cost invested in the program. And this has been possible thanks to the collaboration that TIJ enjoyed with several business partners and also civil societies. Now I'm going to be going back and forth between my 2 slides, but I have only 2. My third point, which is the digital challenges. I would like to make a point here that the power of technology is enormous in helping transform the justice system towards a people-centered approach, but there is a catch, and we need to invest in certain capability to be able to make use of this. At the TIJ, we have been able to champion some technological solutions for the survivors of gender-based violence. Again, we come to realize this through our work with a lot of women prisoners. And once we learn about their pathway that made them come into contact with the justice system in the first place, a lot of them were actually victims of domestic violence as well. So we turn our focus to this issue, and this helped us broaden our mindset and embrace a new approach that we were able to make use of the technological advantages. For instance, we were able to partner with several entities to develop a chatbot that provides survivors of gender-based violence with easily digestible legal information, as well as a channel to file complaints and cases online. Again, in this area of domestic violence, we were able to develop a set of e-courses that are useful for prosecutors, police officers, nurses, as well as social workers to be able to have a standard understanding when they work with the gender-based violent cases. Another product, this is a little bit early in the development, is the predictive algorithm that we hope that it would provide a tool for nurses and healthcare practitioners in the hospital, so that when they come across someone with bruises or with injury, they would be able to have a more sensitive lens to identify whether or not that particular patients may have been victims of domestic violence, and they can, with that kind of awareness, they can take further step, and if that proves to be the case, refer that particular individual or victims to a proper care and taken care of. Now, I must note that we were able to do all this thanks to the partnership that we had enjoyed, particularly with innovators and people in the tech industry. And while the progress made in harnessing the power of technology at the small scale, as I mentioned, has been promising, it is not to be confused with the success, I have to say. At large, the Thailand's justice system remained unequipped to be a well-informed customer of technology, sadly. There's still very limited understanding within the sector that makes it very difficult to even identify the basic technological needs. So we need to continue our journey in this regard. Now, let me conclude my presentation by saying that when we think and when we talk about capacity building, I think it is important to realize that it is not just about developing skills or expertise. In fact, the challenge is much greater and are more nuanced and complex. On many occasions, we practically, it's like we are working to really affect and reshape the culture itself. And we need to seed the concept of people-centered justice into our stakeholders. And we hope that by doing so, it will start to organically develop into a desirable and sustainable system over time. Of course, it will take time. We have also come to realize that it is essential to reintroduce the human perspectives back into the justice system, and that these are the necessary ingredients for building the trust and facilitating access to justice for all. With this, I conclude my presentation, and I look forward to a follow-up and more discussion later on. Thank you very much.
Thank you, Dr. Pisset. I know we are out of time, but we'll open it for questions. Does anyone have any questions for Dr. Pisset before we close the session for the day? Yes, please.
First, let me apologize to everybody that may be wanting for no questions, but hopefully it's not too complicated. I'm Laura Milne from the American Bar Association. Thank you very much for your presentation. I was really interested in the mention of empathy and the need to start with an empathetic mindset. And I'm working predominantly on trafficking in persons and gender-based violence, and have increasingly recently come to realize the importance of empathy. I mean, particularly important when there is a lack of empathy. And in the context of human trafficking in the MENA region, we see that with the exploitative work that is normalized. And something that I've worked in Southeast Asia, I've seen in Thailand as well, this complete normalization of exploitative work. So my question is, on that point of empathy building and starting with an empathetic mindset, have you found successful approaches to help build empathy, whether that is among formal justice actors or whether it's among sort of the community at large in relation to a particular thematic area such as trafficking? And whether you've had successes or indeed any failures. Thank you.
Thank you very much. Probably one example that comes to mind, I'm not sure if I can characterize it as success, but interesting observation that we were able to observe is through one of our flagship capacity building program, where we bring a certain group of practitioners in the criminal justice system to be side by side with the representative from private sectors. And this kind of combination, I also member from the civil society groups, and I think what we found is that the empathy mindset is much easier to materialize, I have, for lack of a better word, when the people with authority here in the criminal justice system, they are faced with honest and challenge questions from people from different sectors in that kind of setting where they know each other well and they have built trust that they, and we at the THJ are trying so hard to provide that kind of environment for them. We do not view this not as the capacity building per se, but it's an important forum for people from different sectors to come together and share the experience. And a lot of difficult questions, like you have mentioned, with respect to trafficking in person approaches, were discussed during this course, but unfortunately it's still in the context of knowledge sharing and experience sharing in the training setting. What we try to do next is to harness the initiatives and discussion points that emerge from this forum and put them into practice by continuing the partnership and the working with these participants of the training course so that we can build upon the momentum and make it a real difference in the world. Thank you.
Okay, well, I want to take this opportunity to thank all of our panelists. You know, all three of you provided very interesting and concrete examples of ways that and initiatives that we could use to break down legal service barriers by empowering people and building legal capability. I know this session was a bit rushed, and so I just recommend to everyone that if you have the opportunity at the events after hours or on breaks to please seek out our panelists if you have more questions or would like to discuss these initiatives further. And with that, Anna, everybody just go to dinner, right? Yeah, it's back to you. Go ahead.
So thank you very much, and I would like to thank all our esteemed panelists and moderators today for the interesting sessions and the fruitful discussions. And we would like to invite you for the dinner now in the premises of Latvian National Art Museum at 7:30. And I would like also to remind that tomorrow's sessions will start at 9 o'clock in the morning, and some of the materials, what was mentioned also today during the discussions, you can find in the back of the room also. So, and thank you very much one more time for all the discussions and your participation. Let us have a nice evening. Thank you very much.